I pledge my eternal gratitude to any Leonard who would edit and combine original Emily's live coverage of this trial with Sidebars coverage at specific moments. That sounds like a doctoral project.
Okay, welcome everybody. Today is day 23 of the trial. We are still here on rebuttal, so Johnny Depp's rebuttal case. And let's see, where did we leave off yesterday of the trial? We left off with Dr. Shaw, I do believe, who was a rebuttal expert witness to rebut Dr. Spiegel. And he was the very distinguished British fellow, and he was just the complete opposite of Dr. Spiegel. But he was at the end of the day yesterday, which would have been day 22. So if we imagine we're here in court, we are in the jury, or we're in the gallery, and we show up this morning, and yesterday what we saw was we saw a number of rebuttal experts, but we finished our day with Dr. Shaw. So here we are on day 23.
There we go. Judge A is on the bench.
Proceedings, the bailiff, all rise. Please be seated and come to order. The court, good morning. Mr. Chu, good morning, Your Honor. The court, all right. Do we have any preliminary matters? We already know the answer is going to be always. Ms. Brodoff, yes, Your Honor, we do. The court, okay.
Oh, they immediately are approaching the bench.
Sidebar, the court. All right, Mr. Niederhoff. First, the easy ones. The court, easy ones are nice, Mr. Niederhoff. These are the exhibits that were admitted and were on the list. The court, okay, all right, so that's 1493F, Mr. Niederhoff. The court, okay, got that one, Mr. Niederhoff. There's a copy, Ms. Vasquez, thank you. The court, and R, Mr. Niederhoff, right, that was the court. And then 1903. Why do I feel like we've already talked about that exhibit before? Mr. Niederhoff, that was yesterday. Oh, that's why. Keep reading. The court, oh, that was yesterday's. Mr. Niederhoff, and then there were two exhibits that were played during the depositions of Tracy Jacobs and Iowa Tillett Wright, and they were in agreement, so I don't think they were on your list. The court, all right, 468 and 537, no objection. Is that correct, Ms. Vasquez? I want to confirm this. Okay, yes, no objection. The court, okay. 468 and 537, no objection. Mr. Niederhoff, thank you. The court, I'll take them off my list as I go. Mr. Rottenborn, we have a few witnesses that we want to discuss. The first one we could discuss in open court. It's the motion to exclude Mr. Neumeister. The court, okay. Mr. Rottenborn, which Mr. Murphy is going to argue. Oh, another new character, Mr. Murphy. Here we are on day 23, and we have a new character. Amazing. Miss Lickrose, our opposition is under seal, so it may make sense to handle it at sidebar. The court, you want to do it at sidebar? Okay, well, you guys are at sidebar, just saying. Mr. Rottenborn, and then we have a few other witnesses. The court, which one do you want to do first, Mr. Rottenborn? The first one is Beverly Leonard. She is someone that was identified last night by them, and they say that this is a witness who reached out to them late last night, which is whatever, that's fine. But she is, as best we can tell, she's one of the police officers from the Seattle airport, which we object to them calling for a couple different reasons. The first one, Your Honor, is Your Honor's ruling in the case, both in limine and during Ms. Heard's examination, no arrest is coming in relating to the Tassa Van Ree issue. Your Honor has already ruled that. Calling a police officer, even if they say, well, we're not going to elicit the testimony, she was arrested, that would be like calling the UK judge and saying, we're going to put you on the stand, don't talk about the ruling, just talk about the discovery and witness testimony and all that. The court, all right, Mr. Rottenborn. We think the jury is going to draw from that. Second, Your Honor, that type of evidence and type of testimony is precluded by the collateral evidence rule, which basically says, she knows what it says, which basically says that when somebody is introduced on cross-examination, a party can't introduce extrinsic evidence on a collateral matter. Okay, here I am, I've got a crystal ball. Right now, what is the crystal ball telling me? It's telling me that Judge is going to say something to the effect of, this is rebuttal. It's not cross-examination, this is rebuttal testimony. We'll see how how reliable my crystal ball is. What happened in the Seattle airport between Ms. Heard and Ms. Van Ree is a classic example of a collateral matter that's barred by the collateral evidence doctrine, and it's also barred under 2608B, Your Honor. I have a copy if Your Honor would like to see, but under 608B, specific instances of conduct may not be proved by extrinsic evidence, and this is a side issue to the trial. It's about something totally unrelated to this, and so collateral evidence 608B and the fact that it would expressly violate or explicitly violate Your Honor's rulings, that the rest is too prejudicial and isn't coming in the court, okay? Ms. Vasquez, if I may be heard, Your Honor, I was the one that received an email past 1 a.m. last night, still working with Ms. Myers. I can represent to you that I emailed Ms. Leonard back, asked her to call me on my cell phone. I then had a phone call with Ms. Leonard. I confirmed a couple things. She has not been watching the trial. She has not seen testimony. I then instructed her, per Your Honor's ruling, that she's not to watch the trial, watch testimony. The court, that's not the issue. Ms. Vasquez, I understand that. She's like, I'm just getting ahead of, like, what the next thing they would complain about, you know, Amber Heard's team. Ms. Vasquez, I understand that. Now, as to the attempt, with Your Honor's blessing, to offer Ms. Leonard just to testify as a third-party fact witness as to what she observed, it is rebuttal. Yeah, okay. I gotta hear Judge A say it. I can't rate my crystal ball until I hear Judge A say it. It is impeachment. Ms. Heard, as Your Honor is aware, allowed me to ask Ms. Heard whether she assaulted her ex-girlfriend. She denied doing so. I then asked Ms. Heard whether people saw it, and she denied that people saw it. And so the court, so you're saying this witness actually saw this. Ms. Vasquez, yes. The witness, she witnessed the assault. She is the arresting officer. Ms. Bradoff, no, she is not. Ms. Vasquez, I can represent to the court as an officer of this court that she will not testify that she arrested Ms. Heard. She's only going to testify, the court, she can't testify she's an officer either. Ms. Vasquez, she's not an officer anymore. She's now retired. If you would like her not even testify, the court, she cannot say anything about being an officer, just being somebody at the airport. I think that's fair. That makes sense. Because it doesn't really matter if she was an officer or not. Ms. Vasquez, somebody at the airport, she observed Ms. Heard hit Ms. Van Ree and rip off her necklace, leaving marks on her neck. That's what she's going to testify to. The court, all right, Mr. Rottenborn, it's a plainly collateral matter. It's a mistrial. It's a collateral matter. Just as if we were to bring someone on to testify about something Johnny did 30 years ago, it's a collateral matter. He loves to repeat himself, Rottenborn, in these sidebars. It's not relating, the court. Well, you did. Somebody, Ms. Vasquez, Ellen Barkin. Mr. Rottenborn understood. The court, how is that not allowed? Mr. Rottenborn, under 608B, Your Honor, specific instances of conduct may not be proved by extrinsic evidence. Again, he just said this. The court, what was Ms. Barkin? So she's basically calling him a hypocrite here, it looks like. Mr. Rottenborn, Ms. Barkin was testifying about the facts of her time and experience. The court with specific incident. Mr. Rottenborn, which didn't come up on cross-examination, which Your Honor blessed before the trial. It's a totally separate issue. They could have argued that. They didn't object to that, Your Honor. I mean, 608B is very clear that specific instances of conduct may not be proved by extrinsic evidence. They are allowed to elicit testimony by Ms. Heard on that. The court, she denied it. Ms. Vasquez, she denied it. The court, she denied it, that it happened. So for impeachment purposes, they can have someone say that it did happen. Mr. Rottenborn, not under 608B. Can I get a copy of the rule? The court, sure. Ms. Vasquez, thank you. Mr. Rottenborn. Okay, I guess he's reading the rule. Specific instances of conduct of a witness may not be proved by extrinsic evidence except as, and then they say, except as otherwise provided in this rule, which is what all the rules say that, literally. It's not impeachment. If it is impeachment, it's impeachment on a plainly collateral matter. It's not relating to whether or not Mr. Depp abused Ms. Heard. That is a collateral matter, and under both the common law collateral evidence doctrine and the rules of evidence, it's not allowed. And her testimony is not, it wasn't false. She said she didn't assault Ms. Vasquez. It's proper rebuttal, Your Honor, and it's impeachment. Ms. Heard said she did not assault Ms. Van Ree, that people did not see it. That's exactly what Ms. Leonard intends to testify about. Court. I don't find that it's a collateral matter in this matter because Ms. Heard testified that she always does self-defense. Oh, I see what she's saying. Okay, only does self-defense. She only hits in self-defense. And that's what her expert also testified was always hits in self-defense. That's why I allowed the question to begin with to Ms. Heard at the time when she was on the stand in cross-examination. She said it did not happen. I will allow the testimony very limited. Ms. Vasquez, understood, Your Honor. Mr. Chu, thank you, Your Honor, Ms. Vasquez. And as an officer of the court, I will represent that she will not testify she was formerly a police officer or that she arrested Ms. Heard. The court, very limited testimony. Ms. Vasquez, understood. The court will be allowed in this matter based on that for impeachment purposes. Ms. Vasquez, thank you, Your Honor. Mr. Chu, thank you, Your Honor. I'll go ahead and interject. Okay, I guess I'll give my crystal ball half credit because part of what Camille was arguing is that it's rebuttal. So Rottenborn's rule, his rule didn't seem to really even be relevant at all anyway, but regardless, part of it was that she was saying it's rebuttal. So Judge A didn't say it, but Camille says, so I'm going to give a half credit on that one, I guess, perhaps. Now, having said that, it could be that there's a sidebar that comes up later, during her testimony where they object for the same thing, and then maybe perhaps we'll see, maybe Judge A will, at that point, herself say something about it being rebuttal, and then I can get full credit for the squirrely crystal ball. Okay, here we were. Yes, thank you, Your Honor. Mr. Rottenborn. Second matter, Your Honor, is just want to get some parameters of what Kate Moss is allowed to testify to. Oh, guess what, guys? Kate Moss today. The court, okay. Mr. Rottenborn, so I don't have to jump up. The court, is H&L her? Ms. Vasquez, yeah. The court, there's a lobby. I didn't know who it was. Okay, so I guess she's using those initials or whatever. Mr. Rottenborn, this is the testimony of Amber related to Kate Moss. It's this one sentence. She said, quote, I just in my head instantly think of Kate Moss on the stairs when I swing at him, end quote. The court, right? Mr. Rottenborn, so in our view, asking about Kate Moss, did Johnny ever hurt you on the stairs? That's fair game. With this, I know she did say that, but that wasn't the only thing she said about this, because she talked about this quite a bit on both direct and cross. And I recall her saying that she had heard this. I think it was on direct. She said she'd heard this. And then I think maybe this quote was from when she was on cross. But I know that she did say something about she had heard it as well, which is a bit different. Okay, did Johnny ever hurt you on the stairs? That's fair game. The court, anything on the stairs, Ms. Vasquez, it's only related to the stairs, but Your Honor, I will represent that in cross-examination. Oh, here we go. Keep reading, squirrel. I will represent that in cross-examination. I also inquired of Ms. Heard whether or not, what about Miss Moss she remembered, and she testified in cross-examination that she had heard a rumor. Mr. Chu, may I just, Mr. Rottenborn, I don't remember that. Okay, that part. Doesn't mean it didn't happen. I don't have that, and I don't recall that. I'm not doubting what she's saying, but if she heard a rumor, it's the rumor about what happened on the stairs. So what I'm saying is they shouldn't be allowed to elicit testimony about, oh, Johnny was so sweet. Johnny never hit me. If they want to get her and ask her, a couple questions about did he hit you on the stairs, I think that's fair game. But anything beyond that is beyond the scope of rebuttal, and I fear that's what they're trying to do, and I just want to stem this off now. You think they're going to keep her, you think they're going to, keep her, like her time, time-wise, they're just going to, no. She's being gracious enough to do it in the first place. Mr. Chu, it is a very short examination, and here's the testimony question. Ms. Vasquez, cross-examination. Mr. Chu, from Ms. Vasquez, quote, you thought he was going to throw your sister down. Okay, so now he's reading, I guess, from the transcript from that day with what we were just saying about. So, you thought he was going to throw your sister down the stairs like he had thrown Kate Moss down the stairs, right? And Amber responds, quote, he swung at Whitney and I'd heard a rumor about that, so that's what I thought of, end quote. Bam. Court, right. There you go, Rottenborn. Happy? Mr. Chu, she testified about it both on direct and on cross. Yeah, that's what I was saying. Court, okay, yes, about the stairs, Mr. Chu. It's a very limited inquiry about whether he ever physically harmed her. We've been doing that throughout the Ms. Vasquez. They brought in Mr. Chu. Clearly, what she's saying is that Johnny was violent with her, and she's going to say that's not true. Mr. Rottenborn, that's beyond the scope, Your Honor. The only two times Kate Moss came up in this is this rumor about, so I guess he's now conceding to the fact that she did say a rumor. Is that the right word? I think that's the right word. What word am I thinking of? Yeah, conceding. Okay. The only two times Kate Moss came up is this rumor about what happened on the stairs to get them to elicit testimony about was he ever violent, which I know is what they're going to try to do, and that's beyond the scope. Mr. Chu, they elicited testimony from Ellen Barkin about Johnny throwing a bottle 30 years ago against a wall in a crowded room. Great point. And being abusive. Mr. Rottenborn, Your Honor has held both parties, where's my thing? Okay. Your Honor has held both parties to objections that are made at the time, and if objections aren't made at the time, then we waive them. They could have brought these brought up these issues, the court, they objected to Ellen Barkin's deposition testimony. Ms. Vasquez, even in motion to eliminate, Your Honor, Mr. Rottenborn understood, but my understanding is not on the same basis that we're objecting now. I'm saying this is beyond the scope of this. It's rebuttal testimony. Your Honor has been very strictly the court, but they're saying they're rebutting Ellen Barkin also. Ms. Braddock, they never raised it in the interrogatories. No, shut up, Elaine. Mr. Rottenborn. It's funny. I said that just because she just jumped in randomly. It's like you wouldn't have even known she was still at the bench, right? She just, pipes up like peanut gallery, Mr. Rottenborn, they can't call Kate Moss to rebut Ellen Barkin, Your Honor. That's inappropriate rebuttal testimony. This is the one and only instance where Kate Moss ever came up, which was a rumor that Johnny had injured her on the stairs, which wasn't limited to Amber. That was a widely circulated rumor. That should be the court. I'm going to limit it just to the stairs, okay? Mr. Chu, Your Honor, I understand. The court, because the only reason it's coming in is because she opened the door on cross-examination about the stairs. Yep, exactly. Mr. Chu, but won't the jury think they're not allowed to ask whether he ever hit her? They're going to think, the court, well, I mean, he could have done it in the case in chief. I don't even know if it would have come in the case in chief. But what I'm saying is the only reason it was overruled because the door was opened because she mentioned Kate Moss on the stairs. She did that, and that's why she's coming in to testify that nothing happened on the stairs. It's all about the stairs. Mr. Chu, may I set the context of how she knows? The court, well, yeah, how she knows is fine, Mr. Rottenborn, how she knows him. If it's like you dated for 5 years, that's fine. Mr. Chu, I just don't want to run afoul of the court's rule. The court, you can do that. I'm saying you can't ask any questions about was he ever violent. Mr. Chu, I understand. The court, focus right on the stairs. Mr. Chu, I gotcha. Understood, Your Honor. I just want to be clear. I don't want to run afoul of the court. I appreciate it. Mr. Rottenborn, 2 more. I'll be quick. This is Dr. Collins, who they've indicated they'll be calling today. Dr. Collins is a pathologist who will testify, I think will testify about some bruising pictures on Amber's face. They designated a longer report of her at the initial, this is kind of like the Berkovici situation last week. They designated a longer report of her in the initial designations. They didn't put her on in the case in chief. Her rebuttal designations, which were filed at the end of February, consist of that, and so we believe that she should not be allowed to testify. They could have put her on during the case in chief. They elected not to. The court, all right, so this is the only rebuttal designation? Mr. Rottenborn, yep, so I guess that means that this would be like a deposition video thing. Miss Myers, if I may, Your Honor, we designated her as an informative witness, right? So we designated her at the earliest point at which we had to identify our expert witnesses, which was in January of 2022. The court, obviously, they can't rebut anything on Dr. Jordan because Dr. Jordan didn't testify. Ms. Myers, that's true. And we don't intend to have her do that. The court, so previously exposed as to which plaintiff incorporates by reference. So what was the first, Mr. Rottenborn? The first designation was quite wholesome. Wholesome? But our point is, that's their case in chief. They should have put her on during their case in chief. To just call her during rebuttal, the court, here's the problem. It's not just rebuttal, it's the defense to your counterclaim, Mr. Rottenborn, right. The court, so that's an issue you're going to have with some of these witnesses, Mr. Rottenborn. I have a response to that. So there was an initial expert disclosure, which I think was January 11th or January 10th, something like that. The disclosure for people in response to the claims. The defense was due February 10th, the court, okay, Mr. Rottenborn. Then there was a final rebuttal disclosure. They didn't disclose anything about Collins on February 10th, the court. They did disclose some people on February 10th for the defense, Mr. Rottenborn, but not Collins. The court, all right, so Mr. Rottenborn, so Collins was not listed. The court, so either in their direct case or rebuttal, but not in the counterclaim, Mr. Rottenborn, correct. And the only reason that she's listed for rebuttal is Dr. Jordan. We didn't call Dr. Jordan, so she shouldn't be allowed to testify in rebuttal. Ms. Myers, Your Honor, we designated her in our affirmative designations. They had notice as of January 2022. She's the earliest. They had more notice than was necessary to put her up on rebuttal, and in those designations, which the court, right? As a reminder for anyone who's kind of new to these sidebars, anytime you see those 2 lines, like here, the dashes, it means people are talking over each other. Ms. Myers, if necessary, I can go grab. We identified at the end, we said that we are also able to designate her to testify in rebuttal in response to anything that any witness has testified to. And at this point, the court, well, you can't use an expert rebuttal on lay witnesses. Ms. Myers, but we, the court, an expert in rebuttal can only rebut experts, Ms. Myers. So we identified her in our initial disclosure, the court. So what is she rebutting? Which expert is she rebutting, Ms. Myers? We designated her affirmatively. And so I have to say, I feel like I'm a little bit unclear as to what's happening with this witness because I don't know. I feel like they're kind of evading answering the question when it should, I feel like it should be kind of obvious, right? Because like each witness is there to rebut another witness. It's like, so I don't know why they can't answer this. We designated her affirmatively, and at this point, they didn't put in any of the photographs of Ms. Heard during our case in chief. So now that it's in their defense, the court, it's your rebuttal case, Ms. Myers. Well, it's also our defense's case. The court, you didn't designate her as your defense witness, correct? Your defense experts, Ms. Vasquez, I believe we did in reference. The court designated as your defense experts. That's a different story. You're saying they didn't designate Mr. Rottenborn. I do not believe that was ever mentioned on February 10th. These are the two. The court, February 10th. All right, so let me see the designations from February 10th. Do you have the designations from February 10th, Mr. Rottenborn? Mr. Murphy has those, right? He's the new kid on the block, as they say. The court. Does somebody have the designations from February 10th? Ms. Vasquez, Your Honor, Ms. Myers. So, Your Honor, first of all, there's no prejudice here. We identified her affirmatively. Can someone just provide Judge J, please, with the designations from February 10th? That's all I'm saying. The court. Rebuttal experts are only for experts that were deposed. I did this from the last time. I almost said disposed. Sorry, it's deposed. Rebuttal experts are only for experts that were deposed in the case who is rebutting their expert. Ms. Myers, well, she's responding to the evidence that came in their defense. The court. No. Objection sustained. Yeah, she sustained it. I mean, that makes sense to me, honestly. Objection sustained unless you've designated them in your defense, Mr. Rottenborn. And I believe the exact same argument is going to be made for Dr. Neumeister. The court, was he designated in your defense, Ms. Myers? He's the affirmative, and the court, they didn't bring any experts, so he can't testify either. Okay, that's where we are. Mr. Rottenborn, we'll just confirm that there was no reference there. Ms. Sleck-Rose, we're checking too. Mr. Rottenborn, okay, the court, that's where we are. Mr. Rottenborn, okay, that's all we have. Ms. Vasquez, I anticipate, Your Honor, that their rebuttal experts that are counters to Mr. Neumeister and Dr. Collins will also not be allowed to testify in the rebuttal case. Did they accidentally call him Dr. Neumeister? Where was he? No, he's a Mr. Okay. The court. Well, yes, because if Mr. Collins doesn't testify, then they don't get a rebuttal expert either. It works both ways. Ms. Bredoff. We wouldn't be able to call Jordan if Neumeister is out correct. The court. They can only rebut experts you've put in on your defense. All right, Mr. Needlehoff. Mr. Murphy's looking for February. Good. So, you know what? Now I'm glad we have this new character because somebody's got to find that for Judge A. So I'm glad he's on the case. The court, 10th of February, Mr. Murphy, February 10th. I don't see Collins. This is part of my argument, Your Honor. Neumeister is not in there as well. The court, we have Richard Marks in defense, Mr. Spindler in defense, Mr. Banya in defense, Dr. Curry in defense, Dr. Shaw. So all those we heard from yesterday, in trial time, right? That's where we are. All right, so that's where we are. Oh, and the TMZ motion, oh yeah, is set for 1 o'clock. So they'll be here at 1 o'clock to argue their motion. All right, we get that today as well. Would you like to weigh in on the motion, Mr. Chu? Yes, Your Honor, we're prepared. The court. It will be quick, though. Ms. Myers, if I may, I have some exhibits for Jamie that she requested. The court. Sure. Ms. Sleck-Rose, Your Honor, we had prepared a written opposition to the motion to exclude Mr. Neumeister. The court. Would you like to put it in as part of the record? Ms. Sleck-Rose, yeah, I think it's a good idea. The court. Thank you. Ms. Sleck-Rose, thank you. And here we are to open court. And it looks like they're ready for the jury. Jury's going to come in, and our first witness of the day will be Kate Moss.
Do you swear affirm to tell the truth under penalty of law?
I do.
Thank you.
Good morning, Ms. Moss, or I should say good afternoon, your time.
Oh, she's also in the world.
My name is Ben Chu from the firm of Brown Rudnick. Would you please state your full name for the record?
Kate Moss.
Ms. Moss, where do you reside?
London, England.
From where are you testifying today, Ms. Moss?
Gloucestershire, England.
Ms. Moss, do you know Johnny Depp?
Yes, I do.
How do you know Mr. Depp?
I had a relationship with him.
Did there come a time when you and Mr. Depp had a romantic relationship?
Yes.
I'm riveted.
For how long, Ms. Moss, were you and Mr. Depp a romantic couple?
From 1993 to 1994 to 1998.
Ms. Moss, did there come a time when you, while you and Mr. Depp were a couple, that the two of you took a vacation together to the Golden Eye Resort in Jamaica?
Yes.
What, if anything, happened when you were in Jamaica with Mr. Depp?
We were leaving the room, and Johnny left the room before I did, and there had been a rainstorm. And as I left the room, I slid down the stairs, and I hurt my back.
I've done that in Cancun when it's wet.
And
I apologize, Ms. Moss. Please continue.
and I screamed because I was because I didn't know what had happened to me, and I was in pain. And he came running back to help me and carried me to my room and got me medical attention.
Did Mr. Depp push you in any way down the stairs?
No.
During the course of your relationship, did he ever push you down any stairs?
No, he never pushed me, kicked me, or threw me down any stairs.
Ms. Moss, have you ever before today testified in any kind of court proceeding?
No, I have never.
Why did you decide to testify today?
Objection, Your Honor.
Because it's all bullshit, Your Honor.
We just talked about.
All right, I'll sustain the objection.
Thank you, Ms. Moss. We have nothing further at this time. We greatly appreciate your taking the time.
I want to know what she was going to say.
Examination?
No, Your Honor.
All right, you're free to go. Thank you, Ms. Moss.
Thank you very much.
Thank you very much. Thank you.
That's it. That was it. Wow. I'm trying to move the closed captions. That was quick. Was it
Your
impactful?
next witness.
Because it was quick.
Your Honor, we're calling Dr. Shannon Curry.
Yes.
Just give us a moment to move the TV.
Dr. Curry is up next. Let's go.
Plaintiff called Shannon Curry, Dr. Shannon Curry.
Has Dr. Curry
You're
just
still
been
under oath,
chilling
so
in Virginia the whole time?
Please have a seat, doctor.
Good morning.
Good morning, Dr. Curry.
Good morning.
Can you remind the jury?
Dr. Gray.
who
Good
you
morning,
are and
Dr.
what you
Gray.
do?
We've slipped
Sure.
into a television show.
I'm Dr. Shannon Curry. I'm a clinical and forensic psychologist, and I'm here today to rebut the testimony that was provided by Dr. Hughes.
Which of the opinions rendered by Dr. Hughes do you intend to rebut?
So generally speaking, there are three main categories that I'd like to talk about today. So the first is that Dr. Hughes misrepresented the tests and the results that she utilized in her evaluation. She misrepresented my testing and the results that I obtained in my evaluation. And she communicated in a manner, provided testimony in a manner that presented essentially her own opinions and the self-report of Ms. Heard as facts.
Yes, she sure did.
Okay, the first category you talked about was misrepresentation of her own test methods and results. What do you mean by that?
So Dr. Hughes she stated that she administered 12 tests. In actuality, she used 8 checklists. About half of those were symptom checklists. The other half were checklists about experiences that people can have with domestic violence. And those are not appropriate for forensic settings. They are easily exploited.
Other issues that you intend to address relative to misrepresentation of own results?
Yes. So in addition to using these checklist measures, which are easily exploited in a forensic context, they're developed for research or treatment only.
Different.
She also stated that these checklists revealed things that they simply cannot reveal, especially in this context.
Like?
And let's see. She also misrepresented information, clear indications on several of the objective measures that she offered. And there were indications visible that Ms. Heard had essentially engaged in what we call response distortion. So clear indications of exaggeration on one of the measures that's specific to PTSD, clear minimization.
And she is a PTSD expert.
On another more broad personality and psychopathology based measure that she gave to Ms. Heard, which she did not acknowledge.
It's very strategic for Team Depp to have so many women coming to testify on behalf of Johnny Depp.
Dr. Hughes administered CAPS 5 about 10 days after I did, almost 2 years after she initially tested Ms. Heard. And she did not administer the test appropriately. So she left major components blank. She didn't apply the scoring rules that are clearly outlined with the test. And yet she diagnosed Ms. Heard with PTSD based on that assessment.
And that's why they brought her in as a PTSD expert.
Dr. Hughes's use of the personality assessment inventory.
On the PAI, there were clear indications that Ms. Heard was responding and obtained scores in a manner that's consistent with individuals who have a personality disorder. Psychologists, I wish we were mind readers. I wish we had a crystal ball and could find out whether intimate partner violence occurred and look back in the past. But it's nothing like that. Really, it's a lot less interesting. We look at data. We have to control for those response biases. And then we also are looking at functioning, which is really the bottom line of the assessment. Did the person have a change in functioning from before the alleged trauma, or in this case, the alleged IPV, to after? Is there a decline in the way they're going about their lives?
And Your Honor, may we approach?
All right.
No amount of objections is going to undermine Dr. Curry, and I'm sure the impact she has on this jury.
It is time for another sidebar. The court. Yes, ma'am. Miss Braddock. All right, she's testifying outside the scope of her designation now, Your Honor. Doctor, and I elicited this from her, and you may recall this before. The only thing she's testifying to is whether Ms. Heard has PTSD or not. She is not. She's explicitly testifying, or she's explicitly not testifying. What? Elaine, not making sense. As per usual, let me just read this again so my brain can wrap my head around it, or just stay confused, I suppose. Remain confused. She's explicitly testifying, or she's explicitly not testifying about whether she suffered IPV or not, whether she was a perpetrator, whether she was a victim, whether she suffered any domestic abuse. All those things she's already testified and admitted. Those are not part of her opinion, and now she's clearly trying to tell the jury about IPV and assessing whether somebody has suffered from IPV, and that's completely outside the scope of her designation. Mr. Dennison, Your Honor, I respectfully disagree with that analysis. This is the root of the report. There are multiple pages in this report, pages 18 through 23. The court, Mr. Dennison, that reflect each of the tests I've been asking about and why Dr. Curry believes they were administered incorrectly. Ms. Braddock. And I didn't object on those, but now she's testifying about whether somebody suffered from IPV or not, and that is absolutely outside the scope, Mr. Dennison. First of all, I don't think the court, I'm not sure that's where she was going, Ms. Braddock. She just says explicitly, she said, when you're trying to figure out whether somebody's suffering from IPV or not, the court, not that she's going to give an opinion to that. I think she's just discussing, Mr. Dennison. Well, she's certainly not giving an opinion to that, Ms. Braddock. That's outside the scope. She cannot address whether somebody suffers from IPV or not. She's already admitted that outside the court. Well, I don't think she's giving an... We're just going in circles here. This is wild. I don't think she's giving an opinion about whether somebody... I think she's talking about IPV, Ms. Braddock. She can't talk about IPV. She's confined to PTSD, and she cannot... And she said she did not try to evaluate for IPV. I even elicited it from her testimony earlier. Nothing about IPV or domestic abuse, Mr. Dennison. Your Honor, she specifically identified that nothing about IPV other than that test given by Dr. Hughes were done inappropriately. Ms. Braddock, and I did not object when she was testifying to those, Your Honor, but now she went into, she's talking about whether you have, oh my gosh, crystal ball, that's funny. You have a crystal ball. Whether you can determine whether somebody suffered from IPV or not, and that's outside scope. It's not anywhere in any of her testimony, Mr. Dennison. I believe the answer was in relation to the use of the checklist. The court overruled the objection to make sure it's within the test. Okay, Mr. Dennison, thank you. Ms. Braddock, okay, back to open court.
Dr. Curry, let's look back at
the muffins.
Some of those domestic violence checklists that you were talking about.
Okay.
What
She's so smart.
Well, Doctor, first of all, they shouldn't be used. So we do have professional standards that require that we utilize instruments that are relevant and appropriate for the particular setting. You have to make it very clear. Transparency is really at the center of good science in general.
Transparency is at the center of
You
good
talked a
science in
little bit
general.
about,
Big fan of science, Dr.
ignoring
Curry.
Response distortion. What is response distortion?
Response distortion is a term that speaks generally about an examinee approaching a test and providing answers that are either exaggerated or minimized, but in some way an inaccurate representation of their current mental status or their experience.
What test do you believe that Dr. Hughes failed to acknowledge response distortion on?
So she administered the personality assessment inventory, which is similar to the test I gave, the MMPI-2. It's that general broadband measure of psychopathology symptoms.
There are no pauses in the way she
personality
speaks.
traits.
She's
It
just so
includes several
fluid.
scales that are very good at detecting either exaggeration, minimization, or even trying to claim that you have unusually good qualities. On that test, there were clear indicators that Ms. Hurd, very similar to the way she approached my MMPI, engaged in defensiveness. And in fact, there's a function that you can look at. So you have that main scale elevation, we call it positive impression management, was elevated. And then because we want to make sure that somebody isn't elevating that scale just because they have such well-being, there are additional configurations of scales that you can look at to find out what's going on. And so the Cashel discriminant function is sort of the name of one of these configurations, these equations that are done. And she was highly elevated on that. In fact, that elevation tells you that no, this isn't accidental. This isn't because she's just doing so well in life that she has an extremely, extremely low amount of problems. No, this is an intentional over-reporting, or I'm sorry, an intentional effort to minimize any appearance of having problems.
Now,
That's
you may
so
have addressed this, but there
interesting.
was a reference to malingering.
Yes.
It's not that
So what's
they're doing
interesting
well, it's
about
that they're
Ms.
trying
Hurd's approach to different
to seem
tests
like they're
is
doing
that it
well.
seems to be influenced by what we call the face validity of questions on the test. So if a test
looks like Whitney's
like it's
in the
measuring
gallery.
PTSD, you see exaggeration on her validity scales. If the test has less face valid questions, for instance, the personality assessment, which Dr. Hughes administered, the MMPI-2, which I administered, where she can't quite figure out what the questions are asking, they seem really banal in general. On those, you see extreme defensiveness, minimization of any potential pathology, essentially presenting herself as perfect and free of any mental illness or personality disorder. But on the trauma symptom inventory, which Dr. Hughes administered, that was the one that I previously indicated for ease of
She's gonna keep saying
explanation. When the
exaggeration,
test
too.
results come out for how the person approaches the test, that test itself prints it as a percentage. And there's a really excellent scale for finding out if a person is exaggerating their symptoms of PTSD. It's called the atypical response scale. And the
Happy birthday, Lynn.
TSI-2 is the revised version of this test, and that scale was improved this time around to really try to be a clean indication of, is this person exaggerating? And it puts quite high questions in the test
Not
that are
condescending at
so
all.
unusual. They might sound like PTSD, but even the most severe cases of PTSD don't have these symptoms. And so somebody
so
who's
interesting.
intentionally trying to exaggerate PTSD, or possibly unintentionally, but nonetheless, who's exaggerating it, is likely to endorse these items, even though they're not real PTSD symptoms. Ms. Hurd scored so highly on this that is effectively ruled out as a possibility.
She just said
Okay.
negative Ghost Rider.
What about Dr. Hughes's administration and use of the CAPS-5?
Okay, yes. So Dr. Hughes had diagnosed Ms. Hurd with PTSD back in 2019 when she began testing her. It wasn't till 2 years later, more than 2 years later, 10 days after I administered the CAPS-5 with Ms. Hurd, that Dr. Hughes held an impromptu evaluation session remotely with Ms. Hurd and administered the CAPS-5. She had previously
She diagnosed her without
PTSD
the CAPS
without
5?
using what we consider to be the gold standard PTSD diagnostic interview. And again, when we're doing a forensic evaluation, it is an important responsibility, and part of our ethics and professional standards are that we document everything to allow for transparency and full judicial scrutiny. And Dr. Hughes administered it incorrectly. She left huge sections, very relevant sections, blank. There's no way to understand why she scored it as high as she did based on the information that's provided. You're essentially supposed to notate the examinee's responses as verbatim as possible to explain your reasoning and implying their scoring procedure. It's a standardized test. And if you don't follow those standard procedures, it's completely invalid. Not only that, but it looks as though Dr. Hughes further invalidated it by trying to show that she had assessed for the childhood trauma impact. And she had said that she went back and asked the childhood question, but you can't do that. If you're assessing for two separate periods of one's life to find out the relatedness to PTSD, you do two separate CAPS interviews.
Look at what I've learned.
You don't create your own question system. That is non-standard administration of the test, and it invalidates it.
All right. You also mentioned with respect to the PAI or the personality assessment and inventory.
Wow.
Mention, some elements. What did she fail to mention?
Oh, okay. So on the personality assessment inventory, so first she failed to mention that there were clear indications of response distortion. She also failed to mention that Ms. Hurd scored in her score profile against their main scores. She did elevate a score for the borderline personality disorder sort of section, but that in and of itself would not indicate a diagnosis. However, the configuration of her scores overall is consistent with that. And in fact, it's one of the diagnostic suggestions given by the test itself. And then also there's a configuration around Ms. Hurd's trauma responses on that particular test, which demonstrates that it is more likely that those symptoms were reported in relation to something in the distant childhood. It's more consistent with childhood chronic abuse than present circumstances or recent circumstances.
Okay, I think you said in addition to the issues with her own testing, Dr. Hughes misrepresented your results.
She did.
Can you tell us how?
So I would say the main issue was that she said that Ms. Hurd obtained a normal profile on my MMPI-2.
How is evidence of PTSD generally exhibited?
So really the bottom line in a forensic psychological evaluation is a change in functioning. That's what we're looking for. Again, I said, we don't have a crystal ball. We're not wizards. We can't get into somebody's head.
Not the wizards,
what we're looking for were there identifiable changes
next to Jedi
in the way the person engaged in their world. Were they able to keep a job? PTSD is an extremely disabling diagnosis. When a person has true PTSD, it is difficult for them to work. You'll see unemployment, job loss. It causes extreme levels of distress and impairment.
What about Dr. Hughes' suggestion that Mr. Waldman's statement
that should have been the last
served
question
as a trigger for Ms. Hurd's PTSD?
All right.
Sidebar time, sidebar time, sidebar time, sidebar time. It's time for another sidebar. Miss Bredoff, very explicitly. Boy, this word has popped up like I could, maybe when I finish reading these, I'll go and do a word finder, because I feel like if I had to guess, this is probably the 10th time so far this has popped up today, and this is what, like, third sidebar, and maybe even more than 10 times. Like, and weirdly, I don't feel like we've seen it. Like, reading these, I don't know that this has even come up, and then, like, today, it's like, yeah, anyway, okay. Very, very explicitly, she's not testifying about, and I elicited it in trial testimony early, and she is not testifying about whether Miss Hurd suffered any PTSD as a result of defamatory statements. Explicitly testified She is not. She's not. It's not anywhere in her report. It's not in her rebuttal report, and she admitted that on the stand, and that she is not addressing that. She was not asked to address that, Mr. Dennison. Her answer, and it's the last answer of this inquiry, is there is no PTSD to be triggered. Oh, yeah, I remember this part. Miss Bredoff, still, he's trying to connect it to the defamation. You know, she can say there's no PTSD, but she can't connect it to the defamation. She did not disclose that opinion. The court, she's going to bring up the defamation is the issue, Mr. Dennison. All it literally says is it brings it into the current time frame. There's no effort to connect it to other than saying there was no PTSD to be triggered. The court, I think you can state there's no PTSD to be triggered. I get that, Miss Bredoff. I disagree, Your Honor. Shocker, right? He's bringing up the defamation and letting her give an opinion about whether she has PTSD. No. Whether she has PTSD as a result of the defamation, and she explicitly said that she's not speaking to that. The court, okay, you cannot ask the defamation, but she, I'm sure I'm supposed to say she can say no PTSD has been triggered. Mr. Dennison, I can do it and not talk about it. The court, all right. Ms. Bredoff, thank you, Your Honor.
She is not, in fact, a level 3 sommelier. She has passed level 2 and is going to take level 3. She is in training, but it was misrepresented. It's like saying I'm a PhD. It's like, well, no, I'm a PhD student.
Ms. Hurd's PTSD was somehow triggered.
Right. Dr. Curry did say trainee. She pledged to be level 3.
I would say
You're
that
hilarious.
it can't be triggered if PTSD isn't present.
Thank you very much, Doctor.
All right. Cross-examination.
Mind your time, Elaine. This is the problem. This is the problem for Elaine. She only has so much time left.
Dr. Curry, I just want to make sure that we all remember you're not board certified, correct?
No, I'm not.
Okay. And you've been licensed for how long?
I've been licensed for 10 years.
Okay.
I've been busy
And
treating veterans.
You are being paid by Mr. Depp's legal team to be here, correct?
Yes.
That sword cuts both
How much have you
ways.
charged so far?
I actually don't know.
Over 100,000?
I truly don't know. I don't do my own books.
Over 200,000?
She's
I
still not
don't
going to know. Use your time, girl.
300,000?
That would be way too much, but I do not know.
Okay. Now, just so that we all remember, you had dinner
Just so we all remember.
at Mr. Depp's house
Muffins.
for 3 to 4
Oh.
hours with Mr. Depp,
Just so we
Mr.
all
Waldman,
remember.
Mr. Chu, and Ms. Vasquez, correct?
I was interviewed. I asked if there was anything I could eat because
Elaine?
in about 3 hours I started to get hungry.
Were you present for Dr.
Mr.
Spiegel?
Depp then offered
You in
order
danger,
takeout
girl.
for the entire team.
So you had dinner at Mr. Depp's home
Trying to make
with Mr. Waldman,
Dr. Curry look
Mr.
unethical
Chu,
is
Ms. Vasquez, and
fucking
Mr. Depp,
preposterous.
correct?
Yes,
And you had drinks as well, correct?
I actually don't know. I do remember that there were drinks.
Do you recall testifying earlier that you did have a drink, a mule something?
No, I remember testifying that there might have been a mule.
Are we drinking
I'm not
Moscow
telling you.
mules? They're
Okay,
delicious.
thank you. We didn't have animals there as well, right?
No animals.
Okay, that's good to know.
Mhm.
And
Are you
talked about
fucking kidding me,
transparency.
Elaine?
I just want to make sure you had several.
There's no alpacas there either.
designations, expert designations and reports in this case, correct?
Yes,
And in not one of them did you disclose that you had dinner and drinks at Mr. Depp's house for 3 to 4
Elaine, they've
hours
seen
with
Dr.
Mr.
Spiegel.
Waldman,
This
Mr.
isn't
Chu,
gonna
and Ms.
work.
Vasquez. Is that correct?
Ms. Bredehoff, you're mischaracterizing what occurred.
Dr. Curry, please answer the question. Not once did you disclose this in any of your
I
reports.
did not
correct?
disclose that I was interviewed as that standard procedure.
Dr. Curry had dinner.
But it's true that you
Be
have
shook.
never gone to a client's house to be interviewed for an expert witness position,
Most
correct?
of them aren't Johnny Depp.
Yes, because I never had a client that was essentially homebound because of their celebrity status.
All right. And you
Wow.
talked to Mr. Depp for 3 to 4 hours
His legal team.
before taking on the role of assessing Ms. Heard and deciding whether she was suffering from any distress, correct?
I did not talk to Mr. Depp. I was talking to his legal team and he was there to observe.
He was present for the 3 to 4
Yes.
hours. Oh, and are you saying now he just stayed silent and said nothing all day?
I don't recall what he didn't or didn't do. I was answering questions.
Okay.
Get to the
Now,
muffins.
your expertise here is limited to whether Amber Heard suffers from PTSD currently. Is that correct?
Yes, I was tasked with conducting an evaluation to determine Ms. Heard's mental status.
We're on very, very strict time limitations because we promised to get this case to the jury. So I really appreciate you just answer my question.
You're on very strict time.
Okay? Thank you very much.
You're on very strict time.
After you had the dinner, you then provided a designation in February of 2021 in which you said, and this is long before you ever saw
Stop asking
Amber
about dinner
Heard,
if you're
correct?
worried about it.
You said that
Elaine.
Amber Heard, quote, exhibits patterns of behavior that are consistent with co-occurring cluster B personality disorder traits, especially borderline personality disorder, end of quote, correct?
No,
We went through this before.
we did.
But, and
We can
that
still
was
do
on
it.
the designation, was it not?
I told you last time that I did not write that.
Okay. And you don't know who did on the legal team, correct?
No.
Okay. And then I also asked you, if you may recall, whether you listened to the audio recording in which Mr. Depp taunted Amber Heard that she had a borderline personality disorder. Do you recall that?
I recall you asking me that, yes.
Did you recall listening to that audio tape?
I don't recall Mr. Depp taunting Ms. Heard. I do recall that he at some point suggested she might have that diagnosis.
Okay. And that was back in these audio tapes back when they were together, correct?
Yes.
Okay. Now, you've never before been asked to testify or serve as an expert with respect to someone who has bipolar disorder, correct?
No, as I previously stated, that's not true.
All right.
Good. Let's take the time to do it. Did the judge remind them how strict the time was? Because she seems pressed about it. Your mic anymore. Your mic, Elaine. You're just muttering around the courtroom
Your
at the
Honor, can we
moment.
approach it?
All right.
Your mic, Elaine. She's just wandering around muttering.
Okay, so it looks like Elaine is fumbling around for something. She doesn't have some sort of, I don't know if it's a exhibit or what. She's looking for something. She's distributed all her copies. So she's apologizing. Mr. Dennison, Your Honor, may we approach? The court, okay. Sidebar. The court. I think we've cleaned up since then. Miss Brown, my apologies on that one. I thought they were still here. Mr. Dennison, I get it. Are we going to rehash the entire previous cross-examination? Miss Sprout, she just testified to bipolar. Mr. Dennison, it's her time. The court, it's her cross-examination. Mr. Dennison, right. The court, I don't have mine. Miss Sprout, should I just show it to her? Would that be the best way to do it? Mr. Dennison, I'm perfectly fine if she approaches the witness and shows her the deposition. The court, right. Just remember, you need a microphone, so don't, oh God, Elaine with her microphone, I swear to God. You need a microphone, so don't start talking. Miss Sprout, okay, thank you for the reminder. I'm shaking my head. You guys can't see me, so I'm just telling you. Mr. Dennison, thank you. Miss Sprout, thank you. Back to open court.
That one? Yes.
The glasses are out. We're ready to roll.
Now, you recall testifying in your deposition on March 21, 2022, correct?
Yes.
And you were under oath at that time, correct?
Yes.
And the question I just showed you on page 207, line 5, have you ever been asked to testify or serve as an expert with respect to whether someone has bipolar disorder? And your answer at that time was no, correct?
Yes, I had forgotten that case.
Okay. And have you ever been asked to testify whether anyone has behavioral or characterological conduct that suggests they may be an IPV perpetrator?
What?
I may have. It's difficult after about 250 cases. It's difficult to remember.
Sorry, I've done so much work.
All right. And have you ever been qualified as an expert in the area of IPV?
No.
And have you ever been qualified to testify as an expert in domestic abuse or violence?
Domestic
abuse or violence?
Yes, that's been a component of testimony.
Right. Elaine, you offered Dr. Spiegel. No one's going to forget that happened. No matter how much you try to talk about dinner with Dr. Curry, no one is going to forget Dr. Spiegel. No one. Oh, yeah. We're fully in. Your failure to plan is not my emergency.
Okay.
This is a rerun. They're trying to make Dr. Curry seem biased. They forget that they've introduced Dr. Hughes and Dr. Spiegel.
Line 16.
And they tried to use Dr.
207.
Spiegel to
Have you
fix
ever
Dr.
been
Hughes.
qualified as an expert in the area of IPV? Your answer on line 20 was no, under oath, correct? Then the next question, have you ever been qualified to testify as an expert in domestic abuse or violence?
I feel like this is a donation, not a pledge. Thank you.
Line 4, the answer then under oath was no.
Sure.
Now,
Keep reading, Elaine.
you would agree.
At least she didn't say, did I read that
The
right?
literature is quite clear that trauma-based symptoms such as PTSD or complex PTSD have symptoms that overlap with borderline personality disorder and histrionic personality disorder, yes?
Yes.
Okay. And you would agree that it's important to use valid and reliable measures for an accurate diagnosis, correct?
Absolutely.
Okay. You chose, however, not to administer the structured clinical interview for DSM-5
Trying to roast Dr. Curry is not the best use of your time.
SKID. Is that correct?
I did.
Okay. And would you agree that that is a state-of-the-art structured clinical interview?
Not for a forensic evaluation with a sophisticated examinee.
But to determine if a personality disorder is present?
No, not in this setting.
You don't agree with that?
I do not.
And you don't agree that that is the gold standard assessment for reliable, accurate psychiatric diagnosis?
It's a good one.
It's
but
situational.
for treatment settings especially.
Okay. Now, did Ms. Hurd, you said you read all of the treatment records, right?
Yes.
Okay. Do you recall reading the
If I'm
treatment
Dr. Curry,
records for the psychologist
My answers would be
Bonnie
slowing down,
Jacobs,
and I would be taking a moment to
who saw Amber
think
Hurd over 5 years?
I do.
for
And did
every
you
question.
see anything in Bonnie Jacobs' notes over 5 years in which she diagnosed Ms. Hurd with borderline personality or histrionic personality disorder?
No.
Now, you also saw the notes of Dr. Connell Cohen, correct?
Mhm.
And you even attended his deposition, correct?
Yes.
All right. And he saw Amber for roughly 2 years. He was part of
Happy
the Dr.
anniversary,
Tipper connection,
Lisa.
right?
Yes.
Correct? Okay. And did you see anything in Dr. Cowan's notes? And did he say in his deposition that he diagnosed Amber Hurd with borderline personality disorder or histrionic
y'all
personality
might be right.
disorder?
I
Elaine
saw the
might be jealous
symptoms
she didn't
clearly
get to have
delineated
dinner
throughout
with
his
Dr.
notes
Curry.
and in his deposition. He does not use diagnoses, so he would not have diagnosed her.
He said specifically in his deposition he did not diagnose her with that, correct?
Yes, and he also specifically stated that he does not
diagnose.
use diagnoses.
All right. Now, Dr. Hughes administered a full intimate partner violence assessment, correct?
That's not a psychological assessment. We can't assess for intimate partner violence. That's an event.
Dr. Hughes administered a full intimate partner violence assessment,
She
correct?
stated that, and that's actually something I'm rebutting today.
Okay. And you reviewed her psychological testing?
I sure did, yes.
Okay. And are you aware that in
Wow.
September 2019, Ms. Hurd had a trauma-based symptom on many of those valid tests?
Well, you're characterizing them as
Can you be a
valid.
little bit more specific? Many of those valid tests, which tests are you talking
Do
about?
you have a recollection of that, September 2019?
That's what
She
she just asked
administered
you.
all of
Elaine.
her testing in September 2019, so I'm not sure which one. Oh, except for the CAPS 5, which was 10 days after mine in 2021.
Now, Dr. Hughes clinically evaluated
Elaine just gave up and
those
moved on.
symptoms and established that Ms. Hurd does have PTSD from the totality of the intimate partner violence by Mr. Depp, correct?
That's what she stated, yes.
Okay. Now, Dr. Anderson's clinical notes that said Amber had come to
Objection, hearsay.
Yes, you can't read
I
them into
haven't
the.
even asked the question.
You're reading notes into the record, Elaine.
Notes?
Well, no, actually, I wasn't going to read her notes. I was
Okay.
going to ask a particular question.
You said.
You talked about danger. Do you recall that in your testimony?
Yes.
All right. Now, if
Girl, you're in.
a patient comes to you as a couples therapist
Mhm.
with two black eyes, would you assess that there may be a potential danger there?
If they're a couples
Sure.
therapist,
Did you read Dr. Anderson's notes?
I believe I did.
Now, you have not been asked to testify about Ms. Hurd's behavior in the context of her relationship with Mr. Depp. Is that correct?
I wasn't.
I was asked to testify about somebody's behavioral mental status in general, so that can include behavior and involved in a relationship with Mr. Depp.
I think
But
Elaine
not
sees
specifically.
it lining up too close.
Can you pull up date 10?
Yeah, this being rushed is
The trial
not going to be
testimony
impactful.
at
It just
page
feels like
2710.
fucking chaos. It just feels like chaos is happening. That's exactly what it feels like. I shouldn't be putting on lip gloss when Elaine pauses. This is when I should be talking, but you know. Elaine's annoyed that she can't pull it up. Her saying we're on very strict time makes me think that the judge has
All right.
makes me think that the judge has admonished them that they are on strict time.
Oh, sidebar time, oh, sidebar time. Here comes another sidebar. The court, okay, Mr. Dennison, I think the request I heard, may we pull up some trial testimony, and I'm Miss Braddock. I'm not going to show it to the jury, Mr. Dennison. Okay, that's the issue. The court, this is to refresh. Miss Braddock, this is what I said. This is what I should have done in deposition. It would have made it go a lot faster. Mr. Dennison, that was why I asked. The court, okay. Back to open court.
No, not grounds for
Dr. Curry, this
malpractice.
is your testimony
Not great
from
trial
day
strategy.
10 in this case. And if you can look at page 27.
glasses. I appreciate that they're not clear framed.
Now,
Thanks,
is it
Dr.
your,
Curry.
my
I see you,
question
girl.
was, now, is it your testimony under oath today that you have not been asked to testify concerning Ms. Heard's behavior in the context of her relationship with Mr. Depp, including any abuse? And your answer under oath
That's a different
to this jury
question.
that day was, that's correct.
Yes.
Correct?
I still agree with that to that question.
All right. And you have not made any determinations, including any opinions, that Ms. Heard abused Mr. Depp or Mr. Depp abused Ms. Heard, correct?
Correct.
Okay. And in fact, you said that's outside the scope.
Yes.
Right? Okay.
Of psychology.
And you cannot testify whether Amber Heard suffered any emotional distress as a result of any of the defamatory comments that she has alleged Mr. Waldman made through Mr. Depp, or Mr. Depp made through Mr. Waldman, correct?
Objection, Your Honor.
Do you want me to read my response?
Sure.
Objection. I'm sorry. Hold on, Dr.
Sorry,
Curry.
Your Honor.
That's okay. Oh, what's the objection? You want to approach? Okay.
I'm laughing because I'm like, what holiday songs have I not done? I feel like I'm running out of options here. All right, so okay. It's cyber time. It's cyber time. It's cyber time. It's cyber time. Sorry, I can't do it without laughing. All right, that's all we're going to do on that one because I won't be able to get through it without laughing. Mr. Dennison. That's the question she wouldn't let me ask the court. Well, it opens it up for redirect. Mr. Dennison, yeah. Ms. Braddock, well, she's going to say what I can testify is there's no indication of a decline in psychological functioning since she's been with Mr. Depp. I'll withdraw that. Okay. The court withdrawn. Back to open court.
Can Dr. Curry analyze me? I'm brain damaged from this trial. She can analyze all of us. I love her work in PTSD. I think it's really inspirational. We need neurodivergent people in law.
Any opinion as to whether Amber Heard exhibits patterns of behavior that would suggest her allegations of abuse against Mr. Depp are false. Would you agree?
No. I mean, yes, I would agree with that.
Oh, thank you. And you have not, no, that's right. That's all I've got. No.
Yep, sit back down.
Right, redirect.
Take your time, Dennison. Slow the pace down. We're all like, we're all a little out of breath and twitchy.
Skid.
Yes.
What's that?
It's a structured clinical interview. It's for rendering a diagnosis. It's best for treatment because you're asking direct questions of the examinee and about symptoms. So if you have an examinee who has a tendency to minimize, you're not going to get much information.
Why didn't you use it?
Because, well, first of all, I had a limited amount of time for my evaluation, and I already had to use, just to complete the interview was extremely time consuming. And I had to even restructure it into handouts so that I could keep Ms. Heard on track. I determined based on that, so this is where you would make an inference. So because I was having difficulty getting direct answers to my questions from Ms. Heard, I had determined that creating forms of those questions would be a better use of the time, which it was. And then I further deduced that adding on the structured clinical interview would probably be unproductive given that I had limited time and needed to use the best, most reliable methods for getting information in that time.
You were asked about the APA specialty guidelines,
Yes.
specifically 1.02 and
Yes.
1.03.
Mhm.
Have you complied with them?
I have.
No further questions.
Thank you.
Yeah.
Thank you. Dr. Curry, you can have a seat in the courtroom. You're free to go. Thank you.
Have you complied with the ethics? Yes. I'm bummed they didn't ask Dr. Curry about Amber's court behavior. I think that would be outside the scope of rebuttal, but I'm still bummed it didn't happen.
Right.
Have you been watching?
And take our morning
have been watching this
recess for
trial with
15
you.
minutes to
Thank you
discuss
for the
the case
hard
and do not
work.
do any outside
You
research.
and Dr. Curry are queens of professionals. Well, thank you. I don't know about that, but I try to be. We are taking the morning break. Thank you for making me feel somewhere as a, that jumped. Thank you for making me feel home somewhere as a trans woman. It's hard finding a place. You changed that. Oh my God. You're going to make me cry, Waffles. Thank you so much. This is a welcoming community if you're welcoming. People who aren't going to be welcoming can find other communities. There's plenty of room for that on the internet. We live by a simple rule. It's basically
just for
don't be
planning purposes.
Yes, time. Give us
Sammy
time.
asked Mr. Tobin to be here as early as noon, just in case with the fluid of the trial. I'm not sure.
Mr.
what time
Tobin's
we get to
probably
that
the lawyer from
motion,
TMZ.
so- Okay, just to let you know. They need to work on that. They're going to find out who the next witness is. So let's go ahead and take a recess until 10:55. Okay. All right. Thank you.
Thank you, Your Honor.
Time for a sidebar. It is sidebar time. Frosty the Snowman, sidebar version. Ms. Myers, Your Honor, I think earlier we were discussing the expert issue. The court, we're going backwards. Ms. Myers, I understand that, but this is why I wanted to grab this. The court, sure. Ms. Myers, this is our rebuttal designations. The court, right? Ms. Myers, we incorporate by reference the affirmative designations of both. Oh, did they find the shit they were looking for that? I guess we incorporate by reference the affirmative designations of both Dr. Neumeister and Dr. Collins. The court, right, Ms. Myers, and so we are offering to rebut not as a fact witness, but evidence that was presented in their defensive case. We understand that rebuttal evidence is evidence that a plaintiff offers to explain or repel evidence that the defendant offered. The court, it's only to rebut an expert. Ms. Myers, Your Honor, I think the rule, the court, I think that's supposed to say it didn't work. It didn't work that way when I didn't let their expert testify. Ms. Myers, well, Your Honor, I think that was a different issue because their expert was only designated in rebuttal to rebut the testimony of our expert doctor or Ms. Frost. In this case, we've designated them affirmatively. In fairness, the court, in your case in chief, Ms. Myers, in our case in chief, and then those affirmative. The court, it's not in your defense. So maybe they didn't actually find anything else to back it up. I guess they're just trying again. Ms. Myers, but this is also our rebuttal case, Your Honor, and we identified them as rebuttal witnesses that incorporated their expert testimony from their affirmative designations. The court, right, so you could have called them in your case in chief. Ms. Myers, but we also designated them as rebuttal witnesses that would testify to. The court testified what? This is what I'm saying, Judge A. I'm with you. I'm with you here, 100%. Ms. Myers, to rebut the evidence that was provided. But what? Which evidence and by who? To rebut the evidence that was provided during the court. An expert can only rebut an expert. Yes, and you've already said that, Judge A. Ms. Myers, so Your Honor, my understanding is that an expert can be called the court if it is it is reversible error if I let an expert testify unless they are designated. Ms. Myers, so we designated the court reversible error is what I'm trying to avoid in this case. Ms. Myers, I understand that, Your Honor. So my understanding is that the rule is not that an expert can't be called in rebuttal unless they're rebutting another expert, but they can be called an expert. You know, under that rule, an expert can never be called in rebuttal if there's no expert testimony on in the defensive case. The court, okay, Ms. Myers, and so we are basically during their defensive case. So this is an issue of fairness. In our affirmative case, I would like to make a record, if I may. Court, yes, sure. Okay, she's making her record. Okay. Ms. Myers, right. So the testimony of our experts, Dr. Neumeister and Dr. Collins, only became relevant once the photographic evidence of Ms. Heard's purported injuries came into evidence. We cannot control. We obviously were not offering that, and they did not offer it when they were crossing Mr. Depp or anything else during our case in chief. The court, they tried to offer it when they did the depositions of the police officers, which was objected to. Ms. Myers, which was objected to, and then it came up during their defensive case. And so the testimony of Mr. Neumeister and Dr. Collins only became relevant once that evidence came in during their defensive case. I'm having some thoughts. I'm wondering if this is a strategy because, like, okay, let's just say that, you know, I don't know if it would be considered 4D chess. Maybe it's just like 3D chess, or maybe it's just like checkers. I don't know. But like, what I'm wondering is, like here, so the court, what made me think of this is when Judge A says they tried to offer it when they did the depositions of the police officers, it was objected to. So essentially, okay, here's what I'm thinking. Like they're saying the photographic evidence, right, that Amber Heard's team presented with her in their case in chief, and then they introduced that evidence with the pictures. Okay, so what Judge A is saying is that, but they tried to offer it earlier when they did the depositions of the police officers, and so what she's saying is like when those pictures initially were going to come in, at that point, Johnny Depp's team objected to it during the depositions of the police officers, and then it came in during their defensive case. Which is when Amber was on the stand. So what I'm wondering, this is the thing that I was wondering, is that, well, I don't know, maybe not. Maybe it's actually not even checkers, because maybe this is just they fucked up and didn't properly designate Neumeister and Collins. But let's just say for the sake of what I was going to talk about, is that let's say that they really wanted to get them in and they didn't really have a good way to do it, and it wasn't just that they forgot to designate them. Let's just say that it was like there wasn't a clear path for it or something. Like, I'm wondering if the reason they Depp's team objected to the pictures coming in with the pictures with the depositions of the police officers, if they objected to it then, but then allowed it in later when Amber Heard was on the stand. I'm wondering if that was on purpose, so that then they could make this argument later, aka now, to say that this testimony for these rebuttal witnesses should be allowed because of when that evidence came in. The evidence being the pictures. That's what I'm wondering. Like, I'm wondering, because this is what Judge A is kind of pointing out. She's like, well, you guys objected to it then. And then they let it in later, so. Because he says, like, and then it came in. I don't remember them. Okay, here's what happened. Yeah, so she's like, and then it came in during their defensive case, like, well, why did it come in? Well, it came in because you guys let it in, right? Like, no one else is, like, it's up to the other side to object, right? So, like, if Johnny Depp's team doesn't object, it's going to come in. Now, they objected, but they objected only to the metadata. That was it. And I remember thinking every time, like, yeah, they just let they wanted those pictures to come. I think they wanted those pictures to come in because they knew that they could actually use it to their advantage. However, if that's the case, then that's why it is interesting that they didn't want the pictures in at this other time, right? Because the only reason that you could think of, again, unless it was just they made a mistake, would be if it was either, I don't know, someone else would have to weigh in on what type of board game situation we're working with here, if this is the case. But unless it was a mistake, then it would have been on purpose so that they could get this rebuttal testimony in. And they would only be able to do that if those pictures came in during the defensive case, aka Amber being on the stand. Okay, that was the little scroll tangent for that part. Okay. And so we are now offering, which trials are fluid. We can't anticipate when or if certain evidence will come in. See, again, she's saying that, right? I think she's making an argument, but it's like, I know, and Judge A knows, and I'm sure y'all know, like, because you guys can object. Like, in other words, like, like, and yeah, they only objected to the metadata. They just wanted that redacted off the pictures. So it's not like the pictures just waltzed on in on their own, right? Anyway. Yeah, see, look at, I can kind of see, I feel like she's actually making it almost a bit obvious because she's really kind of hammering this point, and this point is actually kind of, I feel like, I don't know. Photographs only came in during their defensive case. Well, you see what I'm saying? They're like, yeah, because you guys objected to it earlier. I'm glad Judge A pointed that out. Photographs only came in during their defensive case, as well as Mr. Heard's testimony about how those injuries occurred. And so now, after their defensive case, the testimony of Mr. See, look, maybe I did call it. The testimony of Mr. Neumeister and Dr. Collins has now become relevant based off of the evidence that they put in. And we submit that those experts, because we designated them at the first available date, we have designated what they intended to testify about at that time, and then we incorporated by a reference that testimony that they would respond to any photographic evidence and any purported injuries. Interesting. We identified that when we submitted the experts for our rebuttal case, as well as identifying them to rebut to certain experts if they put them up. But we identified them as rebuttal witnesses who could. So she's saying that the way that they were identified was actually not for a specific witness, but about the content. That it's about what they can test. And I don't know if this is a thing, but this is what they're trying. We identified them as rebuttal witnesses who could testify about photographic evidence and other injuries that only came in during their defensive case. So we submit that that's proper and fair to permit them to testify. Mr. Rottenborn, this is interesting. I don't have anything to add to my arguments from this morning, Your Honor, unless you have any questions. Weird. That's weird. That's weird. In my opinion, the court. So they're saying since they incorporate, she's like, do I need to repeat this? Because why aren't you arguing something? Like Rottenborn's always trying to argue something. So they're saying since they incorporated as their expert designated for their case in chief that the evidence came up about photographs in your case, and therefore they could bring an expert in to talk about the photograph is, I believe, their argument. She's giving him another shot, Mr. Rottenborn. Okay. They could have put up. So I guess he's taking a bite at the apple, as they say. They could have put up the experts on in their case in chief. They obviously objected, as Your Honor pointed out. Well, I agree. This is what I was saying. They objected to get, as Your Honor pointed out, to our attempt to get pictures in, and for all the reasons that we discussed this morning, and that Your Honor ruled, they're going backward. The court, Mr. Murphy, do you want to? Oh, Mr. Murphy again. Do you want to? This is your motion, so Mr. Murphy. Yes, absolutely. Your Honor, Mr. Neumeister, Your Honor, the exact argument on Mr. Bercovici, I have the transcript, was that the expert was here to rebut the facts. And Your Honor said no, experts essentially rebut experts. Now they're trying to say exactly what they argued against. I mean, yeah, I have to say I tend to agree with them here. Their expert is here to rebut the facts. This is a complete contradiction of Bercovici from my understanding of it looking at the transcript. Court. Well, Bercovici was just a rebuttal expert. What they're saying, the difference is, so I want to go through this, is that they actually had him designated also in their case in chief. Okay, let's see. Mr. Murphy, they did, and they didn't call him. They also could have called Ms. Hurd in their case in chief and put in the photographs, and they chose not to, and that's again their choice. So there's no reason they can now put on an expert to rebut the factual testimony when he wasn't identified in the disclosure, and the rebuttal disclosure says he's here over and over again to rebut Ms. Ackert, who has not yet testified. I don't know who that is. The court, well, no, it also says it incorporates the case in chief, Mr. Murphy, in the line above that. But Your Honor, if you can just incorporates everything previously in the case into every expert disclosure, it would just defeat the purpose. I mean, I agree with this argument. It would just defeat the purpose of what the specific testimony is and the specific disclosures and the specific parts of the case. I mean, and part of, this makes sense because what do we hear? When these experts are on the stand and people are objecting over and over again, it's beyond the scope, a lot of the time anyway, it's beyond the scope of their designation, right? Or the scope of their disclosure. There's certain things they have agreed they can talk about, and this is what they're doing. It's very clear. So this makes sense to me. I mean, Mr. Rottenborn said Your Honor ruled on this morning, and we're now trying to go backward. I agree. The court, well, I want to make sure we get it right, Ms. Brown. The incorporation, she didn't muck it up. The incorporation, if you recall, Your Honor, didn't let me have Dr. Hughes testify on things that we incorporated by reference into the designation for her testimony. Ms. Myers, so Your Honor, a couple of things. We can't be punished for not calling the defendant in our case in chief. The reason we objected to those pictures were foundational because there had not been a foundation laid for these photographs. And as you know, as we saw, some of these photographs actually did end up coming in for various reasons. So these experts truly only became relevant. Look, we couldn't have anticipated that. We identified them just in case. Okay? I mean, she's trying. We identified them just in case these, I'm sure that's supposed to say photographs, not paragraphs. These photographs did come in that that testimony did come in our case in chief, and it did not. And then on the defendants, they offered it. I think that, an expert can be called to rebut factual evidence. The court, does anybody have case law for me? Any case law? Yeah, that would be great, guys. Someone give her some case law. Ms. Myers, we looked very hard. There's not a clear case law on this either way. The court, there's a reason for that. Mr. Rottenborn, they clearly knew they could have designated and called the experts in their case in chief because they put them in their January designations. The court designated them in their defense, Mr. Rottenborn, but they didn't, Ms. Myers. This is all rebuttal case. We're offering these not as a defense witness, but we're rebutting the court. If you're offering them as rebuttal, then they don't testify. Yeah, I don't think it's going to come. It's not going to come in, I don't think. Ms. Myers, well, we are offering them to rebut evidence that came in during their case in their defensive case. The court, all the case law I've ever read says you can't use an expert to rebut lay witness testimony. Ms. Myers, but it's not just lay witness testimony. We're rebutting fact, documentary, and photographic evidence. The court, that came in through lay witnesses, right? Ms. Myers, yeah, but I think that, again, I think the rule cannot be that an expert can't be called unless they're rebutting another expert. I think it has the court. I'll tell you what, I'll give you until lunch. This is fair. This is fair. And plus, I want to see this case law if it exists. I'll tell you what, I'll give you until lunchtime to find me some case that says in rebuttal an expert can testify even though an expert did not testify in direct. All right, I'll give them a chance to give me the case law. Let's see it. Let's see the case law. Mr. Rottenborn, at some point, we just need to move on. The court, I'm giving them an hour and then we'll move on. Okay, Mr. Rottenborn? So we'll give you until lunchtime, which I guess will be around, I'm not really sure. Who's up next? Ms. Myers, if we cannot call Dr. Collins, then I think we'll call Mr. Depp at this time. The court will do that. So we're near the end. We're probably not going to have testimony tomorrow. Is that what we're thinking, even if you get these witnesses in? Ms. Vasquez, so there is another issue, Your Honor. Oh, God. Our expert, Dr. Gilbert, who was rebutting and was designated just to rebut Dr. Moore, the hand surgeon, he can only testify in person tomorrow. The court, okay. Ms. Vasquez, he's scheduled to fly this evening. The court, well, I don't think the jury has any problems with me releasing them early. We can work on jury instructions if that's the case. Were you planning on any rebuttal on evidence? Ms. Fredoff, yes, Your Honor. We're planning on calling Dr. Hughes. I never heard. God, I forgot about this. That's it, and both are relatively short. I don't know why she's getting an accent now. It just happens. The court, is there any way, well, I guess it'll depend on this issue. Ms. Myers, and Your Honor, if I may, and Ms. Vasquez just reminded me of this, I do believe, especially with respect to Dr. Collins, her testimony is rebutting the evidence that came in from Dr. Moore, who testified about Mr. Depp's finger injury, and that was designated in her affirmative disclosure. The court, okay? Mr. Rottenborn, no, I'll wait, Ms. Myers. And I believe that she could also be designated to come. I think she's also rebutting the testimony from Dr. Hughes that Ms. Heard's injuries resulting from IPV were more severe than Mr. Depp's, and she testified to the severity of the injury. So I think that was, those types of information were disclosed in our affirmative designations and identified in rebuttal, which under Your Honor's ruling can be offered to rebut expert testimony. Mr. Rottenborn, a couple of things, Your Honor. She's designated to rebut the opinions of Dr. Jordan, Ms. Myers, but she's also designated, her original designations are also incorporated by reference. Mr. Rottenborn, if I may finish, Your Honor, Ms. Myers, on rebuttal. So they're talking over each other. This is a really long sidebar. I'll have to see if this is, because so far, the longest and most sidebars, both the frequency and longest of sidebars this whole trial so far had been day 22, aka yesterday, trial time. I'm wondering, though, if this might actually be longer than the longest one from yesterday. I'll have to see. Mr. Rottenborn, if I may finish, Your Honor, Ms. Myers, on rebuttal. Mr. Rottenborn, Dr. Moore was not designated until February. Ms. Myers just told you that she was designated to rebut the opinions of Dr. Moore, and that's not true. Ms. Myers, I did not. I did not say that. I did not. If you guys get that reference, then that's awesome. Mr. Rottenborn, you did just say that she was designated to rebut the opinion of Dr. Jordan. I have her testimony where I asked her, are you rebutting the testimony of Dr. Moore? And she says, no. I want to. I can get it from the outline. Ms. Vasquez, if I may, Your Honor, just briefly be heard. I'll wait. The court, yes, wait. Ms. Vasquez, if I may briefly be heard on that point. The court, Ms. Vasquez, she, in her affirmative designations, Dr. Collins opined as to the cause of the finger injury. The court, okay. Mr. Rottenborn, here's page 87. The court, I have to go by the designations. You understand that. Ms. Vasquez, we do. The court, again, we're not getting reversible error in this case. Ms. Vasquez, we understand, Your Honor. The court, I'll read the designations to the rule. Mr. Rottenborn, just because they told you that she was rebutting Dr. Moore's testimony, please just read that. The court, you're not offering any expert opinion in reaction to or in rebuttal to Dr. Moore's opinion, correct? Correct. Ms. Myers, okay, so Your Honor, I think, the court, that's the deposition. Ms. Myers, I understand that. Your Honor, I think the point is that we identified her. Ms. Myers is just really trying to get these in. Your Honor, I think the point is that we identified what her testimony from her affirmative designations as potential rebuttal evidence, and we could not have known whether Dr. Moore was coming in. Her testimony, she's not rebutting more specifically, and she won't opine onto any of his things, but her testimony about the finger injury is explanatory or, rebuts what Dr. Moore testified to. The court, that needs to be designated. I have to go by the designations. Okay, Ms. Myers, I understand. The court, so that was clear. Now, if you want to find me something, yeah, get that case law. Fine, let's see it. If you want to find me something in the next hour on Mr. Neumeister, we'll take that up. Ms. Myers, well, I think the case law that you asked us to look for is whether an expert can be offered to rebut factual evidence that didn't necessarily come in through an expert witness. The court, right? Ms. Myers, we will look for that. Yay! Because that would apply to both of them. Mr. Rottenborn, I would disagree that that's the only issue. We can see what they come up with, but we still think there's the initial rebuttal things. As Your Honor will remember with Mr. Bercovici, he said I'll testify in rebuttal to Mr. Frost, and there was a comma. Right, I remember the Oxford comma thing. That was from 2 days ago, maybe, trial time. And he said, the court, Oxford comma, keep reading. There it is, Mr. Rottenborn. I'm not going backwards on that. I'm just saying that was something that was designated. I remember that whole thing with Oxford comma. The court, well, he was just designated as a rebuttal expert. I think this is apples and oranges, but I've never seen, and I don't want to create reversible error, I just have never seen an expert rebut lay testimony. Mr. Rottenborn, particularly when they have Mr. Rottenborn, particularly when they have the opportunity, when they designate it, it's like, you don't need that, just stop. Judge A knows, the court, and I even took the metadata out of it, so there's not even any metadata in the evidence, Ms. Myers. I understand that. I think, particularly with respect to Dr. Collins, it's not so much that she's not responding to lay testimony, she's providing an expert opinion to explain the factual evidence that came in during the defense's case. Yeah, I was just going to say, that's even worse, the court, that's a no for sure. So if you want, Mr. Chu, Your Honor, may we have until 1 since we have an argument at 12? The court, okay. Ms. Bredoff, Your Honor, we have all our experts and we are releasing them all. The court, excuse me, you're releasing, you have Dr. Ackert here. I can only give you until noon. Mr. Chu, what's that, Your Honor? The court, yeah, I can only give you until noon to see what you can find, okay? Right, because they've got to do the TMZ thing. I don't think there's going to be much there. She's like thinking you're not going to need extra time because, yeah, good luck finding stuff. Mr. Rottenborn, thank you, Your Honor. The court, I'm not creating reversible error. You have to understand this, Ms. Vasquez. We do understand that. The only point I'll make is that I don't understand that how a party can designate a rebuttal witness, the court, rebuttal expert. Ms. Vasquez, a rebuttal expert witness only to testify if the defense puts on an expert. The court, that's what rebuttal experts are in Virginia. Ms. Vasquez, I understand, but we'll find the case law, I hope. Fingers crossed. Thank you, Your Honor. Mr. Chu, thank you, Your Honor. Mr. Rottenborn, thank you, Your Honor. Back to open court.
Well, they're up at the bench addressing something. Look at the judge. The judge is like, girl, tell me more.
Mr. Depp.
Okay.
They're calling Mr. Depp to the stand. I have to go to the restroom. Why are you doing this to me? That's happening.
So just a reminder, you're still under oath, okay?
Yes, ma'am.
All right, thank you, sir.
Did he just say good morning to the jury? I think he did.
Good morning, Mr. Depp.
Good morning.
We heard a lot about some statements that Mr. Waldman made. Do you remember that?
Yes.
And Mr. Waldman is your attorney or was your attorney?
Yes.
Could we please pull up Defendant's Exhibit 1245?
And they shouldn't get into anything else he said. This should be kind of limited here.
This is already in evidence, so permission to please.
Yes.
Rottenborn's cross will be interesting.
If we could scroll down to the second page.
Wow.
Mr. Depp, do you see the statement here attributed to Mr. Waldman?
Yes, I do.
When's the first time that you saw this statement?
Going to the counterclaim.
All right.
You just approached for fucking ever.
Oh, the sidebars in trial are frightful, but Judge A is so delightful. The court. Is this going to attorney-client, Mr. Rottenborn? It sure is, yep. They refused to let him answer, Ms. Myers. This question was never answered, never asked, and it was never answered. There was no attorney-client privilege asserted to this specific question, never asked, Mr. Rottenborn. This question still goes into the argument of whether or not Mr. Depp had authorized Mr. Waldman, and they didn't let him answer any questions on that. So I think even going to this is inappropriate, Ms. Myers. This question was never asked, Your Honor, and certain questions he did answer. He answered when the court. I believe the motion in limine was any question that he asserted attorney-client privilege will not be elicited at trial, Mr. Rottenborn. I think it goes broader than that to the subject matter. The court. That's not what the motion in limine said, was it, Mr. Rottenborn? No, I'm not representing that. I'm saying my argument here is that it shouldn't have to be phrased the exact same way for it to go to subject matter. The court. They're not going to change just an and or a to, but it's a different question. We can go from there, Mr. Rottenborn. All right. The court. He didn't assert attorney-client privilege for it. Mr. Rottenborn, okay. I'll be at the ready. Got it, everybody? Mr. Rottenborn's going to be on the ready. Good to know. The court, okay. Back to open court.
Mr. Depp, when is the first time that you saw this statement by Mr. Waldman?
We'll get there.
The first time that I ever saw this statement was in August. It was when the piece was August 2020, when I was countersued by Ms. Heard. This is the first time that I saw any of these statements.
So when he was
Please
sued.
pull up Defendant's Exhibit 1246.
This is a reminder of what these statements are, I'm
And this
guessing.
is also already in evidence. Thank you. If we could scroll down to the second page, or the third perhaps. Thank you. Mr. Depp, do you see this statement that's attributed to Mr. Waldman here?
I do.
And when is the first time that you saw these statements?
Same, when the countersuit was filed.
Mr. Depp, do you recall Ms. Heard testifying that you did not assist her in getting her role in Aquaman?
Yes, I do, yes.
And what is your response to that?
Oh, shit.
It's not exactly true.
What do you understand happened after Ms. Heard auditioned for Aquaman?
After Ms. Heard's audition, or possibly auditions, for Warner Brothers and I suppose the creative team, Ms. Heard expressed to me that the film was going to be, Warner Brothers had said that the film was going to be shooting in Australia.
Y'all, I will be right back.
And Australia was for Ms. Heard, that was a potential problem, which...
Objection, Your Honor. We approach.
Okay.
Mr. Rottenborn, objection, Your Honor. May we approach? The court okay? Sidebar time, sidebars all the way. The court, yes. Mr. Rottenborn, I don't know where he's going to go with this testimony on the problem, but if he's going to talk about the dog issue and the visas in Australia, Your Honor has already made a couple rulings, I believe, in this case that's a collateral issue. That's something that's not coming in the court. At the motion in limine, I said I wouldn't allow it in testimony, but then Ms. Bredehoft, in her opening statements, kind of threw everything out. Well done, Elaine. Mr. Rottenborn, about an Australia dog? The court, about the dog poop in Australia. Mr. Rottenborn, no, that's a different dog. The court, oh, that's different. Mr. Rottenborn, she addressed the dog poop on the bed. Believe me, I wish that hadn't. The court, yes, okay. So you're just talking about the dog getting into Australia. Mr. Rottenborn, Ms. Heard and Mr. Depp had brought dogs to Australia. The court, right, I understand that, Mr. Rottenborn, but that, Your Honor, has been kept out, Ms. Myers. So, Your Honor, I assure you that he understands that he cannot, Mr. Rottenborn. He just said, Ms. Myers, yes, he understands he can't reference, like, the legal issue. He's going to say there's an issue generally, Mr. Rottenborn. He just testified that there's a problem with her getting in Australia. That goes over the line, Ms. Myers. I don't believe that that's true, Your Honor. I understood Your Honor's ruling. We tried to get in the fact of her pleading guilty to the false form issue, and we understand that that's the court. He's saying there were problems. What else is he going to say, Ms. Myers? He is just explaining that because there was a problem, he was asked to intercede with Warner Brothers. The court, was he asked, Ms. Myers, to intercede with Warner Brothers? I assure you that he's not going to touch the specific issue at all. The court, intercede with Warner Brothers? I have no idea what that means. Yeah, me either. Mr. Rottenborn, I have no idea what that means either. That makes three of us. Even just saying there was a problem, I think that runs afoul. The court, I think saying there was a problem is fine. We're not going into what the problems, I guess that should be were or not was, or anything about Ms. Heard. Ms. Myers, yes, Your Honor. The court, okay, that's fine, Mr. Rottenborn. And then there's, okay, if he was asked to intercede, the court with Warner Brothers, Mr. Rottenborn, who is he going to testify he was asked by other than Ms. Heard, Ms. Myers, Amber? He's just saying that Ms. Heard, my understanding is he got this information from Ms. Heard, which wouldn't be hearsay as it's a statement of a party opponent. Mr. Rottenborn, well, we can take it as it comes. The court, take it one at a time. Mr. Rottenborn, okay, appreciate it. Back to open court.
Mr. Depp, could you please continue? What happened after Miss Heard auditioned for
gets weird
Aquaman?
about the no words. Thank you.
I was informed by Miss Heard that the film was going to be.
I'm going to answer this at the next break.
Shooting in Australia, and that was of concern to her, and because it was of concern to Warner Brothers. She asked me if I would speak to them. I made a phone call and I spoke to.
Objection, hearsay, Your Honor.
I don't believe he said anything. I think he was going to say who he spoke to.
All right, we'll see. Overruled at this point.
I spoke to the three upper echelon Warner executives, Kevin Tsujihara, Sue Kroll, and Greg Silverstein. And I told them that.
Objection, Your Honor. Hearsay.
All right, I'll sustain the objection. Next question.
What was the result of you speaking with those individuals?
Well, I can only say that ultimately she did get the job in the film.
How many times have you done MDMA in your life, Mr. Depp?
Actually, not that many times. I would say in my lifetime, maybe in my lifetime, MDMA 6, 7, maybe.
Have you ever consumed 8 to 10 MDMA pills at once?
No, ma'am. No, I have not.
And why is that?
Because I don't want to die.
Because I'd be dead. I'm pretty sure I'd be dead.
And what did Dr. Kipper do when he first arrived at the home?
Oh, the first thing he wanted to do is inspect the damage of my finger.
I imagine.
And try and figure out exactly what had happened, how it happened.
And what did you tell Dr. Kipper about how your finger had been injured?
Objection, Your Honor.
May we approach?
Hearsay. We've discussed this several times.
Oh, there's no place like trial for the holidays. With a sidebar. Miss Myers, Your Honor, when they crossed Mr. Depp, they impeached him multiple times with prior inconsistent statements about the loss of his fingers. They showed him multiple text messages where they intimated that he was suggesting he had cut it off himself. There is a prior consistent statement, Mr. Ronborn. This is no different from Ms. Heard's prior consistent statement that we argued, and Your Honor didn't let it in about the abuse and certain times when she told her doctors that she had been abused at certain times. Your Honor will remember in the designation argument on Dr. Kipper, Your Honor, goodness gracious me, that's a lot of Your Honors. Your Honor will remember in the designation argument on Dr. Kipper, Your Honor limited this, and I understand the argument is, well, they've attacked this, so now we get to use it. To be consistent, Your Honor, Your Honors kept out Ms. Heard's reports to her medical providers of abuse. Okay, let's see. This is a fun game. How many times in this one paragraph does he say Your Honor? 1, 2, 3, 4, 5, 6. Okay. Now we know. The court, you were putting your points in evidence, Mr. Ronborn. I'm sorry. The court, you were putting those points into evidence at that point, Mr. Ronborn. No, even letting her testify that she had told contemporaneous, consistent statements, consistent reports of abuse after certain incidents, Your Honor has kept out. If Your Honor lets this in, tomorrow's examination of Ms. Heard goes way longer because, in my mind, I'm thinking there's no way because you don't have time. Oh, the court, you have 2 hours. Yeah. Mr. Ronborn, yeah, thank goodness. What? Ms. Myers, may I? The court, you're not getting it into evidence. You're just asking him about it. Ms. Myers, well, Your Honor, first of all, I think that they tried to get Ms. Heard's prior consistent statements in on her direct testimony, and I believe on the redirect, you actually allowed her to say what she told Nurse Borum? I have no idea. under the theory that it was a prior consistent statement. This is the exact same principle. He's been impeached with a prior inconsistent statement, and we're offering what he told Dr. Kipper as a prior consistent statement. The court, tomorrow the roles will be reversed. Mr. Rumborn, right. The court, so I'll overrule the objection. Mr. Rumborn, okay. The court, you can handle it on rebuttal. Mr. Rumborn, okay, all right. Okay, all right, now ladies, yeah. What is it after that? You know, you guys know. The court, thanks, back to open court.
Over-explain myself.
Mr. Depp, when Dr. Kipper was treating your finger, what did you tell him about how your finger became injured?
Because this has already come in.
I told him that she had thrown a bottle of vodka and smashed and cut my finger off.
This is coming in because there are prior statements that have already come in.
But a good chunk.
Prior statements that have come in about how the finger
Mr. Depp, you heard
injured.
Ms. Heard testify
About
the way he
said I
alleged
miss it.
incident of abuse on your honeymoon. Do you remember that?
I remember her testifying to that, yes.
And where did you and Ms. Heard go on your honeymoon?
We took the Orient Express from Bangkok, Thailand to Singapore.
That sounds amazing. So obviously he's been to Singapore.
What happened while you and Ms. Heard were together on the
Also
Orient
a good
Express?
episode of Doctor Who.
I don't remember it lasting long at all. I just remember that I took a pretty good shot to the face, to the eye, to somewhere up here. So I had a bit of a shiner. But
They did talk about hand dominance in his direct examination.
Got fine again, and we'd go to dinner, and it was all.
They're probably not going to talk about it again because they already.
Did Ms. Heard ever apologize to you for giving you the shiner?
I don't recall.
Can we please pull up Plaintiff's Exhibit 162, which is already in evidence?
I believe that's the photo.
Mr. Depp, do you recognize this photograph?
The jury will deliberate as long as they
It was with the chef and the maitre d' and the staff were asking if they could take a photo with us, and they'd been very kind.
And what, if any, injuries do you have in this photograph?
I think the eye's a little bit bugged out, if you will.
How did that happen?
These things could happen very quickly if you disagreed.
Objection, Your Honor, non-responsive. She just asked, how did that happen?
I believe he was about to explain.
Well, I'll state the objection.
Okay. So, Mr. Depp, specifically, how did the injury in this photograph occur?
I'm sure it hit me. Is that better?
Don't snap at Rottenborn.
Does this picture accurately reflect what you looked like?
I mean,
on
or
that
two
date?
at this point. I don't know.
I don't look at myself much, but it certainly looks like me with a black eye. Yeah.
Does this picture appear to have been photoshopped in any way?
No, I think no.
I might have objected to that if I was Rottenborn.
To start getting into sort of digital processing with a number of people in the shot, especially in a wide shot.
How do you know that?
Could we please pull up Plaintiff's Exhibit 1301? And this is the new one, Your Honor, so this is not in evidence.
Okay, thank you.
Oh, new things. New things. We're still getting new things. The digital
Mr. Depp,
expert
do
is
you
still on
recognize
deck.
what's reflected in this photograph?
Digital expert is still on deck.
Yes, this is the staff. It's the manager and his staff at the Raffles Hotel in Singapore. And before we left, they asked if they could take a photograph with us.
I'm not surprised by that.
And when was this photograph taken?
Well, that would have been, we were off the Orient Express. We stayed in Raffles, I believe, a couple of days, few days. And then from there we flew to San Francisco.
There's a digital expert.
So this
on the
photograph was
witness list.
taken after the photograph we just looked at?
This photograph was taken after the photograph in the dining car of the train, yes.
Mr. Depp, what, if any, injuries do you see on your face in this photograph?
I see pretty much the same. I see that the area in here has been
Mr. Depp,
is
did you have any amica
swollen
cream?
and yeah, there's a bit of a shiner there.
It looks like he has a black eye.
Thank you. We can take this down.
I mean, it did look like he had a black eye.
Mr. Depp, do you recall Ms. Heard testifying that she punched you in the staircase incident because she thought of Kate Moss in the stairs?
I remember.
Do I remember her saying that?
Yes.
Yes,
I remember
do.
her saying
3
that.
times. Yes, I do.
Do you have any understanding as to what Ms. Heard was referring to?
Yes, I do.
And
as Kate Moss, Kate testified.
He'll call Kate Moss
many,
by
many
her
years
first
ago.
name. He called Kate Moss by her
exactly
first name and then added her last name.
happens-
Interesting.
What she said happened. I recall speaking with Ms. Heard about that very incident because of the downpouring of rain, because it was raining very heavily that day that Kate slipped. And I recalled the story to her.
Objection, Your Honor. Hearsay.
He didn't say what he said.
Okay.
He didn't say what he said.
Sidebar night. Oh my god. I'm becoming delirious reading these sidebars. It's beginning to look a lot like sidebars. I might have already done that one as well. Okay, Miss Myers, Your Honor, this goes to Miss Heard's knowledge. It's not being offered for the truth, but the fact that he told it to her, and she testified that she implied very strongly that Mr. Depp had thrown Miss Moss down the stairs. Oh, yeah. And if she knew that that was not true, that's certainly relevant to assessing her credibility, Mr. Umborn. She didn't imply that at all. You just saw testimony this morning. She said she heard rumors that happened, and that went through her head. The court, I'll overrule the objection, Mr. Umborn. Okay, back to the court.
Where I think they're going with this is that what did Amber Heard know when she testified about the stairs? And that's going to be important because what she knows in testifying about the stairs is going to come from what he told her. So to see from what he told her to what she testified to is interesting. Heard does not have an opportunity to get back on the stand here. This is Depp's rebuttal case, and this is only cross-examination.
Please continue,
Mr.
Depp. What did you tell Ms. Heard about
and
the
whatever
staircase,
they
or
approached
Kate
about,
Moss?
the court
I'll make it
overruled.
easy for Mr. Roddenborn. Miss Heard took the story and turned it into a very ugly incident, all in her mind. There was never a moment where I pushed Kate down any set of stairs, yet she's spewed this 3 times before.
Wow.
Objection, Your Honor. Miss Heard simply testified that she had heard a rumor. And
Rottenborn, you don't
What's
get
the
to
rumor?
testify, man.
Sir, hold on. This
Sorry.
objection. I'll overrule the objection.
misstates the facts and evidence.
Overrule the objection.
Sorry, I was drawn by Mr. Rottenborn's voice. What was you like? What was it?
Yeah, what's the question?
So what specifically had you actually told Ms. Heard about the incident with Miss Moss and the stairs?
Very simply that we were in Jamaica. I had left our bungalow about 3 minutes prior to her, I was standing outside, and suddenly rain starts just coming down like it's, a monsoon. And then I remember looking and seeing Kate coming out the door, and there were 3 little.
Chat, you're right. She did not say rumor.
Stairs.
She said, I thought of Kate Moss and the stairs.
And she landed directly on her coccyx and her lower back.
Ouch.
So, and she was obviously physically in pain, and she was hurt. She was crying. So I ran over and grabbed her to make sure she was all right. That's it. That's all I ever. That's the whole story. But then the rumor of it, I'd never heard a rumor of that before Miss Heard
ouch,
grabbed hold of it. It's like that. Sorry.
Mr. Depp, we heard testimony from Miss Heard's sister, Whitney, during this trial. Do you remember that?
Oh, boy.
Yes.
And how would you describe your relationship with Whitney when you were in a relationship with Miss Heard?
Did she teach you to snort cocaine through a tampon applicator? Please ask this very important question to all of us.
Initially, when I first met her, I liked her very much, and grew to love Whitney. Whitney, Amber's sister, Whitney, seemed to always get the sort of dirty end of the stick, and I felt bad for her for that, because it wasn't new. It had been there for life. And that seemed pretty obvious. So I took to Whitney very, very quickly, very easily. She was a very sweet kid. She was wonderful.
Do you recall Mr. Mandel testifying in this case that you do not spend very much money on charity?
That I don't, sorry?
That you do not spend very much money on charity.
I remember that.
Objection, Your Honor.
Why?
Approach.
Okay.
Just hear those sidebars jingling, ring, ting, tingling too. Come on, it's lovely weather for a sidebar together with you. Mr. Rottenborn, this was covered in motions in limine. Miss Myers, Your Honor, they put in testimony in their case in chief for Mr. Mandel where he said Mr. Depp does not spend very much money on charity. I believe that opens the door for him to rebut that. Mr. Rottenborn, I have no objection to that. I don't remember that testimony, but I'm not doubting her. But if that came in, I have no objection to that limited thing. But if he's going to talk about some, the court, is that the only question on this? Mr. Rottenborn, if that's the only question, I have no objection to it. But if they try to go beyond that, I think it runs afoul of the motion. Miss Myers, my question is, what is your response to that? Mr. Rottenborn, that's fine. I have no objection. Back to the court.
Mr. Depp, just to remind you, my question was,
changed.
what is your response to Mr. Mandel's testimony that you do not
rebuttal.
spend very much on charity?
My response to that is Mr. Mandel is a very bitter man. And one thing about that, me, myself personally, with regard to
I hope he talks
charity
work
donations
at kids' hotels or kids' hospitals.
Sending
hotels.
money to a charity. I prefer, I would rather that my name were not on it. I don't want the name to be the important thing or the thing that people talk about. So when I donate money, I donate without my name being involved because I don't see that that's important, my name being there in terms of money. Now, if I am able to visit hospitals,
I was
or
hoping
if
he
I'm
was going to
able
talk about that.
Meet with Make-A-Wish children, I've held on to the relationships that I've held on to within the Make-A-Wish Foundation and the Children's Hospital and various other places. Then obviously my name is involved. When we held premieres in Leicester Square for several films, Charlie and the Chocolate Factory.
Again, beyond the scope of his response to Mr. Mandel's testimony.
I believe this is in response to Mr. Mandel.
I'll overrule the
It
objection.
is in response to charitable giving,
Basically,
charitable work.
When it was a public, let's call it donation or whatever, I would talk to the studio. I would talk to Disney. I would talk to Warner Brothers. I would talk to whoever the studio was well before the premiere and make the premiere a benefit that would, once we did what we benefited, we did a benefit premiere for Great Ormond Street Hospital. We did a couple of benefit premieres for the Make-A-Wish Foundation.
I didn't know that.
I mean, if you can turn a premiere with that many thousands and thousands and thousands of people there into a benefit, it works and it helps. But it wasn't presented under my name. You know, it was Disney's doing this or Warner Brothers is doing this. I'm not looking for the pat on the back, as it were. If I can make it happen, great. But I don't need the pat on the back. I don't need the adulation. I don't need the attention.
I don't need the attention.
Did you hear Ms. Heard testify that one of the
How very
charities she
narcissistic.
donated a portion of
Sarcasm.
your divorce settlement to was the Children's Hospital of Los Angeles?
Yes.
What is your relationship
I didn't
with
know
CHLA?
that he had done that with the premieres at all.
Objection, Your Honor. Irrelevant to the
May
issue
we
we
approach
discussed.
Your Honor?
It's not irrelevant. I don't think it's irrelevant.
Sidebar. Ms. Myers, Your Honor, this is a different rebuttal point. This is Mr. Depp had a previous relationship with the CHLA when Ms. Heard selected that as one of the places to make a donation. And I think we saw her statement about the donation when he donated the money to CHLA. She said this was a newfound interest in the charity, Mr. Rottenborn. That's really an attenuated attempt to rebuttal. It's not relevant. The court, well, she testified, Mr. Rottenborn, it's not relevant. And also they brought that out on cross-examination of her, first of all. They brought out that statement, didn't they? I believe it was during a cross of Ms. Heard. Ms. Myers, the CHLA came in on her direct, though. Mr. Rottenborn understood, but the statement where Ms. Myers is referring to, I believe, came in on Ms. Vasquez's cross. I'm not going to say I'm 100% certain of that, but I believe it did. Number two, this is kind of what we've been afraid of this whole time, which is they're going to talk about him going into the CHLA in pirate costumes, and you've heard Mr. Chu talk about how she doesn't care about sick kids and all that nonsense. It's totally unrelated. They're going to try to get to, have him say that he marches around in a pirate costume. Well, I mean, facts. That's so far beyond the scope of rebuttal. The court, I haven't heard any of that testimony yet. There was evidence in your examination about these issues. I'll allow. Mr. Rottenborn, there's evidence about what? Her donating to the CHLA. The court, she's saying that when he made his donation in the area, that's how it was made, something along those lines. Mr. Rottenborn, I guess if it's going to be like, hey, I gave to the CHLA in the past, that's fine. But if he's going to talk about walking around in pirate costumes and what a great guy he is with respect to CHLA, I think that goes beyond the scope of any sort of impeachment. Ms. Myers, Your Honor, I would also note that in Ms. Heard's affirmative testimony, she did testify about, in her youth, volunteering at soup kitchens. This is really, if they're going to bring this to bolster her character, the court, that's not allowed. Ms. Myers, I understand. The court, I'll allow that question. Ms. Myers, okay, understood. Mr. Rottenborn, thank you.
It's very interesting to see what's going on with this rebuttal case. The problem for Team Heard right now is that this clock is ticking. We heard Elaine Bredehoff say it this morning with Dr. Curry. We're on strict time to get this case to the jury. No, Elaine, this case goes to the jury Friday. You have substantially less time left than Team Depp. Team Depp had a 10-hour witness time advantage going into this morning. And, time is only strict for Team Heard right now, not for Team Depp. So that is
Mr.
where
Depp,
we're
what
at.
is your relationship with the CHLA?
And they won another sidebar because now it's coming up. Let him talk about it.
I've had a relationship with the CHLA for probably 20 years or so.
We're going to have to do a fundraising stream
What's
soon
just
for
the
this.
nature of that relationship?
Well, since sometimes there are Make-A-Wish kids
no BFF necklace
who are in the hospital there, and that their wish is to
meet
Objection, Your Honor.
Jack's parents.
Your Honor, may we approach?
Okay.
I imagine that they just talked about it.
During this sidebar, Miss Myers did say, Miss Myers, Your Honor, Mr. Rumborn, this is why Miss Myers, this is his relationship with the CHLA. I mean, this is how the court, you can ask limited questions. That's the rebuttal part. Miss Myers, okay, court, 20 years. Now let's move on, Mr. Rumborn. That's kind of the problem with the limited question with him, is she can say what happened, and we all know where his testimony is going. The court, we're working on one question at a time, Mr. Rumborn. All right, Miss Myers, if I may. The court, okay. Miss Myers, in anticipation. The court, I appreciate that. Miss Myers, I was going to ask whether Miss Heard knew about that, the relationship with CHLA. Mr. Rumborn, irrelevant. The court, what would be the relevance of it? Miss Myers, she testified he was not charitable. The court, I'll sustain the objection at this time, okay, Mr. Rumborn? Okay, thank you.
Mr. Depp, what happened at the end of that week on May 27th?
It also came up in direct. It came up
May 27th, my daughter's birthday. May 27th.
And the day of closing arguments this year.
I was not in Los Angeles. I was on the way to on tour, and that was when Miss Heard went for the restraining order. And oh yeah, also that was the day that Alice Through the Looking Glass, a film I'd done, was opening.
Did Miss Heard know that you were out of town on May 27th?
Calls for speculation.
Yes.
How would she have known that?
Did you tell?
Well, I told her I was going on tour. I mean, that was well established.
How long were you going to be out of town on that tour?
2 to 3 months.
And did Miss Heard know how long you'd be out of town?
You would tell your spouse if you were leaving.
I don't know
for
if
2 to
she
3
knew
months.
exactly how long I'd be out of town, but it was a pretty extensive tour of Europe.
How did Miss Heard's actions on May 27th, 2016 affect you?
Changed everything.
Objection, Your Honor.
Oh, it didn't change
in this
everything?
lawsuit.
Sorry.
I'm sorry if you could wait till the objection.
Yes.
Yes, I'm sorry.
Did she call him Heard?
Your Honor, this is one of the key
If you want to
dates.
approach.
Did he say, I'm sorry, Tourette's? Did he say that? I saw it come up. That a lot just happened very quickly.
Here's a sidebar. Here's a sidebar. It's a sidebar. It's a sidebar. Mr. Rottenborn, how they're trying to bootstrap what she said on May 27th into the lawsuit. How what she did on May 27th affected him, that's not relevant, Ms. Myers, Your Honor. This is one of the key dates in this, and this is the date that the allegations essentially came out, and the allegations that we contend were republished in the op-ed that she published in 2018. That op-ed is understood against the backdrop on what happened on May 27th. Mr. Rottenborn, this isn't a republication case, except their theory is that the tweet is republication, but 2018, this is not a republication of 2016. That's not what this case is about. That's not the theory of the case. The law doesn't support that. That's not what the case is about. Ms. Myers, it's her repeating what we contend are false statements she first made 2 years prior to, Mr. Rottenborn. That's exactly the point I was trying to make when I walked up here. That's what they're trying to do. And that's inappropriate. They're trying to get the jury to hold him, Ms. Myers. That's our theory of the case, Your Honor. I think we've made it very clear. Mr. Rottenborn, liable for traditionally immune statements that were made in 2016. Ms. Myers, I think we've made it very clear that the op-ed that is at issue in this case is the defamatory statements are understood in the context of what happened in May of 2016. The court, you need to get to the relevance. The objection is relevance, Mr. Ronborn, right? Because this case is about the statements made in 2018, and it's not a republication case. The jury can't find Ms. Heard liable for statements she made in 2016, and that's exactly what Ms. Myers is trying to get the jury to do through this testimony. So, therefore, how did it affect you is irrelevant. Yeah. That's awesome. Ms. Myers, Your Honor, I think that we've been very clear that what happened in May of 2016, when she made these statements public for the first time, color how the op-ed was understood by people. And I think that what happened on that date, the statements made in 2018 in context with 2016, I mean, that's what I would imagine. That's me talking. Ms. Myers, well, our contention is that people understood the statements in the op-ed to be about Mr. Depp and to imply that he had been physically abusive because there had been a media circus around Ms. Heard's walking into court in May of 2016. Yeah, I mean, that makes sense. The court, right, you can ask those questions. That's not the question you just asked, so I'll sustain the question as to that. Ms. Myers, okay, Mr. Ronborn, I'll also ask that Your Honor consider, I don't want to say it in open court for obvious reasons, but admonishing Mr. Depp for the next time he makes the court, I just did. Mr. Ronborn, oh, okay, I didn't hear that. The court, I did. Mr. Ronborn, I didn't want to say that. Thank you. Back to the court.
What has it been like for you to listen to Ms. Heard's testimony at this trial?
I'm sorry.
What has it been like for you to listen to Ms. Heard's testimony at this trial?
Objection relevance, Your Honor.
It goes to damages.
Overruled.
I'm surprised they don't argue back with him. They don't do speaking objections. I bet you could hear a pin drop in there.
Insane.
Can you expand?
It's insane to hear heinous accusations of violence, sexual violence, that she's attributed to me, that she's accused me of. I don't think anyone enjoys having to split themselves open and tell the truth. But there are times when one just simply has to, because it's gotten out of control. Horrible. Ridiculous, humiliating, ludicrous, painful, savage, unimaginably brutal, cruel, and all false. All false. I wanted no human being is perfect, certainly not. None of us. But I have never in my life committed sexual battery, physical abuse, all these outlandish, outrageous stories of me committing these things and living with it for 6 years and waiting to be able to bring the truth out. So this is not easy for any of us. I know that. But no matter what happens, I did get here and I did tell the truth, and I have spoken up for what I've been carrying on my back reluctantly for 6 years.
Thank you. No further questions.
No further questions.
Do you want to take lunch at this point?
Yep, they sure do want to take lunch at
Let's
this
do that.
point.
All right, ladies and gentlemen, let's go ahead and
They
take
sure the fuck do.
lunch this time. Do not discuss this case with anybody and don't do any outside research, okay?
Depp's
Thank you.
team has been brilliant at leaving these moments at the end that are powerful.
And don't break anything on your way out.
That are memorable and that are almost chilling. Like, I can feel the stillness. I can feel like it made me still. I imagine that it made the courtroom still.
So just a reminder that since you are back on the stand, do not discuss this case with anybody to include
That
your attorneys at
was
this point, okay?
powerful.
If you could just have a seat back there. We do have some other issues to take care of.
Much more emotional
Before we take care
than
of
other testimony in
the
this
third party
case.
motion, can I have
All of you are feeling it.
attorneys come forward on our
We're going to get into the TMZ motion. Do not cut no, don't cut it yet. They haven't approached yet. We need to hear what they're saying. I'm going to throw an absolute tantrum.
Sidebar, the court. All right, did you do research? I want to know where you're at this point. So in rebuttal, oh, here we go. Did they find the case law? I'm so curious. So in rebuttal, designated rebuttal evidence, rebuttal expert in this matter, not just to rebut certain expert, but also all the designations from the case in chief. In the case in chief, were also incorporated. I understand that. The difference I see with Ms. Heard's expert on the police policy was that was just a rebuttal expert designated just to rebut a certain expert who did not testify. And I know you had an argument with that Oxford comma. I just don't agree with the Oxford comma. That's where we are. Looking at this matter, an rebuttal expert cannot testify just to a lay testimony as to witnesses. However, in this case, which I wanted to look into when you brought it up, is that we're talking about photographs and not testimony that came into evidence, and that the expert should be able to opine as to those, to rebut those particular photographs that are in evidence as to their authenticity. So that's where I'm at. Oh, Mr. Murphy's back. May I be heard on that? The court just wanted to let you know where I was. Mr. Murphy. Absolutely, Your Honor. I did research over the past hour. The court, I think we all have. Very good. Mr. Murphy, yes. And what the cases say, Your Honor, is that exactly what Your Honor was saying before. The rebuttal expert is here to testify to an expert opinion. I've got 4 cases holding that backwards, forwards, left, and right. That's a bold statement. The court, right? Okay, Mr. Murphy. So this first one, which is Middle Northern District of California, 1985. How's that authority? I'm sure she'll say something. Middle Northern District of California, 1985, defines a supplemental rebuttal cannot, the court, we can view cases, I found cases in Virginia. See, there you go. Yeah, that doesn't have authority. Mr. Murphy, I wasn't able to find anything in Virginia. Well, Judge A did, apparently. The court, I did. Yeah, I did. Well, Sammy did. I'm sorry, I apologize. I like to incorporate Sammy into my findings. Ms. Brodoft, there's one point here. None of those photographs were objected to when they came into evidence. They all came into evidence, authenticated, and came in. So, okay, that's what I was saying earlier, is that I recall that they were objected to, but they are objected to based on the metadata, and that they were not authenticated. So basically the opposite of what she's saying is what I remember being the case. The court, but Ms. Brodoft, what are they rebutting? Are they now challenging to what was not objected to? The court, no, they're saying they can't do metadata. Yeah. Ms. Brodoft, well, Your Honor didn't let in the metadata. The court, I understand that. Ms. Brodoft, but the photographs, the court, I'm sorry, I let in the dates, and she said this is when it happened. These are different photographs. I mean, Ms. Brodoft, but nobody objected to them when they came in. So the court, I don't think you have to object to them. Now they're in evidence, so an expert can opine as to an issue that will help the jury. Ms. Brodoft, I think they would have had to object to them as inauthentic at the time, Your Honor. One of the things we have asked through discovery and our request for admissions is that they identify any that they claim were not authentic, and they did not do that. Wait, I can't, sometimes I'm just like blown away. Because my understanding is that everything they provided in terms of pictures and shit, they're all not authenticated. All of them. I mean, and actually, didn't they have, I'm pretty sure that's what one of the experts today testified. And maybe this is actually over this one expert. I'm pretty sure that's the point of they're bringing in a dude who's going to testify to that. But we knew that anyway. Oh, my God. And then when we moved for the admission of them, there was no objection whatsoever other than the metadata. Well, yeah, that's what I said. Which came out. I mean, that's true. The court, how come they, Mr. Murphy, I'm sorry, Your Honor, Ms. Brown. So how can they now say, oh, these unobjected to photographs, we're going to object to them now and say they're not authentic? I think that everyone the whole time has said they're not authentic. I don't know how they can do that, and they didn't identify them. David's got a lot of different arguments for I guess David might be Mr. Murphy, for a Neumeister separate than that, but I don't know why you're willing to change, Your Honor, and let him come in to rebut nobody. The court, I still stand. Ms. Bredoff challenged the court. You're challenging everyone, Elaine. I'll say that much. The court, that's a rebuttal witness. That a rebuttal witness can't come in to rebut lay testimony unless somebody gives a medical opinion. Ms. Bredoff, right. The court, right. My knee is sore, and an expert in med mal case can come in and say, well, no, actually, the knee should be whatever. So, Ms. Bredoff, right. My point here is that he's not rebutting anything because nobody challenged it, and these were unobjected to, false. All the photographs came in unobjected to, false. After the metadata came out. I don't even know what to say to that. The court, well, you don't. Rebuttal testimony doesn't have to be challenged. To bring in it doesn't have to be challenged, but it was challenged anyway, but whatever. To bring in rebuttal testimony, you don't have to object to everything. They're rebutting your evidence. Ms. Broft, if they didn't object to it, I don't think they deserve to be able to object. Holy shit. Okay. The court, you're saying if you don't object, you can't bring any rebuttal testimony in? It's like, what rule are you making up now, Elaine? Ms. Broft, to challenge something you didn't object to. It's just ridiculous. It's just, I don't understand. I just don't understand how she's even in the court doing what she's doing. Mr. Murphy, essentially, Your Honor, I understand it as evidence requires authenticity under Rule 9. Whatever it is to be admitted, it was admitted. Therefore, it's been authenticated. Therefore, the authenticity is not an issue. Is what I understand Ms. Bredoff to be arguing. Well, that's what she's arguing. Yeah, you're correct in that. The court, that's the weight of it, right? They can argue the weight of anything in evidence, Mr. Murphy, but that returns to the overall point. Granted, I'm not looking at Virginia case Your Honor has. Yeah, why don't we take a look at the case? Time and time again, in these cases, they talk about rebuttal experts are here to oppose previous expert testimony over and over again in the court. But it doesn't have to be just expert testimony. So I guess what she's found is actually supporting Depp's team's argument. That doesn't just have to be expert testimony. Mr. Murphy, I understand. I don't have the Virginia site, Your Honor, but these cases, Fourth Circuit, it's saying that's exactly what a rebuttal expert does. And actually, not exactly. That's only what a rebuttal expert can do, the court. If they're only designated to rebut a certain expert, I agree with you, Mr. Umborn. What's the Virginia site, Your Honor? Yes, thank you. Can we get to the case law, the court? I have a few of them here. You might be able to get them from Sammy faster, Mr. Umborn. We can get them from Sammy. Ms. Lickrose, we have Greer versus the Commonwealth, Your Honor, the court. Okay, I think mine was Hodges versus Commonwealth. Ms. Vasquez, we have that one as well, I believe so. I've read Hodges versus Commonwealth, Ms. Lickrose. I have Greer here. So in Greer, at trial, after Greer, the defendant rested, the Commonwealth called the 3 experts as rebuttal witnesses. Over Greer's objections, the court allowed the Commonwealth to elicit testimony from the experts that they evaluated Greer at the request of his counsel. We find no merit to Greer's contention that the trial court erred in allowing this testimony. The evidence was relevant because it provided background information about the experts and showed how they became involved in the case. So there, Your Honor, we have Virginia Supreme Court, so that's even better in terms of the authority. We have Virginia Supreme Court saying it was not error to allow experts in rebuttal that had not been called in the case in chief. Mr. Murphy, Your Honor, what I see here is this is talking about relevance. We're talking about an expert disclosure issue, the mechanism of disclosure, and the defined roles of experts. That's a much different issue than a relevance issue. What I see here is the relevance because it provided the court, but they did disclose him as a rebuttal expert, Mr. Murphy, right? But it's talking about relevance, not talking about purpose. The court, I think this is relevance, Mr. Murphy. It doesn't seem like, from what I'm seeing here, Your Honor, that the argument we're having right now was made. So I would say this case is not on point. There isn't any relevance to this testimony. I don't agree with that. Ms. Lickrose, I think that's all we have from Virginia, Your Honor. We do have a District of Colorado case. We didn't have Hodges, I don't think, the court. That was not a Commonwealth case where the expert was DNA, or gave testimony on DNA, Mr. Rottenborn. Your Honor, just to be clear, Your Honor's made the ruling that Dr. Collins is out. Is that correct? The court, that's correct. Ms. Vasquez, she's opining on just pictures as well, Your Honor. The court, no, that's not in the designation. Mr. Rottenborn, Your Honor, she's reviewed pictures, but she's saying Amber's account doesn't match the pictures. That's totally different. Ms. Vasquez, she has reviewed the photographs, the court, but that's just commenting on Ms. Heard's plain testimony. Mr. Romborn, yes. Mr. Murphy, actually her testimony is she opines as to whether the injuries reflected in the photographs aren't consistent with the court. No, I'm going to keep going over that. I'll sustain the objection as to that expert. Mr. Murphy, Your Honor, I recognize this is out of state, but if I can send you one federal case, it really addresses this issue. The court, yes, sir, if you'd like to. Mr. Murphy, so this is Bowles versus, oh, look at that, representing North Carolina. Bowles versus United States Middle District of North Carolina. Literally, quote, rebuttal experts cannot put forth their own theories. They must restrict their testimony to attacking theories offered by the adversary's experts, end quote. Okay, you provided literally no context for that, so I don't, that's exactly what I understood Your Honor's ruling earlier to mean, and that's exactly what we're arguing now. And then on the next page, talks about how they don't address any of the defendant's expert reports. They offer their own theories. And that's exactly what our argument is here, Your Honor, that they could have called Mr. Neumeister in their case in chief, as that's how he was designated. They chose not to do that. They fought against the photographs and our summary of the metadata coming into evidence. They fought against the photographs and our summary of the metadata coming into evidence. Your Honor sustained that objection. And then, additionally, they could have called Ms. Heard, but they chose not to do that, as that is their right. But for them to say they didn't have the opportunity, or I heard earlier the argument that trials are fluid, that came from the judge, sir. That was Judge A. They don't know what evidence is going to come in. I mean, come on, the whole forensic order process, they knew, wow. This dude, I don't know about this dude, man. I don't know about this dude. That was Judge A. I heard earlier the argument that trials are fluid. They don't know what evidence is going to come in. I mean, come on, the whole forensic order process, they knew these photographs were going to come in. They've known that for 5 years. So that argument, I don't think, really holds any sway. And again, it's essentially their expert cannot rebut a fact witness, and I don't see this case holding that. That's essentially what their argument is. I did not find any Virginia law that said an expert witness in rebuttal can rebut a fact witness's testimony. Here's the thing, though. Apparently, your legal research skills maybe, perhaps, are just a little bit wanting, because Sammy / Judge A, they found more than one Virginia case law that addressed this issue, and you didn't find any, so maybe you didn't do that good of a job. Your Honor actually said Ms. Heard cannot testify to the metadata because that's expert testimony. Well, that's, yes, correct there, the court. They're not rebutting a fact witness. They're rebutting photographs themselves, Mr. Murphy. Right. So if Mr. Acker had been called in our defense and said these photographs are authentic, I wouldn't have this argument right now. The court, you can call him in rebuttal. Mr. Murphy, he hasn't been called yet, Your Honor. The court, yes. Mr. Murphy, and I would also point out that Mr. Bercovici actually was designated in the opposition expert disclosure. It just had the language Your Honor said. I'm not trying to revisit that. I'm just trying to point out, yeah, you're trying to go backwards? The court, he was just rebutting that particular. Mr. Murphy, I'm not trying to revisit that ruling. Well, then why did you bring it up? My point is, he was even included in the opposition expert disclosure, whereas Mr. Neumeister isn't mentioned, period, in that opposition expert disclosure. I wanted to point that out as well. The court, they're not using it as opposition. They're using it as rebuttal, Mr. Murphy. So then I'll focus my arguments on rebuttal and this case law. Isn't that what you're supposed to be doing the whole time? And there's no Virginia case law I have found. Again, that's not really saying much because you missed some. And there's no Virginia case law I have found, at least, that said a rebuttal expert can rebut anything but expert testimony. That's their purpose. The court, I understand. I think in this particular case, just the photographs in this limited, it's going to be extremely limited as far as only photographs that are in evidence that he can opine on. There's not going to be talk about any discovery issues, period, general. No software issues, we have that. So it's just literally going to be photographs that are in evidence and his opinions on those photographs. Ms. LaGrose, Your Honor, just so I understand your ruling, because of the way that they entered the photographs into evidence, they submitted them as screen grabs of a photo. Right, of course. So what Mr. Neumeister will testify to are the photographs that underlie the screen grabs, which are not necessarily the trial exhibits. Dang, this is getting complicated, isn't it? Yeah, that's a problem. That's a problem. but they are the underlying photo that is part of the trial exhibit. Ah, God. The court, what is he going to testify to? Ms. Lick-Rose, to issues with the underlying photos and the authenticity and issues with the photo editing applications that the underlying photos, Mr. Murphy, the word screen grab does not appear in the disclosure. I don't even know what they are talking about. They are not screen grabs, Your Honor. Ms. Lick-Rose, you can look at them, Your Honor. They are in our opposition. You can see, and Your Honor obviously dealt with this, the court. He's not going to opine about the ones that are in evidence, Ms. Lick-Rose. He's going to opine about the court. There was no objection about them being screen grabs at the time of the trial, so we're not going to go back to that because they are in evidence as they are. That's probably the right way to handle this. So there is no objection. You could have objected to the authenticity of them being screen grabs, right? That'd be a whole different issue. I would have addressed that issue, but now you can't just let them in evidence and then say, oh, well, now those are screen grabs. I can't do that. Ms. Vasquez, Your Honor, may I just be heard on that one point? I believe I called them screenshots, not screen grabs, when I objected because the metadata, the court, we dealt with that. Ms. Vasquez, it was a picture of a picture, right? When I made my objection that it was a screenshot, my objection was that it was a screenshot. It will not. I should have articulated that. When I said that it was a screenshot, I was trying to articulate that it wasn't authentic. The court, you didn't say that, Ms. Vasquez. I didn't say that. I did say that. I said it's a picture, Your Honor. She's looking for the exact words, I think, there. Judge A is. Mr. Murphy, all I would respond to that is, Your Honor, it doesn't matter what she argued. What matters is Your Honor's ruling, and what matters is what came into evidence. The court, well, if she objected to it, she did object to it because she did say it was a picture. Mr. Murphy, there's nothing in evidence for him to opine to because of their objection. The court, but I overruled their objection and allowed it into evidence. Mr. Murphy, without the metadata. That's what I've been saying this whole time. It was allowed without metadata. The court, without the metadata. But she wasn't saying about the metadata. She was saying it was a screenshot of a shot, so taking a picture from a computer or, Ms. Vasquez, an iPad. The court, and I allowed it in. Mr. Murphy, I want to make sure I understand your scope clearly. Are they saying he's only going to be opining to photographs that, due to Your Honor's ruling, now have the black box over the metadata? Because what I will... His disclosure doesn't have any of those pictures in it. There was none of those pictures with the metadata are in his disclosure. This is the first time hearing that's what he's going to testify to. The court, well, Ms. Lick-Rose, the photographs that he looked at matched the photographs that came into evidence. Mr. Murphy, that's their brief, not their disclosure. Ms. Lick-Rose, I understand that, but those pictures came from Bryan's disclosure and his report. I guess Bryan is Mr. Neumeister? Mr. Neumeister, and same with the photo, obviously came in. He can talk about all the versions of that photo. The court, the ones that are in evidence over objection with screenshots, and he's going to testify that they are screenshots and that the original photo fill in the blank, Ms. Lick-Rose, right. So he's not going to say original photo because of the way that the collection was done. There's an issue, right, he can't testify that it was an original because that would be lying. There's an issue with the way the collection was done, so you can't say which of the photos is the original. This is the authenticity issue. Yep, absolutely, 100%. The court. So he's saying you can't tell when they were taken. Ms. Lick-Rose, he's saying you can't confirm it based on the way that Mr. Murphy. Additionally, Your Honor, again, the photos she's showing you in their brief with the metadata on them. I've lived in this disclosure. Then that is not in his disclosure, so it's outside the scope of his disclosure to testify about the photographs with the metadata on them. Ms. Lick-Rose, this is his disclosure, Your Honor. Mr. Murphy, that's not. Do you see metadata on these photographs in the court? It wouldn't matter if it's there or not, Mr. Murphy, but that's what's in evidence. Oh, man. Ms. Vasquez, it's the underlying. Ms. Lick-Rose, this is EXIF data, that is the photograph. The court, I'm going to allow that. We're going to allow that very limited, and then you can have your rebuttal. Ms. Vasquez, he can, just to confirm, he can opine as to the metadata that's in the underlying photographs. The court, in the underlying photographs. Ms. Vasquez, yeah, that is part of the screenshot. The court, they can redirect or cross-examine on it in their expert as well. Mr. Murphy, that raises another related issue, Your Honor. Our expert, Mr. Ackert, as they know from the expert disclosure, has found versions of the photographs that do not have this metadata issue. The court, okay. Mr. Murphy, and if they are now allowed to bring Dr. Neumeister to talk about that, I want to make sure there's no reason that our expert cannot rebut that, saying I found X, Y, and Z. I'm looking at Your Honor's earlier ruling of this disclosure and the timing of the photographs. Ms. Lick-Rose, Mr. Ackert testified at his deposition that he couldn't opine as to any specific photographs to which he was going to offer an opinion that they were originals. Mr. Murphy, that's not true, Your Honor. The court, that's fine. I mean, he's going to be your rebuttal expert, so he can opine to that. That's fine. Okay? Mr. Chu, thank you, Your Honor. The court. So does that resolve that issue? Do you have another issue? Mr. Rottenborn, one brief issue. The court, okay, you were actually very quiet. Mr. Chu, thank you, Mr. Rottenborn. Mr. Depp testified at the end of his testimony just now. He said, I've been living with it for 6 years and waiting to be able to get the truth out. I've spoken up for what I've been carrying on my back. The court, Mr. Rottenborn, all of us up here know that's not true because of the UK trial. He has had his chance, and we believe we believe we should be able to get into the UK judgment on that basis. The court, nope. Mr. Chu, thank you, Your Honor. Mr. Rottenborn, it's a question about everything other than that. The court, not to the judgment. Mr. Rottenborn, not the UK trial. Ms. Bradoff, but can he testify to anything else? The court, right. Are you ready for the other motion? Ms. Vasquez, yes. Mr. Chu, yes, Your Honor. Open court.
I think they're just arguing this motion at the bench, and I'm pissed because I wanted to see it. Something just happened. Benju is smiling. Put it on the record. Please just at least put it back on the record. If you just ruled on this motion, just put it on the record, please. I'm waiting for the mics to turn on. Like I'm waiting.
Yes, sir.
How you doing, sir?
Very well, thank you, Your Honor.
Thank you.
And now it looks like they're going to be doing, this is the TMZ thing. Yep, this is the TMZ thing. Okay.
TMZ. Okay.
Hey, Mr. Tillman, if you could just come to the center.
It looks like whatever they discussed, they're going to at least memorialize it for a record.
Thank you,
and the jury's going to get a long lunch today, or the lawyers are going to get a short one.
Mr. Tobin, if you want to.
Certainly. Thank you.
I got to make this relatively short,
okay, so
you can understand.
This is the TMZ
I wanted
lawyer.
to take up your motion. I have read your motion and the declaration and everything attached to it in all the cases. And I have reviewed it, so I'd rather you not regurgitate that based on our time limit. But anything you wish to add to that,
sir, we're tired and hungry.
If you want to, if I could focus you a little
Please.
bit. Okay.
Thank you.
All right. Yes, sir. As far as your comments about Virginia Rule of Evidence 2:508, that's a criminal rule of evidence. So that's not your strongest argument. And as far as what goes on is when the or if the witness testifies, whether it's hearsay or it's third-party knowledge, that's something I'll deal with at trial. So again, not what I'm concerned with. As far as Supreme Court Rule 314, which I would like you to talk a little bit about that as far as intervention. And I got to tell you where I'm at right now. The concern, the issue I have with the argument is intervention obviously would make you a plaintiff or defendant in the case, and it has to deal with an issue that's germane to this case, and this is a defamation case. So if you could just tailor your argument to that issue, sir.
Oh, sure.
How do you get to intervene?
Intervention. For the record, Your Honor, Charles Tobin from the law firm Ballard Spar.
Yes,
Here
sir.
representing TMZ, which is the publisher of news and entertainment for the celebrity and entertainment industry.
Yes, we know.
And Your Honor, we're seeking to intervene simply to protect the relationship between reporters and their sources when it comes to reporting news in the public interest. We, as the court noted, we really don't have a dog in this hunt as far as Mr. Depp misheard. We're really here purely on the First Amendment.
I always appreciate when they don't say dog in the fight, personally.
Sources. Your Honor, the intervention rule,
like dog in the hunt
as the court is aware, allows intervention by anybody where the issue is germane to the subject matter of the proceeding. And certainly, Your Honor, the purported testimony, the proffered testimony of a former employee of TMZ who purports to be in a position to disclose confidential information learned during the operation of journalism, during his work as a journalist, is a germane issue that is being raised in this case. And Your Honor, we would point the court to the Tafts, Fletcher, Malden, and Reed versus Southern Bank and Trust case, 213 Virginia Circuit, Lexus 253. It's a Norfolk Circuit Court decision from 2013. And there it was an interpleader action. The funds had been interpleaded into the court by two trust companies that were fighting over it. And the man who had sold his property, who had no interest in the funds themselves, intervened in the case because he was uncertain as to his liability for excess
like in Twister
funds,
when they're like, we have
which was an
cows,
issue that was not
we have
directly in
interpleader.
litigation between the two parties. It was not part of the cause of action between the two trusts fighting over the money that had been pleaded into the court. The circuit court held that certainly the rights of that man was going to be affected by the decision making in the case. He would be prejudiced if he didn't have an opportunity to intervene, and no party was in a position to assert his rights. And so similarly here, Your Honor, TMZ is a news organization. It routinely accepts information, as is common in journalism, under exchanges of promises
They are
of
trying to cross the
confidentiality.
first
If it is
hurdle
not able to intervene in this
of
action,
why they are
then neither of
allowed
the parties is going
to
to
be
be in a
heard.
position to assert the reporter's privilege. It is
They're arguing for the right to argue.
TMZ's journalist privilege that we're talking about. Then the rights are certainly going to be prejudiced.
But if the witness, in all the cases, and I reviewed the cases that you had.
They're trying
in
to
those
say
cases,
that they're
the
allowed to
witness was
intervene.
compelled to testify and came and was forced to testify. So there was an issue about the privilege of the witness. It's my understanding in this case, this witness wants to testify and is not under subpoena.
He has been subpoenaed, Your Honor.
Are you subpoenaed?
Incorrect, Your Honor.
That's incorrect, Your Honor.
A subpoena from this court would not be enforceable.
Yes. Yes,
Your
Ben
Honor,
Chu.
I have a copy
Yes,
of a
Ben
subpoena that
Chu.
was entered last night compelling Mr. Tremaine to give testimony in this case.
Bring it up, Boo.
And so he is coming under a compulsion under subpoena.
And if he takes a stand and he asserts some sort of privilege, then that's something I will deal with at that time.
Sure,
But a subpoena from
I'm here
Virginia
because of a
isn't-
scenario where he may not assert that privilege.
Right, exactly. And that's,
And it is
that's why I'm saying all your cases that you showed were the opposite, where they did assert the privilege.
Well, it is a unique situation.
Right.
where-
And I understand you might have some issues with a former employee and you have some avenues to go
Sue them.
deal with that.
but
Oh, dear.
once he testifies in the privilege,
The shit's out of the horse.
Lost our opportunity to intervene and
I
to
understand.
intercede.
Yeah, the shit's out of the horse at
Your
that
Honor,
point.
the privilege, I know, Your Honor, you said you read the case file.
I did.
Appreciate that.
Yes, sir.
But
These
the
judges
privilege
must be
has been
exhausted.
recognized by the Virginia Supreme Court in the Brown case and applied by the circuit courts uniformly. It is a very important underpinning of the relationship between reporters and sources and reporters and the public. Without the ability to enforce its promises by current employees or former employees, a news organization will have absolutely no control over being able to enforce its promises. And so we would ask the court to permit us to intervene and to assert the privilege that belongs to TMZ, which is the
not friendly to
organization,
this
after all,
argument.
Your Honor, that would be responsible to the source if the privilege were waived.
All right. I understand, Mr. Tobin, your argument. I appreciate it very much. Okay. Did the parties wish to be heard?
Oh, Ben Chu.
Good morning, good afternoon, Your Honor.
Yeah, fair.
I'd like to begin where Your Honor began. As a threshold matter, the court should deny TMZ's motion to intervene. Intervention is not appropriate for the reasons suggested in Your Honor's questions. As Your Honor is well aware, intervention is only appropriate with leave of court where a third party seeks to, quote, file a pleading to intervene as a plaintiff or as a defendant to assert
Interesting
any
local rule.
claim or defense germane to the
local case law.
subject matter of the proceeding, unquote. Virginia Supreme Court Rule 3:14. As Mr. Tobin, to his credit, has conceded, TMZ is not asking to file a pleading. It cannot properly categorize itself either as plaintiff nor defendant, and it seeks to assert no claim or defense germane to the subject matter
Oh, the
of
judge
this
is
action.
nodding.
Moreover,
It's
even
good
if the
signaling
privilege were
for
applicable,
Depp's side.
which is not the case here, the testimony intended is directly relevant and would outweigh any qualified privilege. Quote, an intervener must be asserting an interest that is part of the subject matter of the litigation, unquote, Hudson versus Jarrett, 269 Virginia 24/32. Here, as Mr. Tobin stated, TMZ seeks to protect potential information solicited from a third-party witness, which is in no way a matter before this court, citing Commonwealth versus Gill, 89 Virginia Circuit 323, a 2014 case denying a motion to intervene where the intervener filed it, quote, to protect a property right, not a matter before the court, unquote. The outcome of this trial will not affect TMZ, and it does not have a sufficient interest in the subject matter of this suit to intervene. See Texas Fletcher, Maiden and Reed, PC versus
and they say
Bank
it will because then they
Trust
won't have
Co.
sources.
2013 Westlaw 5849140, granting, and this is distinguishing it, granting the motion to intervene where the intervener's liability would be affected by the outcome of the litigation. Finally, Your Honor, TMZ lacks standing to object to testimony by a third party in this action because TMZ, as Your Honor pointed out, is not being compelled to testify. TMZ's reliance on the Philip Morris case for the proposition that the privilege cannot be circumvented by seeking confidential source information from an employee is inapposite. 3-6 VA Circuit at 1. For one thing, as noted in that case, there is no testimonial privilege akin to that enjoyed under the Fifth Amendment, which would allow a reporter to refuse to appear before a grand jury and answer questions. And Philip Morris, as Your Honor is aware, the party issued a third-party subpoena for records to trace confidential sources. Philip Morris is inapposite here, as that case related.
Elaine is trying to think fast.
As this case is related to witness testimony, not records. As Your Honor suggested, TMZ's quarrel, if any, is with Mr. Tremaine to the extent that he had an NDA that was enforceable, applicable, and that's not what we're hearing from Mr. Tobin. So to the extent that TMZ, which is not exactly Edward R. Murrow, Your Honor, to the extent they have a beef, as it were, a cognizable beef, it is with Mr. Tremaine. It is not with Mr. Depp, and they clearly do not have standing to assert or to intervene because they are not intervening as a party, plaintiff, or defendant. So we respectfully submit, to the extent the court disagrees, I can go into the arguments why the privilege is inapplicable.
That's all right.
I will reserve that.
Thank you.
I agree, Mr. Chu, is basically what the court just said.
Your Honor, I would like to weigh in from just a different perspective, and that is because we're trying to deal with some important issues of privilege, et cetera. But from our perspective, representing Ms. Hurd, we have issues with this witness separately, and I want to make them very clear for the record.
Oh, yes,
this is somebody who should have been identified in discovery, was never. Second of all, it's not relevant whether apparently what they're saying he's going to testify. We have not had the opportunity to discover that. Is he's going to claim that someone leaked to TMZ that Ms. Hurd was going to obtain the TRO on that Friday, and also
is that what they're testifying
video, the kitchen video with Mr. Depp being rather violent. I'm almost certain he's not going to claim it's Ms. Hurd, so I think it's never going to come in.
Ms. Berghoff, I
that's
understand
a separate
all that.
issue,
Do you have any
Elaine?
argument as to this particular motion?
No,
Okay, well, then we can address you.
My point is, though, if you balance
No,
the prejudice versus the probative value, I don't even see how he can come in on foundation or hearsay or relevance.
That's just not part of this motion at this time.
That
Thank you,
is
ma'am.
a
All right,
separate
Mr. Tobin,
point.
your motion, you get the last word, sir.
She is Elaine's splaining.
You know,
She's Elaine's splaining.
Appreciate that the court kind of shook your head when he made the snarky comment that this is not Edward R. Murrow. Obviously, the First Amendment applies to everybody, citizens, the New York Times, or TMZ. And this is a First Amendment-based privilege. Your Honor, the Philip Morris case is actually a very good case to answer Your Honor's question about the intervention of somebody else in order to assert the privilege. ABC was a defendant in the case, and it moved in order to prevent other people from coming.
Elaine does not understand the assignment today.
I understand. There is no other mechanism, though, and so it would be an interesting procedural issue for appeal, Your Honor, whether a journalism organization or anybody else who's a First Amendment holder would be denied intervention on a constitutional-based privilege.
Look at him.
I also, just for the record and for the merits of the case, if I understood
for the
Mr.
interwebs,
Chu correctly,
don't forget the interwebs.
he said this is not an issue in the litigation. This does not relate to an issue in the litigation. Well, if it's not an issue in the litigation, if it's not part of a prima facie part of the defense, part of the allegations of the complaint, if it's impeachment evidence, if it's collateral to the main
This
issues
says
of the
everything.
case. Under the Brown
Sir,
v.
no.
Commonwealth decision of the
Sir.
Virginia Supreme Court,
Sir,
under
no.
the application of that privilege
This face.
in the Philip Morris versus ABC News, it is not supposed to be compelled in this case.
Which is, again, it's not being compelled,
Sir,
it appears.
It's not being compelled.
Well, he is appearing by subpoena, and
Apparently
it is
not,
a compulsory
sir.
process, and he will have an obligation
She is
unless he asserts
so-
privilege under oath.
So patient.
But it is our privilege, Your Honor. It's not an employee, a loyal or a rogue employee's privilege to waive on behalf of its employer. This is an unusual situation.
Tell me about
But the answers are there in the law, and it is a First Amendment concern.
This is not the first unusual situation in this case. I can
For either
tell you,
of us,
for Mr. Tobin.
for anybody here.
Judge-
Yes, sir. I
Jay.
appreciate you coming in today, and I appreciate
you.
your arguments. Yes, sir. Thank you.
Negative
All right, in
ghostwriter,
this
the pattern
matter,
is full.
Under Virginia Rules, Supreme Court
Denied.
3:14, a new party may intervene as a plaintiff or defendant to assert any claim or defense germane to the subject matter of the proceeding. A new party may not intervene unless they assert some right involved in the underlying litigation. A party is not entitled to intervene merely because a byproduct of the litigation adversely impacts them, and the
that's
decision to allow
the winning
intervention
sentence.
is within the broad discretion of the trial court. Here, the rights asserted are not germane to the trial. The central issues in this case are whether defendant defamed plaintiff and whether plaintiff defamed defendant through a theory of vicarious liability. The issue of the confidentiality of sources has not come up as in other cases cited by EHM, which is the corporation that TMZ belongs to, is under their umbrella. In Brown versus the Commonwealth, there was an attempt by the criminal defendant to subpoena institutions in order to obtain the name of the confidential source. When the author of the article was subpoenaed, she refused to identify her confidential source on the stand. And in this case, it appears that the witness is willing to state the name of the confidential source without being compelled voluntarily. Whether that breaches a non-disclosure agreement between Mr. Tremaine and EHM is not germane to this matter and can be litigated in a separate matter if EHM so chooses. And while breaches of contract must be taken seriously, and the court does, any alleged breach is not germane to the underlying litigation here. That contractual action has no bearing on this case and is thus not germane to this litigation. Therefore, I'll deny the non-party EHM Productions motion to intervene.
Thank you, Your Honor. For the record, I've known Mr. Tobin for several years. I meant no snarkiness toward him.
Well, you're just a snarky guy.
You meant snarkiness towards TMZ.
Yeah,
For the record.
Ashley, Mr.
Your Honor, I am concerned that we preserve the issue fully. And so
For the record, yes.
For the
sir.
record. And so I would ask, may I have the opportunity to object when Mr. Tremaine is questioned by
You've already
question?
objected.
No, sir, you're not a party to this case. However, I will note for your record your objection to his complete testimony on behalf of your client.
Right. Thank you, Your Honor.
Okay, thank you.
I'm dead. Color me deceased.
Microphone.
As
Elaine.
the Hicksville witness, Your Honor, I would ask that we could voir dire him before the jury to find out when he contacted counsel and when they became aware of it. And I think also under the circumstances, in fairness, I think we should at least be able to ask him what he's going to claim.
No.
Response.
No.
Your Honor, I don't think that's appropriate. Certainly,
No, it's a rebuttal witness.
The proffer is necessary or appropriate in this case.
I'm not going to do a proffer in this matter. Okay.
Yep.
All right. Oh, Mr. Rottenberg.
Sorry.
Almost
Did you
at
hear
lunch.
I know, I'm so sorry. But I truly am the messenger here.
This is-
Mr. Murphy just informed me that he has to just clarify one thing about.
One clarification.
Okay,
Jesus.
all right, okay.
I apologize.
That's fine. I think we need Miss Myers.
Away in a sidebar, this trial has no end. Sidebar, the court. Well, if somebody could just represent her here, Mr. Murphy. I'm not trying to keep Your Honor, the court. No, I know you want to know what to do for a witness. Mr. Murphy, yes, I heard that Your Honor said he can to the metadata. I would like to know what exactly that means because there's hundreds and hundreds of lines of metadata. And mountains of proof. No, I added that part. And let me just say why this is important, Your Honor. I just read the brief because I was off researching their opposition, and it talks about the metadata indicating this photo is 3. Your Honor, I have to say, Mr. Neumeister said in his report literally, quote, none of the photographs in Miss Heard's, end quote, the court. You can cross-examine on that. Mr. Murphy, it's not in evidence, Your Honor. He literally said they're not in the trial exhibits, period. So how can he testify to that? The court. Mr. Murphy, we're going to see what's going to happen with the testimony, but if you want to go with counsel during the lunch break and see exactly which photos we're talking about, what he's going to testify to, Ms. Vasquez. The ones in his report, Your Honor, part of this disclosure of the court. If you want to get with him, you can work it out. Mr. Murphy, who's my partner on that? Or what about who's his mate on that? That's what Elaine would have said if she was up at the bench. Ms. Vasquez, Rebecca, Mr. Rottenborn, would it be possible to get an updated time? The court, you can get it from Sammy. Let's just announce to everybody after lunch. Get back just 1 second. All right, so court will be in recess. Let's come back at 2 so everybody gets an hour for lunch, okay? Bailiff, all rise, and it looks like they are now having their lunch break.
So court will be in recess. Let's come back at 2 so everybody gets an hour for lunch, okay?
Thanks, Judge A. All right. You are a queen of justice, and we appreciate you.
Coming back from lunch, bailiff, all rise. We're ready for the jury. Wow, they're actually ready for the jury. That's amazing. Here comes the jury. Bring the jury.
Mr. Depp, I'd like to start with the honeymoon that you and Ms. Heard took in late July 2015.
Certainly.
You testify that you took a train ride from Bangkok to Singapore. Is that right?
That's correct.
And you claim that on this train ride that Ms. Heard hit you in the face, correct?
Yes.
And left a black eye, correct?
Yes.
At least he's not rushing.
Michelle, could you please pull up PX 162?
His pace is not super rushed, which I appreciate. Elaine came out with Dr. Curry rushed. We also had testimony from Kate Moss.
Mr. Depp, this is the picture that your counsel showed you both in your prior or showed you this morning, correct?
Yes, sir.
Okay. And that mark under your left eye is what you claim to be a black eye caused by Ms. Heard, correct?
Seems to be there's some scratches around my nose as well.
Okay.
Right here.
All right, but that it's your left eye, the one close to the chef. That's what you says your black eye, correct?
Yes, sir.
Okay. And that was the picture your team chose to show you, right?
Huh. Not my job.
Let's pull up exhibit 1905, Michelle, please.
I'm sorry, which number was it?
This is a new exhibit, Your Honor, 1905.
Oh, new exhibits.
And that's defendants?
Defendants exhibit 1905.
Okay, thank you.
We love new exhibits. This is a new exhibit, and we all go,
Publish, Your Honor.
Oh, you want to put it in evidence? Okay, any objection to 1905?
put it in evidence before you publish it, Rottenborn.
With the comments, we have no objection to the photograph itself. We would ask the comments be redacted as hearsay.
Well, I'd like to at least question the witness about the comments.
I have no objection to the photograph being published.
Okay, well, let's wait a minute. Mr. Depp, you see here, these are 4 pictures of you, right?
Yes.
Yeah, and below it indicate that they were taken on July 24th, 2015 in Bangkok, Thailand, correct?
Objection, lack of foundation, calls for speculation.
Overruled.
In Bangkok, Thailand, so before the train ride.
Correct, before the train ride, because you didn't get on the train ride till the 25th, is that right?
Somewhere in that area, I guess.
Okay. Your Honor, I'd ask for permission to publish this to the jury.
If it's just the photographs, we have no.
Hey, Paul Pack and El Jefe, good to see you both in the chat.
Just have the photographs in it?
Sure. So we'll do 1905.
5, just with redaction, should be fine.
Thank you, Your Honor. Michelle, could you please scroll down to the bottom 2 pictures there?
Yeah, he was trying to organize his space. I definitely try to control my space when I'm feeling stressed.
Mr. Depp, in these pictures that were taken before you got on the train ride for your honeymoon, where you claim that Miss Heard hit you and gave you a black eye, you have the exact same shadow or sunburn or mark under your left eye.
Fair.
The exact same mark, don't you?
That's the, when you get a side light, you see the occipital bone. So that is the exact area.
Yep. And it's actually
a side light will cause that.
Yeah. Well, the picture's not being taken from the side, is it? It's being taken head on, isn't it?
No.
He's talking about the light
in front.
Yeah.
The light on the side.
Right.
Will cause that occipital bone, I believe it's called, to appear sunken.
Just like lights on the side of a train car, correct?
Objection calls for speculation.
You can take that down, Michelle.
That was in fact in the dark. I had a chef, I had people on either side of me, so I don't see where the light fill is from the side there.
Mr. Deputy,
People
wait
on
for the
either
next
side of
question.
me.
Next question.
Next
Oh,
question.
sorry.
Even the picture your team chose to show you on that train isn't accurate, is it? Let's pull up.
Objection calls for speculation.
Let's pull up exhibit 1859, please.
Rottenborn is not going
1859.
slowly
Is
into
that
the
in
good night.
evidence?
No, Your Honor.
They are just ready.
Mr. Depp, this is the same picture, or the same, the exact same scene displayed in PX 162 that you looked at this morning, correct?
That looks like my face has been, the eyes have been photoshopped.
Oh, okay. So this post from the Eastern and Oriental Express's Facebook page, you're saying that that's photoshopped?
Is that from their page? I would,
He didn't say he
sure,
knows
why
where it's
wouldn't
from.
they?
Let's pull them up side by side, please.
He didn't say he knew where it was from. Oh, if we're getting into pulling
Your
up
Honor, I
photos
move
side
for
by
the
side.
admission of
be
this
interesting.
exhibit. We can just have the pictures. We don't need the.
Any objection to the picture?
Objection, lack of foundation, lack of authentication.
Is that you in the photo, Mr. Depp?
It is me, but it's clearly.
Your
it's
Honor,
been-
I'd move to
it's
strike
been-
anything after that, first of all, and would ask for admission of this photograph.
All right, just a photograph?
Yep.
Are you gonna,
We maintain our lack of authentication, lack of foundation.
all right, over objection, I'll allow 1859.
Thank you, Your Honor. Michelle, could I please get you to,
You need to redact it first.
Yeah.
we actually have one, it's, that will admit.
I don't like
or
the
ask you
huffy
to admit
sounds
it's
either.
1858. That is just the picture.
I already have 18.
Okay, so we'll call this 1859 then.
Rottenborn has
So
been
this
a
is
good
1859.
lawyer.
Yeah, we
He
just
is
need to-
doing his job.
Okay.
The questioning is clear. But yes, the huffiness
We'll fix
bothers
that
me.
exhibit sticker on the bottom and get you that correct 1859.
18.
They also are working against the clock.
And
And that's
Michelle, what
hard
I'd
for
like
them.
to ask you to do, please, is to put the picture displayed as 1859
Digital expert is still on the list.
was admitted into evidence next to PX 162 that was shown to Mr. Depp this morning.
Okay, you can pop, those are both in evidence.
Can you try to make them the same size, please?
Can you try to make them the same size, please, Michelle?
This is the exact same picture, isn't it, Mr. Depp?
With radically different quality. And
No, you answered my question.
I don't know, I wasn't done.
You answered my question, sir. Thank you. Appreciate it.
You're very welcome.
Oh boy.
Mr. Depp, you had that, whatever mark it is, whether it's a sunburn, whether it's a shadow, whether it's the light reflecting, you had that same mark on your eye before you got on that train.
Well, it's pretty difficult to get a sunburn on a train. And in
let's
the
go to-
photographs with the child, I don't look particularly sunburned. Can we see those again?
Let's pull up exhibit
Your
one.
team
Actually, no,
will
let's
have
talk
time
about Australia.
to do redirect.
Oh, good.
You testified that you've
do you
never
say? Oh,
done
good.
ecstasy more than a handful of times in your life, correct?
6, 7 times.
Now, you heard Miss Heard's testimony. You've been sitting here. I know you didn't look at her. but you
Rottenborn
heard
is
her
now starting
testimony,
to rush.
and you heard her. You didn't hear her say you ingested 8 to 10 all at once.
That's what she
came
said.
down after being apart from you for some time.
Rottenborn.
and there were 8 to 10 gone from the bag.
Objection
No.
form compound.
Misstates facts and evidence.
I also heard Miss Heard say I reached into a bag and threw and poured a bunch of
That's what she
MDMA
said.
down my mouth.
Correct. That's right. She
a
didn't say you
handful.
poured 10 at one time, did she?
No, she said a handful.
She did.
Okay.
Which is more than 10, I believe.
That's interesting.
Could you repeat that?
And you've also said that with
Could you
respect-
repeat that, please?
Yeah, that if you want to be with a woman sexually, that she is rightfully yours.
That's ludicrous.
You've also said that with respect to women that you want to be with, you've remarked, I need, I want, I take, haven't you?
Equally as ludicrous. No.
Can you pull up DX 883, please?
Yeah, I'm gonna need some context.
You can pull it what you like. I've never said those words. There's not enough hubris. in
There's
you.
not a question pending, sir.
883.
The judge is gonna
883,
cut you right
Yes.
off.
Is it
It
evidence?
is not admitted yet.
Okay, 883.
Though it seems that Rottenborn is very excited about this.
Mr. Depp,
They better not be moving
these
lines.
are text messages from you to Stephen Deuters on February 22nd, 2017, correct?
If he asks for the metadata, I'm going to die laughing.
No, this looks nothing like me. You might have mistaken.
Mr. Depp, we can show the full unredacted. You've looked at a number of text messages in this case, and the words him as the identifier, that's you, correct? In every text message we've seen in this
Show
case.
the full unredacted then.
Yeah, sure. It still doesn't mean it hasn't been screwed with. That's not anything that I've ever said or written.
You want to see the whole thing unredacted? We can look at that too.
Let's do that.
Because you could have typed it up last night. No.
Yeah, I can assure you I didn't type it up last night.
Just
Mr.
answer
Depp.
the question,
Your
Mr.
Honor, I move
Depp.
for the admission of Exhibit 883.
All right, any objection?
Objection on relevance grounds, Your Honor.
All right, well, do you want to approach for a moment?
The huffing absolutely kills me, but now it's impeachment because he's saying I never said that. So
Judge Rest ye merry sidebars, let nothing you dismay. Here comes another sidebar, the millionth one today. The court. All right, Mr. Rottenborn. He testified to Miss Myers that he would never commit sexual battery. He just testified to me, quote, those words would never come out of my mouth. I would never say that, end quote. It's relevant and it's impeachment, Miss Myers. There's no foundation that that's what he's talking about here. The words, quote, sexual violence, end quote, or, quote, assault, end quote, are not in that text message. Oh, I remember this. Mr. Rottenborn, Your Honor, the jury can draw the inference from it that they want. Miss Myers, this is not, it's unclear what he's talking about. It's not, Mr. Rottenborn, I'm happy to admit the whole chain. I just figured every other time they wanted to redact those words. So he's like, so I'm just doing you guys a favor. The court, do you want to see it unredacted to see the context of it for a redirect? Miss Myers, I would like that opportunity, but I suspect I would like it admitted in redacted form. Mr. Rottenborn, I was just trying to do you a favor, counsel. The court, I mean, it's impeachment to what he said, so I'll allow it. Mr. Rottenborn, thank you, Your Honor. The court, okay, back to the court.
Mr. Depp, you're aware that these are text messages. You can see the bottom right.
He's saying that they're not his.
And then it has a number, 8129.
He's
Those
saying they're not his.
Produced by you in this litigation. You understand that, right?
I understand that.
Okay. All right. Michelle, could you please, let's take a look at the top text first. Mr. Depp,
I mean, he should be
February
tense. He's on
22nd,
cross-examination.
2017,
Tense is appropriate.
You texted Mr. Deuters.
That's going to be the problem for the jury.
Exactly.
If this feels
Molly's pussy is rightfully mine. Should I not just bust in and remove its hinges tonight?
That's not what you
right?
asked.
You read it, right?
And the one beneath that, you say,
oh my,
I want to change her understanding of what it is like to be thrashed about like a pleading mackerel. And then in all caps, you write, I need.
Rottenborn is reading sex into the record again.
Right?
You read it right.
Rottenborn is reading sex again. Rottenborn is reading sex again. Oh, Elaine.
Perhaps someone else.
You wrote every other text that you produced that came from you in this litigation, didn't you?
Not necessarily. Sometimes you give your phone to people and they text.
Right. And it wasn't uncommon for you to ask Mr. Deuters to communicate with Ms. Hurd on your behalf, correct?
It wasn't uncommon for any of them to communicate with Ms. Hurd on my behalf if I were on set or unavailable or any of that.
Or if Ms. Hurd and you had a fight, you would sometimes have them to communicate with Ms. Hurd on your behalf, correct?
I think my crew caught on very quickly that
just a yes or no
would be necessary for them to.
No, just a yes or no. It was not uncommon after you and Ms. Hurd had.
I'd ask that he be allowed to finish his answer.
Yes or no
I'd ask that Rottenborn chill.
Go ahead and ask your question.
Thank you, Your Honor. It wasn't uncommon for you to have one of your personal assistants communicate with Ms. Hurd after you and her had a fight.
I disagree because you're insinuating that I had them do it, and you don't know that.
After the Boston plane flight, you had Mr. Deuters.
He's asking you that.
Communicate with Ms. Hurd, correct?
When I'm asked what to do, I said placate her, just placate her like we always do.
And you told him, send her whatever message you need to send to placate.
I'm sorry,
correct?
he's sorry, he feels bad, yes, because any other answer, it would turn into World War III.
Okay. Can you pull up Exhibit 229, please? Your Honor, think you know where I'm going here, and based on Mr. Depp's testimony, I'd ask me for the admission of Exhibit 220.
They're asking if a door's been opened.
Can we please approach?
Sure. They're asking if a door's been opened.
Away in a sidebar, dog poop in the bed. Ms. Myers, Your Honor, these are not Mr. Depp's words. These are the words of the court. He's saying, quote, just placate her, end quote. Mr. Rottenborn, he said, quote, tell her what she needs to hear, end quote. The court sustained. Mr. Rottenborn, okay, all right, thank you. The court, appreciate the try. Back to open court.
You were pretty angry after Ms. Heard got her temporary restraining order, weren't you?
Angry. I was, more than anything, I was hurt.
And you testified earlier this morning, you claimed that you somehow were responsible for her getting the role with Warner Brothers, correct? That's what you testified to this morning. You also tried to get her fired.
Did he answer?
From Aquaman, didn't you? After the temporary restraining order.
Wait, compound.
Which question would you like me to handle?
Correct.
One question, sir. You tried to get her fired from Aquaman after the temporary restraining order, didn't you?
Well, what is related to the story about me getting
yes or no, Mr. Depp? I don't
have time for this shit.
What the story related to?
I can't please you with a yes or a no every single time.
It's a yes or no
Poor
question.
court reporter.
You tried to get Ms. Heard fired, didn't you?
Answer's no.
All right, let's pull up Exhibit
The poor
821.
court reporter. RIP, like F in the chat for the poor stenographer with these two talking over each other, because oh my God, why are there no objections?
Is that me trying to get her fired?
Strategic choice.
This is a text message that you had with your sister, Christy Dombrowski. She was the first witness in this case, right?
She doesn't work at Warner Brothers. She can't fire Amber.
Yeah. This is a text message you had with her
just
on June 4th, 2016, isn't it?
They're just going to fight.
June 4th, yes.
Your Honor, move for the admission of Exhibit 821 as redacted.
Any objection?
We would object on relevance grounds, Your Honor.
I'll overrule that objection. 821.
Rottenborn, they're marking a record. Don't huff every time they make a record. They're letting the jury see how much Amber Heard's fighting.
2016, Mr. Depp, you texted your sister, I want her replaced on that WB film. Did I read that right?
You did.
Her is referring to Amber, right?
That's correct.
And WB is Warner Brothers.
And
correct?
WB already testified.
Again, correct, yes.
And then after you sent this text to your sister, following the temporary restraining order, you reached out to Guy Silverstein to have him fire Amber, correct?
Who?
It's Greg Silverstein, I'm sorry.
Still who?
I don't recall reaching out to Greg Silverstein.
You reached out to Sue Kroll to get him to fire Ms. Heard, right?
I had vetted Ms. Heard. I had vetted Ms. Heard.
Mr. Depp, you got your chance to speak this morning. Your Honor,
Warner Brothers had two franchises.
Mr. Depp, if you could just answer the question, sir. Next question.
You reached out to Greg Silverstein to get him to try to get Amber fired from Aquaman, didn't you?
Asked and answered.
Excuse me?
Asked and answered.
It's a yes or no question.
Nothing's been answered.
All right.
Nothing's been answered.
Okay. Yes or no, sir? You reached out to Greg Silverstein to try to get Amber fired from Aquaman.
Second half of your question is wrong, sir.
You reached out to Sue Kroll
because I vetted her.
No, Mr. Depp. You reached out to Sue Kroll to get her to try to get her to help you get Amber fired from Aquaman, didn't you?
No.
And you reached out to Kevin Sujihara to try to get him to help you get Amber fired from Aquaman, didn't you?
No.
Can you pull up Exhibit 857?
Oh, chat. Rottenborn is not going to slow down. Rottenborn doesn't have time to slow down. This is just, there are moments.
Mr. Depp, this is a text message that you sent to Christian Carino on August 15th, 2016.
Does a text message to Christian Carino
evidence, correct?
Parts of it are.
Have anything to
not this version?
Well, this can't be 857 then, don't.
I'm sorry, Your Honor.
The judge is like, please, for the love of God, don't fuck up the exhibits now, Rottenborn. We have 2 days left. So the judge is like, you can't admit different. The record needs to be clear, not just for the jury, but the record needs to be clear for the appellate court. Which
Mr. Depp,
exhibit
you
is
sent
which?
this text to
The
Christian
redacted and the
Carino on
unredacted.
August 15th?
I most certainly did.
Okay. And in this text that you sent to Christian Carino is the person who used to be Amber's agent and then was your agent for a time, correct?
That is correct.
And in this text, Your Honor, permission to publish, please.
You want to put in evidence first?
Move for admission of
Any
857A.
objection?
No objection.
All right, 857A, as redacted, will be in evidence.
I think he's worried he's going to run out of time.
And in this text, Mr. Depp, you said, she's begging for total global humiliation. She's going to get it. I'm going to need your texts about San Francisco.
Oh, this is the one about
I'm even sorry to ask.
Elon Musk's crooked dick.
She sucked Mollusk's crooked dick and he gave her some shitty lawyers. I have no mercy.
Are you that
no
shitty
fear,
lawyer, sir?
And not an ounce of emotion or what I once thought was love for this gold-digging, low-level, dime a dozen, mushy, pointless, dangling,
lawyers.
overused, flappy fish market. I'm so fucking happy she wants to go to fight this out.
I was surprised this
she
didn't
will
come
hit
in.
the wall hard, and I cannot wait to have this waste of a cum guzzler out of my life. I met a fucking sublime little Russian here, which made me realize the time I blew on that 50-cent stripper. I wouldn't touch her with a goddamn glove. I can only hope that karma kicks in and takes the gift of breath from her. Sorry, man, but now I will stop at nothing. Let's see if Mollusk has a pair. Come see me face to face. I'll show him things he's never seen before, like the other side of his dick when I slice it off. Did I read that right?
This, I believe, came in the UK case.
Ms. Myers asked you something about, how does it feel to make you, or how does it feel to be here? You said, I've been living with it for 6 years and waiting to be able to get the truth out. You remember saying that?
Yes.
You also said, I've spoken up for what I've been carrying on my back. Something to that effect. You remember saying that?
Yes.
And you've claimed several times in this proceeding, Mr. Depp, that this trial is your first chance to tell your story, haven't you?
Oh, are they going to get into the TRO? Is that
But
where we're
that's just
going?
not true,
Ooh.
is it, Mr. Depp?
Oh, dear.
That's not true.
Huh?
No, for me it is true.
Okay. Well, here's the thing.
For me,
the fact is, Mr. Depp, when Dan Wooten wrote an article that was published in the Sun calling you a wife beater, you brought a lawsuit against the Sun in June of 2018.
Wife beater
correct?
as much as he can in court.
Yes, I put
And that was 6 months before Miss Heard ever wrote her op-ed, correct?
I don't know.
And in the summer of 2020, there was a several-week trial in London against the Sun, correct?
Ms. Heard was not a party to that trial.
Not my question, Mr. Depp. In the article that the Sun wrote that you sued over, you sued for Mr. Wooten calling you a wife beater, correct?
Objection asked and answered.
Sustained. Next question.
And in the trial that you subsequently brought,
Rottenborn's like, but he's not
you called a
answering.
lot of witnesses, right?
I don't know what a lot is. I don't know.
Many people testified on both sides of the trial, correct?
Yes, ma'am.
Are they going to try to get into a result? of the
Many
trial?
exhibits were introduced, correct?
Like a trial, yes.
And you, just like in this trial, you were on the stand for several days in that trial, correct?
Yes, sir, I was.
And that trial involved the same factual issues that you are litigating here, which is whether
Objection.
abuse against Amber Heard.
Sustain the objection. Next question.
You brought that case against the Sun because you were angry at the Sun for calling you a wife beater, correct?
Or he felt it was slander. I mean, one of the two.
Yeah, that's probably a pretty good reason.
And you went through that trial in London, correct?
I did indeed, yes.
Mr. Depp, you've already had a chance to tell your story, haven't you?
No, there were great limitations in the UK trial.
Okay.
No further questions.
All right. Redirect.
No.
Thank you.
No further questions. Redirect.
Mr. Depp, Mr. Rottenborn asked you some questions about the UK trial. Why do you feel that this is the first time that you've actually had an opportunity to tell your story and, as you said, get the load off your back?
Oh, she folded the post-it.
As the UK trial was me suing Dan Wooten and the Sun for defamation for calling me a wife beater. The UK have there are different laws, there are different ways they handle things. There are also limitations in evidence. Some things can be brought up, some things cannot be brought up. Mr. Rottenborn.
He's talking about limitations in evidence in the English.
Your Honor, he's talking about his experience testifying.
He is talking about his experience testifying. Rottenborn, you brought it up.
Yes, there is a very.
He's going to start back over again.
Everything is quite boxed in with regard to what can be said, what can be spoken about. So, Ms. Heard provided information to the Sun as their star witness, but the case was not brought against Ms. Heard. It was brought against the Sun newspaper, journal, whatever it is.
Mr. Rottenborn referenced that you were on the stand for multiple days.
4.5, I believe, yes.
Yeah. What was the nature of that examination? Or excuse me, who was conducting that examination of you?
QC Sasha Was.
And whose attorney was that?
The Sun.
Interesting.
Can we please pull up DX 857A?
All right, it's already in evidence, so we can publish it.
Mr. Depp, do you recall seeing this text message when Mr. Rottenborn was questioning you?
Oh, yes, I do.
For all the huffiness of Rottenborn,
to Mr. Carino,
it was a good cross. He got into the things he needed to get into. This text is damaging. But it might be too late if the jury's already just like, who cares?
Shock that this is happening to me, that my entire life on the planet has been brought to the head of a pin with all this completely, utterly false information. So I am, when you're accused of horrific acts and things that you have not done, when it's actually some very ugly things that are going out there into the world about you on a non-stop basis.
He was pissed. Fair.
By Ms. Heard and her team. You have a tendency as humans to get very, very irate and angry, not to the point where you go out and hurt someone, not to the point even where you assault a cabinet. But you do get irate. You do wonder why this person is doing this to me. So many things go through your head. And then you've got your family, you've got your kids, you've got your parent. My mom, thankfully, didn't get to read any of this because that would have killed her. But my father, my family, everyone that I've met, the people that have supported me, suddenly I'm scum. Why? Never had to happen. One little lie. So yes.
I was pissed.
Very angry.
Could we please pull up Defendant's Exhibit 821?
And we've had so many other texts that have been hyperbolic, violent with violent languaging.
Mr. Depp, do you recall seeing this text message?
The jury
when Mr. Rottenborn was asking you questions.
We'll find that hugely impactful at this point.
Would you care to explain what you're trying to convey in this text message?
And this is why there's a redirect. And she slowed the pace down intentionally. She didn't match the pace of Cross, which kind of feels like a breath of fresh air.
They were about to find themselves in quite a dilemma as the person that they had just cast.
Objection, Your Honor. Lack of foundation as to what Warner Brothers knew or thought.
Didn't I meet with them?
All right. If you could just wait for the question. I'll sustain the objection. Next question.
Mr. Depp, without explaining what Warner Brothers
Might have
felt,
perceived.
why did you send this text message to your sister? And what were you trying to convey to your sister when you sent this text message?
Honestly, I felt responsibility for having gone to those people and
vouched for her?
Painted such a beautiful picture.
Objection. Hearsay, Your Honor. Now he's talking about what he said to Warner Brothers.
Oh, Rottenborn, stop it with the talking objections.
Please continue.
Change seats.
So, sorry, you can continue.
I felt it was my responsibility to get the truth to Warner Brothers about what they were going to end up facing down the line, which is 2 franchises.
You felt responsible.
That would be causing problems for one another, especially as any news, any press, any media that came out about me at that time had been turned into, I was Charles Manson, I was the worst thing on earth, and they just kept coming. It was like a nonstop fire. So my responsibility, after having painted a beautiful picture of her for them, was to tell them, I think you better.
Objection, Your Honor. He's getting into what he claims he told Warner
He's talking about his state of mind.
He's saying what he wanted to tell them. He's not saying what he actually told them.
I'll sustain the objection. Next question.
State.
Mr. Depp, you
of
mentioned
mind.
2 franchise films with Warner Brothers. What 2 franchise films are you referring to?
There was Aquaman, and Fantastic
There was Aquaman.
Beasts, the one that I was in.
Oh, right, because
And why
Fantastic Beasts
did
is
you
Warner Brothers.
Feel a responsibility with respect to those 2 franchise
I'm
films?
not connected.
Warner Brothers was starting to get quite upset about some of the things that were being said about me in the press that were constant hit pieces.
That makes sense.
Mr. Depp, do you know who took this picture?
Malcolm Connolly.
And despite what Mr. Rottenborn showed you about the picture of you prior to this, do you see a bruise on your face in this picture?
I see like what looks like a pretty decent shiner and a kind of a scratched up nose, yes.
And do you recall how you got the scratches and the shiner?
There was a very brief freak out that Miss Heard had in our cabin just before this dinner. I can't remember why, but there were many. I remember taking the photograph, though. I remember being there. I remember meeting the chef and all that. But the quality of the photo is not great. The quality of the other photo that he showed is
what?
Prettied up.
Mr. Depp, did you ever physically abuse Miss Heard during your relationship?
Never.
Probably her last question.
No further questions.
All right, sir, you can have a seat next to your attorneys. Thank you.
Thank you very much. Thank you.
Your next witness.
Please let it be the TMZ witness. Your
Didn't quite
microphone.
get that. I'm sorry.
Mr. Depp calls Morgan Tremaine.
All right. Morgan Tremaine.
TMZ witness with Camille Vasquez as the attorney. TMZ witness, TMZ witness, TMZ witness.
Solemnly swear or affirm to testify truthfully in this case in penalty of law.
I hope they ask, what if any contact have you had from TMZ? Because wow.
Yes, ma'am.
Good afternoon, Mr. Tremaine.
Hello?
Would you please state your full name for the record?
Morgan Cliff Tremaine.
And what do you do for a living?
I produce esports events and design video games.
Why does everyone have great voices?
And in 2016,
There's
what
lots
did
of
you do for a
voice.
living?
I worked as the field assignment manager at TMZ.
What is TMZ?
TMZ is an entertainment news website and television show.
I'm fascinated.
And what were your responsibilities as a field assignment manager for TMZ?
I was the go-between the news desk in the office and the reporters in the field, which you might know as paparazzi.
Oh my God, I love the black fingernails.
Approximately how many paparazzis were you in charge of?
At the time, it was about 20 in LA, a handful, maybe 3 in New York, and then 1 in DC.
And what were your responsibilities specifically as to the paparazzi?
It would be to dispatch paparazzi to various locations based on tips or just direction dictated by having a list of sort of hotspots where celebrities would be.
How much do you
And how
spend
were
time
those tips
do you spend at
received?
Nobu?
They were received either through tips that we received
about
through
Mr.
our tip
Chow?
line or directly through news producers in the office.
And were tips frequently received directly from sources?
Very often the case, yeah.
And who were the type of sources that TMZ received
If
tips
Kris
from?
Jenner's name comes
They've
up,
received
it's
tips
center bingo.
from, oftentimes it would be publicists, managers, agents, or B-list celebrities.
They're going to ask about Laura Wasser too.
Lawyers?
And lawyers, definitely.
They're going to ask about Laura Wasser too.
How were tips verified?
Tips are verified by an extensive process. If they come in through our tip line, we have to verify who sent it, that they
I love the
that
inside
source is
TMZ of all of
truthful,
this.
and so they have to add their contact information, which is a field in that on that website for like name, phone number,
So nosy.
things like that.
And how long did that process typically take?
If we receive a tip through the tip line, it could take a while because that would need to be, if it was a tip, we would need to verify it. If it was media, such as photos or videos, that would need to be extensively verified to ensure that the person sending it is the copyright holder and that
copyright.
we would have the legal ability to air it and distribute it.
And while working for
keep getting
TMZ,
with
were
his
you
eyes
involved in
closed.
any assignments related to Ms. Heard?
I was.
What was the first time you recall working on an assignment related to Ms. Heard?
I believe it was May 27th, 2016.
And what was your role in that assignment?
For that, Ms. Heard was filing a restraining order at a courthouse in downtown Los Angeles. So I dispatched camera people to that location.
How did you know? How did you know? How did you
Under
know?
what
But
circumstances
how did you know?
would you normally send paparazzi to a courthouse?
Only if we had been informed prior. It's not by any means a celebrity hotspot. We would only
It's not-
ever
there weren't-
send people there if we had been tipped off that something was
There weren't
occurring and there was somebody
Paparazzi
present
there regularly during
And
the
what
time I
footage
worked
was
there, and I
TMZ
worked
trying to
there
capture
in
at the LA
well,
courthouse on May
before that.
27th, 2016.
We were trying to capture Amber leaving the courthouse and an alleged bruise on the right side of her face.
What
did
was
you
your
know?
team of paparazzi supposed to do while they were at the LA courthouse on May 27th, 2016?
Objection, Your Honor. Hearsay and foundation.
What were they supposed to do?
She's asking.
Did you hear the court? What was she supposed to?
I don't.
What was he supposed to
I'll overrule the
do?
objection at this point.
Do being
Go ahead,
the
Mr.
judge's
Can you
voice speaks
state the question
volumes.
again?
What was your team of paparazzi supposed to do while they were at the Los Angeles courthouse on
Do.
May 27th, 2016?
Being operative.
Their objective was to capture her leaving the courthouse, and then she was going to sort of stop and turn towards the camera to display the bruise on the right side of her face, the alleged bruise.
Did your team of videographers get the shot of Amber Heard?
We did.
How did you know she was
What is the
there?
difference between receiving a tip from a news producer and any other source?
If it's any other source, it would have to be verified by copyright. If it was anything that was received directly through a news producer, then they go through that process to verify the source.
Did you do anything to verify the tip on May 27th, 2016 related to Amber Heard?
I did not,
Why not?
because it had come directly from a news producer.
Does that mean it had been verified?
It means that they had verified that tip and deemed that it was credible, and therefore a camera person needed to be dispatched.
After May 27th, 2016, were you involved in any other assignments related to Amber Heard?
Yes.
Can you tell me about those assignments?
The next one would have been August 6th, 2016, where she was giving a deposition.
So what did you do in relation to that tip?
I dispatched camera people to a parking lot adjacent to a law office in which she would be arriving to, so we could get the footage of her arriving for the deposition.
Do you typically send paparazzis to parking lots of law offices?
No, not at all.
Did you get the shot of Miss Heard on August 6, 2016?
We did.
After August 6, 2016, were you involved in any other stories involving Miss Heard?
Yes, I was.
And what story was that?
On the 12th, we received a video depicting Johnny Depp slamming some cabinets that was captured by Ms. Heard.
And what day was that?
I believe that was the August 12th.
Of 2000.
I believe that was the August 12th.
The way my heart stopped.
2016?
Of 2016, yes.
Can you describe to the jury how you received the video on August 12, 2016?
Yes, the video was sent in through our email tip line, which is an email distribution that goes to all the producers and to myself as the field assignment manager, because it often included celebrity locations. It came in as I recall,
Objection, hearsay.
He's just describing how it came in.
I think he's about to reveal hearsay, Your Honor.
I'll overrule for now. We'll see where it goes.
Please continue.
So I received that email, and it included a link from some unknown Dropbox type public website in which it contained that
Objection,
video.
Your Honor, hearsay. He's about to describe what comes from the Dropbox website, and that's.
So far, he just said was a link from a Dropbox. We'll see the next question. Go ahead, next question.
So you received a link. What was in that link?
In that link was the video of Johnny Depp.
Video.
And you received this video in your inbox, correct?
I did.
What did you do once you received that video?
We downloaded it. We alerted the web editor who was sitting next to me at the time. We downloaded it, and then were instructed by the news producer to do what we call slap bumpers and a bug on it, which is putting the dun 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 at the beginning and end, and then putting a.
If I get copyrighted for that music, I
watermark over
swear.
it, which indicates copyright ownership.
Don't do it too well. Why do you have copyright ownership? Why do you have copyright
After you
ownership?
did that, was it posted?
Draco, why did you strike my
Where
videos?
was it posted?
It was posted to TMZ.com.
Did you do anything else related to Amber Heard on August 12, 2016?
Yes, I received a tip that Amber Heard would be arriving at LAX, and so I dispatched camera people to film that exit, or her arrival to LAX rather.
And why did you do that?
The airport.
I was instructed to.
Chat started calling him
How long
Draco.
does it take
I'm
to
here
post a
for it.
story after media's been received by TMZ?
After media's been received, it could take any length of time depending on who owns the copyright.
You guys, I see your stuff
How
about
does TMZ
the
obtain
text.
copyright over
We're gonna get
images
to
and
it.
videos?
I saw the super chats.
The only way to obtain copyright over media would be if we shot it ourselves, if it was sent to the tip line, source verified that it was from the original copyright owner,
calls for legal conclusion.
and then either purchased from that person or given to us. And then the third option would be if it was directly given to us by the copyright holder, like a direct source.
And how long does it take to copyright something TMZ has received through the tip line?
It can take a while because you have to extensively verify that that person owns the copyright. And then possibly, it depends also if you can even get in contact with the person because they might not be super responsive immediately via phone or email that they provided. And then potentially you'd have to enter a negotiation with our clips and clearances department to figure out the cost of that media.
How long does it take for TMZ to obtain a copyright over something received directly from a source?
Something in the realm of 15 minutes just to do what I described before, which is putting bumpers and plug on something. And
she's not going to answer the question. She's going to let the jury put it together with circumstantial
How much time
evidence.
had passed from the time you received the kitchen cabinet video to the time it was posted on TMZ?
About 15 minutes.
Damn. Let the jury decide.
Did any other tabloids other than TMZ post
Said it
this
without
video?
saying it.
No, leading and calls for hearsay.
Did any other tabloids?
Overrule.
Mr. Tremaine, go ahead.
No, they did not.
And why not?
Because it was a TMZ exclusive.
And what does that mean?
It means the TMZ owns the copyright to it. So it can't be distributed by any other media source without backlinking to TMZ. And they wouldn't be able to upload that media without getting a copyright strike.
Verified.
Have you seen the kitchen cabinet video that was played in this trial?
Verified.
How does that video that was played in this trial compare to the one you received on August 12, 2016?
When I had clicked the direct link that we received and watched the video in its entirety, it was much shorter than the video we had received, than the video that's been played in this trial. There was a bit at the beginning that was played here in which Ms. Heard is seemingly sort of setting up the camera and getting into position. And then there's a bit at the end where she's seemingly snickering and looks at the camera. That part was not present in what we received.
Did TMZ edit the video?
No, not even a little. When we receive something and it's edited, there's a clear indicator because there's sort of a journalistic practice that uses when there's an edit, you do what's called like a white flash transition, which covers the entire screen with white to very clearly indicate to everybody there was an edit here for time or whatever, just to make it a little more compelling. But in this case, it was not edited as I was staring at the machine that edited it and present for the entirety of receipt to publishing.
Present.
When was the next time you worked on an assignment related to Amber Heard?
It was, there was the time where we went to the airport. And then the day after that, because she had flown in for the deposition, because I think the first time didn't work out. So she was arriving again for the deposition in that same parking lot adjacent to a law office.
And what's that, August 13th, 2016?
That was August 13th, yeah.
And what was your assignment on August 13th, 2016?
To dispatch camera people to that parking lot at a specific time in order to film Amber Heard arriving for the deposition.
How did you know that tip was legitimate?
It came from a news producer.
While you worked at TMZ, did you ever receive any communications from Mr. Depp or his camp?
I did not.
Nothing further, Your Honor.
Cross-examination?
Yes.
Yes.
So how do you know what video was shown at this trial?
I was alerted by a friend that that TMZ was being kind of talked about in this trial. And so I had seen a clip of that.
So you watched some of this trial?
Correct.
Okay. When did you first reach out to counsel for Mr. Depp?
I believe that was 6 days ago. Whatever that date would be, I'd have to do that.
All right. And then you received a subpoena, I think yesterday, in care of your attorney, Cindy Hickox, right?
Correct.
Okay. And Cindy Hickox represents Christy Dombrowski, Kate James, Robin Baum.
Objection, Your Honor.
Were you aware
Calls
of
for
that?
speculation.
Overruled.
Were you aware of that?
No.
Okay. Now, if you don't have information that's helpful to this case, then you wouldn't be a witness, correct?
That calls for speculation.
Sustained. Next question.
I'm not aware.
Okay. You know this case is being televised, right?
I am aware that there are cameras.
And so this gets you your 15 minutes of fame, doesn't
Objection, Your Honor. Argumentative.
it? That question.
Overruled.
So I stand to gain nothing from this. I'm actually putting myself
at risk
in the target of TMZ, a very litigious organization, and I'm not seeking any 15 minutes here. Though you're welcome to speculate. I could say the same thing by taking Amber Heard as a client.
Oh shit!
A little argumentative, don't you think?
Oh, hardly. I find that to be purely logical. Thank you.
Now, are you aware that Mr. Depp's attorneys were well aware of the TRO that was going to be presented on May 27th?
Objection calls for speculation.
Were you aware of that?
Lack of foundation.
Can you restate the question?
Were you aware that Mr. Depp's divorce attorneys were aware that Amber Heard was going in to seek a TRO on May 27th?
I don't think I understand the question. I don't think so, no.
Okay.
It's kind of a
Do you
complicated
know whether Blair Burke, one of Mr. Depp's divorce attorneys, had a very close relationship with TMZ at that time?
Objection calls for speculation.
Overruled. If he knows.
I was not aware of that.
Okay. And when you said that you were dispatched twice, once to film Amber for the parking lot for the deposition, and then it didn't work out, and so you had to do it another time. How did you know it didn't work out?
Because TMZ.com posted an article saying as much.
Okay.
And I was not dispatched.
Do you know why the deposition did not work out?
I'd have to reference the article. I forget.
So do you know?
I didn't write that story. I wasn't involved in the actual journalism of that.
Which side? Do you know which side would have known or not known whether that deposition was going to work out? In other words, the people representing Mr. Depp or the people representing Ms. Heard?
I wouldn't know.
Okay. And then the video clip. You don't know who provided that, correct?
Correct.
Okay.
Not testifying to that.
I have no further.
All right, redirect.
What's going to happen?
Mr. Tremaine, why did you contact me in relation to this case?
Because you're bae.
I saw that there was a discrepancy with like the video that was shown here and the video that I know I had received.
Because they copyright struck Emily
interest in
Baker,
testifying.
and I was pissed.
I had reached out simply to maybe try to help with the timeline of things, or help with the case in any way, just by virtue of understanding the timeline of the stories that were published and kind of how that can be unclear. But I had no idea I'd be on the stand.
Nothing further. Thank you.
All right, sir, you're free to go.
Sir, you've slayed us all. We need a collective
another witness.
I can't handle another witness.
Mr. Depp calls Bryan Neumeister, Your Honor.
All right, Bryan Neumeister.
The same could be said of you taking Amber Heard as a client. TikTok has just lost their minds. I'm going to die. Who is this? Neumeister? Umbridge and Draco meeting in court, you guys. Thank you, chat, for being the best. Umbridge and Draco should be on the same side, but not in this.
Mr. Neumeister.
Good afternoon.
Could you please state your full name for the record?
Please be a metadata expert.
Norbert, Bryan. I go by Bryan. Bryan.
Proper way to spell
Neumeister. Neumeister.
Have you
Do you have a
testified as
Post-it?
an expert in digital forensics before?
Yes. And what people sometimes don't understand is only about 2% of all cases go to trial. So 98% of the time, you're actually just doing the forensic work and getting it to the parties. And as we say, data is data. It really doesn't take a side. We don't have a narrative. So very often it's just providing the data for the attorneys to work with or the parties.
Facts. We love data.
Have you ever been excluded from testifying as an expert regarding any work that you performed?
No, but you have to take into account that sometimes there might be curbs put on what, for example, in this trial, there's certain boundaries. Or if you're working with a proper
evidence
or with a attorney that is not very familiar with electronics. and the thing is, again, they teach Latin in law school, not binary. And binary is the universal language these days. So sometimes in the legal system,
they don't teach
it's
digital.
a little bit hard to explain to attorneys what exactly we're doing. So we try to break it down and make that work.
Attorneys don't know tech.
What is digital forensics?
A lot of them don't.
Digital forensics is anything that you are using, like your television set, your cell phone, your computer, anything that runs off of binary information that has coding in it. But I got started because very often as working in a helicopter, we'd be asked to work for a police department, a rescue or a chase or whatever the situation might be. And since I'd be videotaping it, they would ask me to break it down frame by frame and analyzing it using what's called a time-based corrector in the day. And so word got out that I could do unusual things because I'm pretty good with machines. And
there's a nerd. We need him. Help.
It just ended up, more and more people started calling, and it just became a full-time job.
Are you a member of any professional associations in your field?
Yes, the IEEE, which is the International Engineering Society. And the reason I belong to that is about 40% of the world's white papers on electronics are published through IEEE. So they have a huge database on anything from microwave technology to telephone transmission technology. Anything that I might work with, they might have a white paper on it. Also, with the Audio Engineering Society, AES, I'm a member of that. I lecture to AES. There's a few others, but again, they're just mainly to have a repository of information.
Your Honor, at this point, I'd like to attend.
I'd pay for those CLEs.
As an expert in the field of digital forensics.
Are you speaking at any conferences?
No objection. All right,
Can you be at the ones in Vegas? I like to go there. Can we just
Mr.
do?
Neumeister, turning to the work you've done in this case.
Oh my God, I love Snubs. I need to have her on.
I was asked to analyze the photographs of reported injuries.
I'm nerd
to
hyped.
Ms. Heard.
And what was the purpose of that analysis?
To authenticate photos or to review and see if they were altered in any way.
What did you analyze to reach your opinions?
Well, I analyzed groups of photos that were submitted by Ms. Heard's legal team. We would take a look at that to see if there's anything out of the normal for the type of camera being used. In other words, would there be above a certain percentage of chroma? And chroma means color saturation.
Objection, Your Honor. Outside the scope, we can approach.
All right,
like,
you want to approach?
What's outside the scope?
Hark the lengthy sidebars read. The court. Yes, sir, Mr. Murphy. So this is what was part of the brief, Your Honor. He's talking about these technical elements: chroma, chromatic, values, pixels, and none of these things appear in the expert disclosure. And my understanding is that it's also beyond Your Honor's ruling this morning about EXIF metadata. The court. Okay, Ms. Liquor-Rose. So he is talking the things he looked at, and it's, I guess, talking about the things he looked at, and it's the process of his analysis. The court. Ms. Liquor-Rose is right, but there is, I'm sorry, while I find his designation. So you can see here, Your Honor, and his designation goes through. These are the vector scopes and the chroma stuff that he's talking about right now. And this is where it's disclosed in his report, that this was something that he looked at when he was analyzing these photos, Mr. Murphy. Your Honor, there are little color schemes there. He has never explained what those are about, what they mean. He doesn't talk about, but you know that you would object because I remember his testimony was very limited. And this Murphy dude, he's like hardcore. He was objecting like constantly from what I remember. He doesn't talk about any of that in his disclosure. They literally have a picture and he's not testifying about what it means for the first time. That's the basis of my objection. That's outside the scope of the disclosure and outside the scope of Your Honor's ruling, Ms. Liquor-Rose. This was provided prior to his deposition. They had an opportunity to ask if they weren't sure what these things were or what they meant. The court. Is it in his disclosure? I guess it is the question. Ms. Liquor-Rose, this is the disclosure. The court. This is the disclosure. You're saying that the pictures are there but didn't explain it? Mr. Murphy, the testimony about what it means is not stated in this disclosure. And as the case law in the brief said, Your Honor, she's saying, quote, had the opportunity in deposition, end quote, and the case law from the brief is crystal clear. That is not an adequate response. It has to be in the disclosure. Court. I'm going to sustain the objection. Ms. Liquor-Rose, okay, thank you, Your Honor. Back to open court.
Neumeister, based on the analysis you performed in this case, have you formed any opinions?
Pardon?
Based on the analysis you've done in this case, have you formed any opinions?
Yes.
What are they?
Well, three basic ones. One is quite a number of the photos had been through a photo, at least one, possibly two.
Objection, Your Honor. Foundation, which photos is he referring to? We have to go through this one by one.
One's in evidence. Mr. Neumeister, in terms of the photos that you looked at and that you formed opinions about, do you understand if they've been submitted as evidence in this case?
Yes.
Okay. And
she's
what
just going
conclusions have you formed about
rebound.
those?
Same objection, Your Honor. That doesn't cure the issue of the objection. We have to go through this. Which photos is she talking about? Which one's in evidence? What exhibit numbers? That's the basis of the
We're
objection.
talking generally about opinions right now, Your Honor.
Yes, we
We're
are.
going to get into some specifics.
Bro, you sound a little panicked.
Specifics. Okay.
It's like when they were trying to object, when Depp's team was trying to object to Heard's expert. It's like, why are you objecting at this point? It's not a good look. So she's going to just be like, it doesn't cure the issue. Yeah, they're just repeating the words back. She should have said, what, if any, opinions do you have?
Mr. Neumeister, have you prepared a demonstrative that aids in your testimony with respect to any of the photos that you looked at in this case?
Yes.
Go back to the opinions. We didn't get there.
Pull up
Wait. Close the loop. Close the loop.
If I might approach.
He didn't talk about his opinions yet. Wait, don't forget to ask about his opinions. Somebody give her a Post-it.
Your Honor, I would, again, object. We can approach to discuss it.
Approach.
Stop approaching.
So how about like Nutcracker theme? Here comes a sidebar. Here comes another sidebar. It's another sidebar. Yet another sidebar. Okay, that's insane. The court, yes, sir, Mr. Murphy, these photos are in the disclosure. They are not in evidence. There's no foundation for him to testify about them. The court, is this part of the evidence? Ms. Legros, so this is the issue, Your Honor, we discussed earlier. The court, right? Ms. Legros, the photo that's in evidence is a picture of a photo. Yeah, problematic. Totally. I think. The court, right? Ms. Legros, but you, the court, let's start with that photo so we'll have it and it's in evidence. And then then we're going to go from here. Mr. Murphy, I'm saying, Your Honor, hi. That's what it looks like if you can see this cursor. Let me make sure. Okay. It looks like hi. AHA1, I don't know. 1824, AHA 520. What the heck is with these initials, though? That's brand new. Oh, it says none of these are in evidence. I guess that's why. Yeah, we've not seen any exhibits with that type of labeling. I mean, I guess it's like Amber Heard. I don't know what the last A would be. Anyway, we've not seen any three-letter exhibits. None of these are in evidence, therefore he cannot testify. The court, I understand it's part of his expert testimony. He's going to testify to it. As long as he directs it to something that is in evidence, I'm going to allow him to testify to this, Mr. Murphy, in my right. But he cannot testify to this because it's not in evidence is my other argument. You just said that, and she just shut that down, dude. The court, I understand what your argument is, but I'm allowing him to testify to this after we have connected it with something that's in evidence, okay? Thank you. Back to open court.
Pull up Defendant's Exhibit 178, which has been admitted into evidence.
Thanks, Tom. Question, if the following texts aren't literal, why did he say he didn't write them?
Does this photo appear to be one that you have analyzed as part of your analysis?
We're going to have to talk about the text.
There were many versions of this
They
photo.
were incoming, not outgoing.
I would say there were dozens of different versions with different chromatic values.
Dozens of versions of
file
this?
sizes, different physical sizes. Some had been through Photos 1 or Photos 3, which are photo editing software programs.
She's like, hey, Needlehoff, you asked for this.
This time I'd like to show Mr. Neumeister's demonstrative plaintiff's exhibit 13.
Needlehoff, you asked for this. You asked for us to go photo by photo by photo, so we're going to go
photograph in 178 is
photo
not in
by
evidence.
photo by
I mean, the
photo.
photograph is in evidence. None of the photographs he wishes to show the jury are in evidence.
1303 is in evidence over objection. I'm not in evidence, I'm sorry, as a demonstrative. Just as a demonstrative. I'm sorry. Could we go to publishing 1303, please?
Ooh, demonstratives.
And Mr. Neumeister, what does this demonstrative show about the photos that you analyzed?
Well, they appear to be similar. However, if you look below at the file sizes, one on the left is 712 kilobytes. The one in the middle is 489 kilobytes. And the one on the right is 524 kilobytes. Now, what's unusual about that is these photos will not digitally fingerprint with each other. They won't hash. In other words, forensically, they won't
hash.
But the thing is, you could say, well, it was sent through email. Maybe it's a different size. The file sizes, for example, would be possibly You can select the file size you send a photo, but there's no way to authenticate any photo that was presented in the way the evidence was collected.
And so what conclusions do you draw from that?
Well, this is just 3 of many of the same type of photos that are all different sizes and have different chromatic, which means color.
Objection, Your Honor. We just had a ruling on this.
All right. Sustained objection.
Mr. Neumeister, stick to your opinions that relate specifically to what you analyzed about the EXIF data, please.
All 3 of these
He's
photos
not allowed
had
to
to
talk
go through
about
some type of transformation to change sizes.
The jury is going to pick up on what he's saying is the problem. And they're trying to prevent that from happening, which is their job to do.
Photos 1.5 and Photos 3.0 earlier, I believe.
Photos.
What is that?
Photos 3 and Photos 1.5 are editing programs that Macintosh or Apple put out with their product. It's for editing photos. In other words, you would put a photo in and you would change the colors, or you would crop it, or you would clarify it by enhancing, for example, the sharpening.
You could pinch zoom.
Or you could darken it. But when you save a photo through an editing program, you leave a mark on the EXIF data.
And what is the EXIF data?
The EXIF data is the data that is embedded in a photograph that tells you a lot about the photograph. And again, in the early days when we were using film cameras, you would write down the f-stop, which is the light setting. You would write the type of lens you use, the time of day, the type of film stock, the type of filters you're using.
So you know.
Now with digital cameras, that's done electronically, and there's about 1,000 lines of code, of which 50 are probably important, that tell you what the camera was doing.
So what's the significance of EXIF data in your photo analysis?
Well, in this situation, I can see that normally where the operating system of the camera would be, which means the version that of operating system the phone is running on, it would normally say something like, I'll just throw out an arbitrary number, 9.1.3 operating system for iOS, which is Apple's iPhone operating system. Instead of saying that, it says software Photos 3.0 or Photos 1.0. That means that the photo had to be rendered, which means composited together in an editing program.
Did you prepare a demonstrative that shows some of your analysis of some of the EXIF data of the photos in this case?
Yes, I did.
Okay. Can we pull up 1304, please? Your Honor, may I approach?
All right. So they're approaching about a photo. They're going to go through and through and through these photos. He's like, let's go one by one. He's like, fine, let's go one by one. Let's go one by one through the demonstratives. Thank you so much.
I'm sorry, Your Honor.
She wishes to publish it as a demonstrative.
I don't know why Elaine does that. Sometimes
no objections demonstrative.
on cross, the question sometimes matters more. Hello, Jen Gerard.
Just as a demonstrative.
On cross, sometimes the question.
And Mr. Neumeister, are these images in this demonstrative excerpts from the report you prepared in this case?
Yes, they are.
And what do they show?
On this particular photo and on all of them, it shows the first few lines of EXIF data, the ones that would be most important for this photograph. So, for example, things you would see, the very top line would be the make of
the jury the jury does not get the demonstrative
6. And then the resolution is 72 pixels per inch, 72 to 1.
That's a good question. Thank you.
And instead, where it says software on a normal iPhone photo, it would, instead of saying Photos 3, it would say the software version, for example, 9.3.1. And then you've got the date and the time of the photo below that, which is really easy to change in an EXIF editor. And below that, you have things like the like the flash. You've got the exposure type, how long the exposure was. So what you just highlighted there again was the date and time. So that's universal time code minus whatever area you're in the world.
Anything else you want to show us with this demonstrative?
Yeah, just below that, if you look, there's some things that would say, for example, a directly photographed image. That is not going to be necessarily accurate once it's been through an editor. It will always pretty much say that. When you're looking at scene type or auto exposure, These are things that that really don't matter all that much. What would matter is, for example, if you're taking notes, the focal length would be important. The pattern of metering, things like that to a photographer would be important. And again, this is just a few lines, and the reason I put these in there was just to explain a bit what EXIF data is. The actual thing I'm trying to point out is the fact that instead of an operating system, it shows the editing program that was used on this photo.
Are there additional photos that you did this analysis for?
Yes, many.
Can we scroll to the next page, please, Tom?
Is
there anything about
interesting.
this photo that you noted as part of your analysis, Mr. Neumeister?
Yes, again, it's right there, you've got photos 3.0 on that particular photo. And I think, we've pretty much covered what the stuff is. But again, you see the photos 3.0.
So they're coming out of editing programs, not directly out of the camera.
And again, this could not come out of an iPhone this way. This would go into a computer, be edited and rendered through the photo editor. And this would then be embedded in the EXIF data.
Do you have
Emily,
other
tech
photos in
issues.
this demonstrative?
Yes.
All right, can we scroll to the next page?
Same thing. You've got up here in the top, you've got the photos 3.0, and this is throughout a lot of the photos that are in evidence or versions of the photos in evidence. We're gone through photos 3.0 or photos 1.5, an earlier version.
The jury sees the demonstratives. The jury sees the demonstratives as we do, but they do not get them back in the room.
Same thing, photos 3.0.
I imagine that they are sitting
in
up and
photo,
taking notes.
Editing app, you can do an awful lot of things. So when you see photos 3.0, first of all, it's not anywhere near an original. There's going to be compression.
Not anywhere near an original.
Because it's a JPEG file.
There's going to be compression.
I'll sustain the objection. Next question.
Can we move on to the next page of this demonstrative, please?
There are some tight rulings on this, it
Same
seems.
thing.
Interesting.
You've got the photos app.
Okay. And I believe there's one final photo in this demonstrative. What about this one?
Again, if you look up there, it says photos 3.0 on that particular photo.
All right. We can take that one down. Your Honor, I have a little bit left. I don't know if you wanted to.
All right, you want to take our afternoon? Let's go ahead and take our afternoon recess. Just do not discuss the case and don't do any outside research. Thank you. Is it a jury?
Yes, yeah.
May we approach for just one moment?
Okay.
Goody. We've now approached.
It's another sidebar, sidebar time, sidebar time, sidebar time, time for a sidebar. Boo-loo-loo-loo. Nutcracker again. That's the, what is that? The Sugar Plum Fairies, I believe? Dance of the Sugar Plum Fairies? The first one, the one from last sidebar was the Waltz of the Flowers. Okay, the court. Yes, ma'am. Miss Lickrose. So sorry, Dana, understanding your ruling on the chromatography issue, I just want to, if it would be all right, instruct the witness before we go on to the next. The court, I know, we just need to talk about it and tell him. Miss Lickrose, just to tell him I don't. The court, do you have any objection to that? Mr. Murphy, if that's all she's saying, and that's yes, no objection to that. Back to open court.
I wonder if they're going to try to talk again about what they're allowed to get into with this expert or just seek further clarification.
Mr. Neumeister, do you have another demonstrative prepared that shows
The
a
jury
photo
might
with
find that
exit
too.
data reflecting that it was saved in Photos 3?
Correct. Photos 3, yes.
Your Honor, we have a video of these photos, and we're happy to play it once so that counsel can review.
There's a
If that's
video
all right.
demonstrative?
Here comes another sidebar. Here comes another sidebar. Tray pack from the Nutcracker Suite. Miss Lickrose, you don't even want to see it first. Mr. Murphy, I know what it is. I know what the video is, the court, okay? Mr. Murphy, the two photographs in the video are not in evidence, Your Honor. The court, if they're not in evidence, it doesn't come in. Miss Lickrose, Your Honor. Mr. Murphy, it's, and again, we have these funky exhibit numbers / with letters, ALH 57 and ALH 58, right? Miss Lickrose, correct, but they, oh, and another funky one, DX 708, weird, is, and it's the same photo. Mr. Murphy, it's visually the same. photo, but it's not the same. Ms. LaGrose, it's consistent with your ruling, Your Honor. The court, I've already taken care of that argument. So what part of the video doesn't have a video? Ms. LaGrose, so he has different versions of the same photos. One that has been through a photo editor, the Photos 3 app, and one that does not indicate that it's been through Photos 3. So it just shows back and forth between the two versions of the photo, Mr. Murphy. And the basis of my objection is that neither of the photos are in evidence. That's, well, it's beyond the scope of Your Honor's ruling, I understand that. But again, they're showing, I would absolutely object to it being admitted as an exhibit at trial because they're not in evidence. I will still object as demonstrative, but I'm not sure if Your Honor is already going to rule against me or not because, again, the photos are not in evidence. The court, but it's the same depiction on a photo that's in evidence. It's just not Ms. LaGrose, and I'm happy to pull up the defendant's exhibit that is the same first. The court, all right, we'll see that first. That's fair. Ms. LaGrose, yeah. The court, and then I'll allow it, okay? Ms. LaGrose, and just to be clear, too, Your Honor, on this demonstrative, it says DX 1322 because there's even yet another version that he looked at that was on the defendant's exhibit list at 1322. He didn't know, obviously, which one was coming into evidence. And so when the court, so what are we going to, Ms. LaGrose, I can do both, but defendant's 1322 is not in evidence yet. Defendant's 708 is. Actually, I remember talking about that exhibit before. Mr. Murphy, I would object to the video. I know what it is. It says at the bottom, quote, defendant's exhibit, end quote. It's going to be incredibly prejudicial for them to use a video that has a defendant's exhibit number on it. I don't really know why that would be the case. That cannot be shown to the jury. Ms. LaGrose, can we cover it up? The court, yeah, you can cover it up because it's just a demonstrative. Mr. Murphy, if they can cover it up, yes. The court, if you can cover it up, you can show it. Ms. LaGrose, yeah, let me consult with my tech. Okay. All right, we took care of that, Your Honor. The court, thank you. Ms. LaGrose, may we publish or would you like to see it? Mr. Murphy, I'd just like to see it first, Your Honor. Ms. LaGrose, okay. The court. And which demonstrative is this going to be then? Ms. LaGrose, this is Plaintiff's 1305, Your Honor. The court, all right, thank you. Could you play it? There you go. Mr. Murphy, subject to Your Honor's ruling, that's fine. Back to open court.
The Molly texts were incoming. I saw that. I wonder if it will come up.
Mr. Neumeister, we're going to go ahead and play the demonstrative that you prepared. And then after the jury's had a chance to see it, if you want to explain to them what the demonstrative shows, that would be great.
Yes, ma'am.
I can't wait to see the demonstrative. What's going to happen? Oh, they're running it through iOS and Photos 3. Can we do that again?
Mr. Neumeister, what was depicted in that video?
The same photo treated two different ways. One was marked with the original with the operating system from an iPhone, which is iOS 9.3.1 on that particular photo. The one that says 9.3.1, there is a graphic below indicating it. The second photo is marked Photos 3, and it looks quite a bit different.
And
I'd say,
just, Tom, could we pull up defendant 708?
Yeah, I think Runkle did a video on this. I'm going to have to link Runkle of the Bailey's video. Runkle did a video on this.
Mr. Neumeister, does the image in defendant 708 appear to be similar, same photo as what was depicted in your demonstrative?
It's the Photos 3.0 edit version.
Thank you. We can take that one down.
The Photos 3.0 edit version.
Mr. Neumeister, have you also formed an opinion about defendants exhibits 712 and 713?
Correct.
Did you prepare a demonstrative that shows?
Your Honor, exhibits 712 and 713 are outside the scope of disclosure.
What? I can show you if you'd like, Your Honor.
Here comes a sidebar. It's just another sidebar. First movement of the Nutcracker Suite. Ms. LaGrose, so this one is also defendant 712 and defendant 713. Mr. Murphy, I'm sorry, I don't understand Your Honor's ruling. If I could maybe have a continuing objection to the court. You just want to do a continuing objection, or sorry, you just want to do a continuing to the Mr. Murphy, yes, the court. Are you going to do it for each of these, or is this the last one? Ms. LaGrose, this is the last one. Mr. Murphy, just to make the record, the court, okay. Mr. Murphy, a continuing objection to any photographs not specifically in his disclosure, then I don't have to keep doing this. Yeah, I think we would all appreciate that. The court, okay. Ms. LaGrose, I think it's specifically in his disclosure, but thank you, Your Honor, the court. All right, back to open court. Yeah, especially because you know what? I'm going to run out of freaking Christmas songs at this rate. So, yeah, let's minimize that. Minimize the approaches.
Could we pull up Plaintiff's Exhibit 1306, Tom?
Tom, like I said before, can we just
And Your Honor, this is another video that...
more videos.
Pause that, please. This is another video that we prepared. It's not published yet, so I'm happy to play it once through. So that
Play it once through. This is 1306.
All right. I guess they're playing it through for the defense to view before the jury views it, which is appropriate.
Are they, I'm sorry, Your Honor. What exhibits are these that are in this video? It doesn't say. I don't know.
Yeah, I tried to get my question out a moment ago. Defendant 712 and 713, Your Honor.
Yeah, you objected to it. So we were trying to establish that, and then you objected, and we ended up at sidebar counsel.
1306 then will be demonstrative as identified in the public.
Runkle saw this coming.
And if we could go ahead and play that, please. Tom?
Are they overlaying them?
And Mr. Neumeister, what's your, what do we see here in this demonstrative?
So they're the same picture?
There's Exhibit 712, I believe you have. I'm not sure the date's number, 712 and 713. They're two separate exhibits, except it's the exact same photograph that's been,
that
one's
wasn't
been
the
edited,
testimony.
one hasn't. Or I can't say that one hasn't, but the colors have been modified in an editor.
Objection, Your Honor. Beyond the scope of your ruling, talking about colors. It keeps happening.
Thank you, Your Honor. Mr. Neumeister, did you form an opinion in this case about the authenticity of the photos that you reviewed of Ms. Heard?
Well, first of all, nobody can identify the authenticity of the photos, of any of the photos. Marked photos 3, photos 1, or just marked with the operating system number. And the reason is the manner of collection. So
there we go.
These came from an iTunes backup. Now, what is an iTunes backup?
Objection, Your Honor. I'm sorry. You're beyond the scope of your ruling. EXIF metadata. This keeps happening.
Your Honor, may I approach on this one?
It's time for another sidebar. It's time for another sidebar. Boom, 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 boom. That would be the march from the Nutcracker Suite. Okay, Ms. Gross, I understand that your ruling is that he could opine as to the lack of authenticity or the lack of an ability to determine the authenticity of the photos, the court. And he's already testified to that, so what's Ms. Gross? Yeah, so he's just explaining how he knows that. I mean, he has to be able to get the basis for his opinion, Mr. Murphy. He can only do that based on the metadata. What he's doing now is well beyond, he's talking about forensic imaging process, not the actual metadata. And that is beyond the scope of Your Honor's ruling, and it's highly prejudicial. I keep having to do this. I keep having to do this in front of a jury. Wow, this dude, I don't know. I feel like he's got an attitude. I'll be interested to see when I get to the video, because I'm reading this first. I don't remember anything about him because this is like his one day. But boy, he's maybe he's trying to just make sure he's very memorable on his one day. I keep having to do this in front of a jury when Your Honor's ruled already. I mean, I don't know, it just seems kind of rude to me. Ms. Gross, I don't think it is beyond the scope of your ruling, Your Honor. He disclosed the issues with the authenticity of the documents. The court, I've already made a ruling on it, though, so I'm going to sustain the objection. He already testified that nobody could. Ms. Gross, okay. The court, if you want him to explain that without going into the Mr. Murphy, he can only rely on the metadata. That's it, Ms. Gross, okay. The court, that was Your Honor's ruling. That doesn't make any sense. That must be Mr. Murphy, unless Judge A is talking about herself in the third person, which honestly, she could be going so crazy right now with all of this nonsense that maybe that's what's happening. Ms. Gross, all right, that wasn't my understanding, so I apologize. Thank you, Your Honor. Back to open court.
There is a ruling here, and I don't know exactly what it was, that is deeply constraining this expert, which is interesting, but there are issues with metadata in this case. We know that from prior motions in this case, but it is good for Team Heard. The more they can constrain this witness, the better off they are. This is probably the most jovial we've seen this side the entire time.
So, Mr. Neumeister, without going into the specifics, what's your opinion about the authenticity of the photos you received from Ms. Heard?
Based on the way they were collected, there would be
Objection, Your Honor. We just ruled on this.
I framed my question, I thought, Your Honor, to avoid the issue that you're concerned about. Mr. Neumeister, what's your opinion about the authenticity here?
There's no way for any forensic expert to validate any of these photos.
Thank you very much. No further questions.
There's no way to validate these photos. If they open the door on cross, that'll be interesting.
Your only degree is in political science, correct?
42 years ago, correct.
Wait.
And you have no degree whatsoever from any academic institution in computer science, correct?
This is the direction you decided to go on cross,
you
my
have no
guy?
certifications in computer forensics, correct?
That's correct.
Oh, boy. When you can't attack the facts, attack the credibility. All right. This is
from the opinions you've testified today.
Oh,
You
wow.
relied on no data except for the embedded EXIF metadata to support those opinions, correct?
Incorrect.
What other data did you
he's
rely
gonna
on
open
for
the
the
door.
opinions you've testified to today?
The
I was
chroma.
trying to explain that you kept it.
What other data did you rely on for the actual opinions you've been able to testify to today besides EXIF metadata?
The type of extraction that was performed? You're asking the question.
For the actual opinions you testified to.
That's
That is
what
I would
he
use.
relied
I would
on.
also use vector scopes.
Objection, Your Honor. That was not
It's your
responsive to my question, Your
question.
Honor.
If you want to approach.
It's absolutely responsive to your question. You asked, what else did you rely on? And he's literally telling you what the fuck else he relied on.
Sidebar time, it's 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 sidebar time. That's from the, I think it's the reflutes movement of the Nutcracker Suite. Not the best one of the bunch, but again, with all these approaches, we're digging deep here. All right. The court, if you're going to ask him how he devised his opinions, even ones that aren't in court, you didn't let him explain it because you said, quote, devised, end quote. Mr. Murphy, the opinions he testified to, the court, right, and he testified to it, and he's going to get into why he came to that conclusion, which I sustained your objection. But now you asked him, so now he gets to answer it. Mr. Murphy, understood, Your Honor. Ms. Lickros, thank you, Your Honor. Dr. Open Court.
Sir, you can answer that question.
Yes, you can.
Pardon?
Answer that
You can answer
question.
the question.
He asked it. He
Can you
stepped
restate the question?
step in your own poo. He doesn't want to.
I don't recall
Read
the
it back.
question, Your Honor. We can move on.
No,
Your Honor,
read
maybe
it
you
back.
could have the court reporter read it back.
Yes.
They could redirect.
No. Read it back.
What was the question, Judy?
Now he's trying to avoid it because he lost the ruling. Ha!
I believe the question was, what methodology did I use to make my findings?
Judy's voice has changed.
Sorry.
Is that correct, Judy? Okay.
She had to write down, y'all. You have to deal with the grumpy that you stepped in, my guy. Yes.
That's fine. Okay.
So when you're analyzing video or photo, in this
Objection to video, Your Honor. That's beyond the scope.
You asked the question.
All right. If you
Sir.
could just answer the question, sir.
when you're analyzing a photo, a digital photo, you look at the EXIF data, you use a vector scope, you can use a Pantone chart if that's available.
He opened the
That should be
door and
done,
he is
but that's a
pissed.
whole different deal. If I go into that, you'll object to it. So you'd also use a waveform scope. You would use an RGB parade. You can use a histogram, though in this case, it's not really all that relevant.
You are not offering any opinions that any photograph in this case was intentionally modified by Ms. Hurd, correct?
I'm just stating the fact that photographs were modified.
But so you are not offering any opinion that any photograph in this case was intentionally modified by Ms. Hurd, correct?
That's correct.
Who else would have done it is the conclusion.
Can you please pull up Exhibit 170A?
I would have stopped there. I would have stopped there.
Is that Defendants 170?
Defendants 170, yes, Your Honor.
I think I would have stopped there. It might have because
So you offer testimony regarding this photograph.
he
during
opened the
direct
door,
examination, right, Mr.
redirect
Neumeister?
it.
There's
That's a yes or no, sir.
On redirect, they should be able to get into it more.
a photograph like that. I don't exactly remember the photograph. There's so many different versions of this photograph, but yes, I talked about that particular photograph.
But on, do you recall being deposed in this matter?
There are so many different versions.
You were under oath?
Yes,
And that was on April 6, 2022?
I believe.
Can I approach Your Honor?
Yes, sir.
Did you bring enough copies for everybody?
Thank you.
Wow. Wow, 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 wow.
I'm still shook that he opened his own door. He was like, what? He fought so hard to keep it closed. And I was like,
Neumeister, if you could please turn to page 76.
I'll talk about that.
And when I say pages, those are the little pages in the 4 boxes, not the page at the top.
That's actually a very helpful clarification. We still don't know what the name
page
is.
76, line 3. You were asked on April 6th, anywhere in your April 1st, 2022 expert disclosure, do you offer any opinions regarding the authenticity or lack of authenticity of the specific photograph produced as ALH 7101?
A different
response.
question.
Can I refer to my report to see if that specific number is in the report? Yes. Response, not that specific photo. I just grabbed 3 out of the batch. Do you see that?
Yes.
That sounds like there's also missing
Please pull up Exhibit
context.
517 or Defendants 517.
Thank you.
All right.
You are not offering any opinions regarding this specific photograph, right, Mr. Neumeister?
That's correct. My testimony has been limited here.
Interesting. And the jury just heard that.
And you are not offering any opinion that any photograph
Don't you have questions
was visually
now?
doctored by
I've got
Amber,
questions.
correct?
Not by, I can't put the person
At the
who
keyboard.
might have done it.
Well, you're not offering an opinion that a photo was visually doctored by anybody, are you?
I'd have to see each photo. There's no way to authenticate any of these photos based on what I received.
Oh my.
So you testified about photos 3. Do you recall that
He
testimony?
shaded this dude about his education, and now
Photos
he's
3
trying
is
to
a
tango
photo
with
editing
him.
and photo sorting application, correct?
It's a photo editor and photo sorter, as are a number of editors.
So when you reference Photos 3.0, you never did any independent strike that, Your Honor.
Technically, it's
So
a drawing counsel.
when the software of a photograph in the EXIF metadata says Photos 3.0, that could be just saying that the photo was saved in Photos 3.0, correct?
Unless you looked at a scope of the photos, that would tell you that the parameters of the photo do not meet that of the cell
As
phone that
I
it was
did
taken on.
here.
But the notation Photos 3.0 in the
As I
software
did
EXIF
here.
metadata, that does not in and of itself mean that the photo was edited in Photos 3.0, correct?
It means that you've recompressed the photo and it will not hash or digitally fingerprint with the original photo.
But it does not mean in and of itself that it was visually edited in any way in Photos 3.0, correct?
Again, it's not the same photo because you're using lossy compression once you save it. So you have changed the
He
photo.
attacked this dude's credibility and now wants to play, and that's what's going badly here. This is why you catch more flies with honey, man. You don't go
So
in
if you
that
could please
hot
turn
on an
to
expert
page 233
who,
of that
you know,
transcript.
may or may not have more experience than the years you have. It's just,
And
it's not a
line
good
20,
idea.
You see question. When it says exit software, okay,
Oh yeah,
Photos
Depp staring down the
3.0
lawyer is also not a good
on to
look.
234. That's just saying it was saved in Photos 3.0, right? Response.
I don't love
Saved in
Depp staring down the
3.0.
lawyer
That's
either.
correct. Question. That notation in and of itself does not mean that the photo was edited in 3.0, right? Answer. That's correct. Did I read that correctly?
Yes.
A file has not changed visually just because it has been processed through Photos 3.0, correct?
That's incorrect.
Can you look at page 128 of your deposition, please?
Sure, let's go page by page. This is going to be so interesting.
Bottom, line 20. Question, you see, question, but the file changed visually just because it is.
Oh, I love
it has been
cross-exam. It's always
processed through
fiery.
Photos 3.0.
Love.
Answer, you know, obviously I understand what you're asking. From a technical point, yes, because of the compression. You get down to scopes and artifacts, yes, it has changed. Was it intentionally changed? We don't know. In other words, did somebody save it in there and just save the photo? We don't know. Did I read that correctly?
That's
correct.
different than what you just
That was my question.
asked. When you ask a question and then try to impeach with a different fucking question,
So if
it
the
doesn't
EXIF metadata
work like
software field lists the software as iOS, you have no reason to dispute that, correct?
Incorrect.
Well, isn't data data? That's what you testified to, right?
It's very simple to modify EXIF data. Did
Did you find any evidence in this case of actual modification of EXIF metadata?
You can't authenticate any of these photos because of the way they were.
That wasn't my question, Mr. Neumeister. Did
Yes,
you
it
find
was.
any evidence of any modification of EXIF metadata of any
They opened
photograph
the door.
in this case?
You didn't listen to my answer. My answer is there is no way to know because of the way the files were presented.
So you found no actual evidence, correct?
That no one could.
I'm not asking
way.
if anyone else could, Mr. Neumeister. I'm asking, did you yourself you found no evidence of any modification of EXIF metadata of any photograph in this case, correct?
Now, I understand trying to control the narrative, but there's no way to answer that scientifically because given the evidence we were given, there is no way to positively or negatively answer that. It's not a question that can be answered.
It is a question, Mr. Neumeister. The question is, did you yourself?
He said it's not a question that can be answered.
You found no affirmative evidence of any modification
of
software,
Bring the asked and answered.
Metadata,
Bring the asked and answered.
Photograph in this case, correct?
Bring the objection.
You found no actual evidence of that, did you?
Objection. Asked and answered.
No one could tell either way because.
I'm not asking about anyone else, Mr. Neumeister. I'm asking about you.
Objection. Asked and answered.
Did you found no evidence of that, did you?
Objection, Your Honor, asked and answered.
Thank you.
He's not answered what he found, Your Honor.
Overruled.
There's not a way to answer that the way you're asking the question. You have to restate it. You're trying to control
Your Honor, he's not
narrative.
responding to the question.
Could you just answer yes or no, sir, to the question?
I can't.
It's not a yes or no question.
Did you, yes or no, you found no evidence of EXIF metadata modification of any photograph in this case, correct?
The limit does not exist.
Incorrect.
The limit does not exist. The limit does not exist. Amber Heard's dude is struggling with this witness, though.
The metadata of all photographs.
This witness is not answering either.
That Ms. Heard has identified as her trial exhibits do not indicate that the photographs went through a photo editing application, correct?
Well, first of all, that's not a yes or no question because a lot of the exhibits that you have put up, they're not photographs. They're screen grabs, and they've been changed from Apple format, which is JPEG, JPEG, to a JPG Microsoft format. So you have actually changed the exemplars. You've changed the data yourselves. We actually ran EXIF data on some of your own examples that you've entered in the evidence. They are not photos from an iPhone. Those were edited on a PC.
I'm going to hand up a page from your disclosure.
This, I'm going to have to go back and look at the motion for sanctions. I'm imagining this is the guy from the motion for sanctions that was losing his mind over the evidence not being turned over the way the court ordered it to be turned over. But this lawyer said, you don't have any education outside of a degree in political science 40 years ago, and that just took everything left. You don't have to come that way. You don't have to approach someone that way. But they did. And now this is where we're at. This is where we're at.
Yes, Mr. Neumeister, it states, quote, the metadata of all of the photographs of purported injuries that Ms. Heard has identified as her trial exhibits do not indicate that the photographs went through a photo editing application. Did I read that correct?
That's correct.
No
But
further,
we're talking
no
EXIF
further questions,
data.
Your Honor.
All right.
No further questions, Your Honor. Yeah, they're going to fix it.
Mr. Neumeister.
They opened
a
up
moment
the
ago,
door.
Mr. Murphy was asking you some questions about your opinion about the trial exhibits that Ms. Heard has offered in this matter.
Yep, sure.
And he asked you about your opinion that they don't indicate that they've gone for a photo editing application. What can you tell us about that?
Well, first of all, in this last exhibit, it says metadata, not EXIF data. So that's two different things altogether. We're talking EXIF data. And on the report, I put metadata because I was requested to cover meta and EXIF data. So it's taken out of context. The EXIF data is the data
Don't try to school this dude.
That's embedded in the photo. Metadata can be the file data about the file itself, two different things. So the way the data was collected, it was an iTunes backup is a backup.
Objection, Your Honor. Backups outside the scope of Your Honor's ruling.
You
EXIF metadata.
opened the door.
Overruled objection.
Thank you.
Yep.
Go ahead, Bryan.
An iTunes backup is only a backup of things that are on an iPhone that have not been deleted. It does not have the critical operating system. It doesn't have any of the files that would validate the path of a photograph in that phone. It does not have a lot of the log files. It does not have the Knowledge C database, which talks about usage of the phone and the patterns of how data was handled. All it is the photos you decided to save, not the photos
she's
you
excited.
deleted. So it's a very
I'd be
limited
excited if I was
database.
her.
Without the system registry or without the system operating system, there's no way to tell, because it's very easy to modify a photo on a phone and have it just read iOS 9.3.1. But with the actual phone, if you were able to get a hold of the actual phone, and in 95% of all cases we have the actual phones. It doesn't matter if the phones are 10 years old or 20 years old, or not 20 years old, but 10 years old. The reason is if people have something they want to keep as evidence, they don't throw out their phones. They don't recycle their phones. They save their phones. So people ask how we're doing phones on 13-year-old cases, because people do not throw out evidence. They keep the phone.
People do
in a
not
situation
throw
like
out evidence.
this, there are no forensic extractions. In fact, the extractions we were provided were backups of iTunes, just exports. So it's third
he opened the door
generation,
for all of
and
this.
there is no way to verify the file paths and the history of any single photo that we've looked at.
No further questions, Your Honor.
All right. Thank you, sir. You can have a seat in the courtroom. You're free to go.
Thank you very much.
All right. Your next witness.
He opened the door for that, trying to be clever. Not clever enough.
We call Beverly Leonard by video link.
I need the TV. All right. Just give us a moment to get the TV up. Your first question.
Thank you very much. Good afternoon, Ms. Leonard.
Good afternoon.
Would you please state your full name for the record?
Beverly R. Leonard.
Where are you testifying from?
I'm testifying from my home in Arizona.
Are you familiar with the defendant in this matter, Amber Heard?
Yes, I am.
And how are you familiar with her?
I met her in 2009 at SeaTac International Airport.
Oh.
Why were you at the airport?
Oh.
What happened when you met Ms. Heard in 2009?
Oh.
I was in the baggage claim area, and I observed her with a traveling companion, and they got into an altercation where Ms. Heard had grabbed her traveling companion and pulled something from her neck. At that point, I got up and went over to try to break up what appeared to be a fight. And I summoned a colleague to help me, and I stepped in between them and separated them, stopping any further injuries or escalation.
How would you describe the interaction between Ms. Heard and her traveling companion?
Ms. Heard was aggressive towards her traveling companion, and she had reached up and grabbed her arm and pulled a necklace off of her, and then I observed her having it in her hand. She seemed to be not very steady on her feet. Her eyes were blurry and watery, and I could smell alcohol.
What was Ms. Heard's traveling companion's reaction to being assaulted by Ms. Heard?
Objection, relevance?
I'll sustain the objection.
On relevance? Yes.
Yeah.
Okay.
Highly relevant.
What did Ms. Heard's traveling companion do?
She raised her hands in what appeared to be a defensive manner.
Someone from
but other than
SeaTac.
that, she was pretty stoic and didn't really respond much. Her stature was 2 or 3 inches taller than Ms. Heard, so she
I didn't know that.
She didn't really need to have to defend herself.
I didn't know that.
How would you describe Ms. Heard's demeanor when you stepped in between Ms. Heard and her traveling companion?
Wow.
She was somewhat dismissive. She just said, we're just having an argument. We're fine. Because I was asking if they were okay. Are you okay? Is there anything wrong? What's going on?
Yeah, because you don't want people popping.
Objection, hearsay. Just objection, hearsay to what she's saying.
All right. All right. I'll sustain the objection. Next question.
Yes.
What, if any, injuries did you observe on Miss Heard's traveling companion?
She had abrasion on the side of her neck where the necklace was, like a rope burn from the chain as it was removed.
Interesting.
How did you come to testify in this trial?
I became aware of this situation, specifically this trial, because I was sent an email anonymously. I don't even know who it came from, asking.
Objection, hearsay.
Right. I'll sustain the objection.
But it's why. It's not to prove the truth. The judge has been doing that the whole time.
How would you generally describe Miss Heard's behavior on the occasion you met her in 2009?
Objection, Your Honor. I already asked and answered the specifics.
I'll sustain the objection. Next question.
Ooh, boy.
Did Miss Heard's sexual orientation have any impact on how you conducted yourself?
I'll sustain the objection.
Nothing further, Your Honor.
All right. Any cross-examination?
Yes, Your Honor.
Okay. Cross-examination.
Don't open any doors.
When did you
She was trying to answer that.
contact counsel for Mr. Depp?
Late last night.
Oh,
Late
my.
last night. Okay. And this happened in 2009, correct?
Yes.
13 years ago, correct?
Yes.
And you know that this trial is being televised, right?
Really?
Yes.
And so you know that if you have something that might be significant to say, that way you can get on television, right?
People don't care about being on TV, Elaine. We have YouTube.
No, I had no desire to be on television.
People want to be on TV, they can be.
I waited for a call and wondered why I hadn't been contacted.
All right. But you you reached out and contacted them last night, correct?
Yes. Yes.
Okay. All right. Thank you. I have no further questions.
All right. Any redirect?
Nothing further, Your Honor.
All right. Thanks, Ms. Leonard. You're free to sign off. Thank you.
All right.
Interesting. Heard
All right,
said
your
that there
next
was no
witness.
physical encounter at the airport, and that's why that
Your
witness.
Honor, may
came
we
in.
approach?
Sure.
Here comes another sidebar. Actually, I don't think that's in the Nutcracker Suite. I think that's just in the ballet. So I don't actually remember what it's called. But it's a really beautiful Squirrel Tangent. It's a really beautiful, let's say, duet. Pas de deux, rather. And it's very lovely. And maybe on a live, if it's at all possible, I will try to pull that scene up because it is phenomenal. Okay, Miss Vasquez. So our last rebuttal witness is Dr. Gilbert. Oh, good. Are we almost to the end? The court. Doctor Who? Huh. Doctor Who. That's funny, right? Because Emily keeps talking about that during the trial footage. Miss Vasquez, Gilbert, he is the hand surgeon. He can only testify tomorrow morning. First thing, he has a funeral today. We disclosed that he would be testifying tomorrow. That they did, I remember. So with that, I don't know if you're going to count time against us today. Oh, right, she's trying to save the time. I think Judge A will still count it, though. I mean, the court, I would. Yeah, Miss Vasquez, okay, well, the court, that's what we have to do. Miss Vasquez, yeah, I mean, you guys have plenty of time. You're fine. Miss Myers, Your Honor, if I may just make a brief record with respect to Dr. Collins and then the court, okay? Miss Myers, back to the Dr. Collins from like the beginning of the day. Feels like hours ago at this point. The court, okay, Miss Myers, so first of all, we would request an opportunity to amend our designations to allow her to testify. Really? Okay, they really want this person in. I don't remember if they end up testifying or not. It would be really interesting because if they do, whatever it is that they've got must be really freaking important. The court, okay, Miss Myers, and then consist. The court, do you want to do a proffer? Miss Myers, we can do a proffer. Yes, the court, you can do a proffer. I'm not going to allow her to just testify, so you can do a proffer, but I don't want to count all those times, count half and half. But if you're going to do a proffer, I'm not going to count that. Miss Bredoff, thanks. Miss Myers, that's fair, Your Honor. I agree. The court, so do you want to do a proffer now? You could submit a written proffer if you want, and Miss Myers, we can do that as well. The court, I can add it to, let's go with Mr. Needlehoff's Mr. Chu to the circular file. Miss Myers, the other point we would make is that I understood Your Honor's ruling with respect to comparing Ms. Heard's testimony with the photographs, and we would also request that Dr. Collins be limited to testify about the injuries reflected in the photographs that are in evidence and have been shown. Court, all right, I understand. I'm going to sustain the objection, so you have nothing further tonight? Oh, so the proffer's just for the record, then that's why. Ms. Vasquez, nothing further tonight. Dr. Gilbert, very short rebuttal witness tomorrow. The court, just give me the final times so I can give them to them as of right now. Don't count this bench conference. So she's really trying to not charge extra time at this point, especially, of course, for Amber Heard's team, because they must have well under 2 hours at this point left, because they had 2 hours and that was earlier today, as in trial day. Actually going to have to add, is it 45? I'm sorry, Mr. Rottenborn, 52 minutes. The court, 51. We'll give you 51 minutes to the plaintiff side. You have a lot of time. You've only got one more rebuttal, right, Mr. Chu? Yeah, Ms. Vasquez, thank you, Your Honor. Mr. Chu, I think you guys are out, right? Yeah, I would imagine so, yeah. Ms. Vasquez, that's called wishful thinking, Mr. Chu. The court getting really close, yeah, I'll say. Everybody's starting to get a little giddy. Yeah, me too. I'm getting giddy. Listen to all the crazy singing. Ms. Vasquez, nervous. Mr. Rottenborn, I think both sides are ready for each other to be done. The court, I'm extremely happy. I can't tell you how much. Ms. Vasquez, not that you don't love us. Aww. The court, I can't wait. Mr. Chu, at least you're not snarky. Oh, this is so cute. Ms. Vasquez, I don't think so. I haven't yet been accused of being snarky. Accused of a lot of things. Yeah, I would not call her snarky. Sammy, for the defendant, that's 1 hour and 16 minutes. Ms. Vasquez, I'm sorry. Sammy, I'm sorry, for the defendant, it's 1 hour and 16 minutes remaining. Ms. Vasquez, 1 hour 16. Sammy, yes, the court. 16. For the plaintiff, they've used 54 hours and 7 minutes. So, Sammy, 7 hours and 8 minutes. The court, 7 hours and 8 minutes. Ms. Bruff, can we have some of yours? She's like, please, can I have some cheese? That's from, like, what is it, A Muppet Christmas Carol? Oh, God. Ms. Vasquez, I bet maybe for Mr. Umberwell, if they want to have Dr. Gilbert on the stand for 7 hours and 8 minutes, then that's fine too. The court, yeah, that's fine too, I bet. That's funny. Ms. Vasquez, I bet. The court, all right, so with that, I'll excuse the jury. Remember, I need those, Mr. Rottenborn. Yes, I was going to address that. The court, jury instructions, Mr. Rottenborn. Yeah, thank the court. You can go back and have a seat. Ms. Vasquez, okay. Mr. Chu, thank you, Your Honor. Ms. Bredhoft, thank you. Back to open court, and this has got to be the last one because, look, she's addressing the jury, and that's got to be it. Is that it? Are we done? This was a lot of sidebars today. Yep. Okay. There it is. Oh, look. Hey, there's Judy. I never scrolled all the way to this last page. There it is. There's Judy. Shout out to Judy.
Ladies and gentlemen, we're still on track to have closing arguments on Friday morning, but the plaintiff only has one more witness in rebuttal, and then since we have a counterclaim, the defense has a chance to have rebuttal for their counterclaim, and so you'll hear the remaining witnesses tomorrow on that. So since we don't have anything further today, I'm going to go ahead and release you at this point. Do not discuss the case with anybody. Don't do any outside research, and we'll see you back tomorrow morning at 9 o'clock.
It sounds like Heard will have a few rebuttal witnesses. I am very interested to see who their rebuttal witnesses will be. I don't know how much time Heard will have left for rebuttal witnesses. What, if any, time does Team Heard have left?
Right, and then for the record, charge the plaintiff the remaining time till 5:30. The plaintiff has 7 hours and 8 minutes left as of this moment, and the defendant has 1 hour and 16 minutes left, right? So we're on the same page. Okay, and jury instructions, we get clean copies today?
Yes, Your Honor. So I think we just received their comments around noon today, but we've had someone not in the court who's been looking at those and I think has narrowed down the areas of disagreement and either is sending or has sent to Sammy an email that sets forth the few remaining issues of disagreement. But actually, I think we're mostly there, but I haven't had a chance to read what they said.
Mostly. Okay, so I have everything. So I don't have everything quite yet. Then
it's not finalized.
Okay,
yet.
But I will get it sometime this evening. We have an hour now. You can stay in the courtroom and work it out. How about that?
We're happy to address those. I think we need an opportunity to see what we sent them our comments 2 days ago.
He's still huffing.
I understand, but we have some extra time right now, so nobody leaves until I get my jury instructions. How's that?
That's fair.
I like that.
I like that too, Judge A. We like the sass.
The verdict form also. And then if I could read Sammy's handwriting and tell you exactly what he's saying. Sammy, what are you saying here?
Under
Oh, yes,
advisement.
we got the 3 jury instructions that are under advisement, so we'll address those tomorrow as well, okay? And we'll work on Sammy's penmanship. All right, anything else?
So to be clear, Your Honor wants to hear the
She ordered you to stay, Rottenborn.
We could, I mean, I don't think you know what the disputes are yet.
Right.
So I'll hear the disputes tomorrow. Okay. Well, yeah, we could do those at some point tomorrow. Sounds like we're going to have some extra time tomorrow. So we'll take care of those tomorrow, but I want everything today. I want to know what those disputes are and have what you have clean.
And that's what I'm saying. I think that by 5, you will get what the disputes are.
Okay, for everything, right? Okay, so just stay here until we get all that for everything. Okay, great. Anything else then?
No,
all right, we'll see you in the morning.
Thank you, Your Honor.
The judge is like, and I'm out. I really like the way, I like the judge's demeanor. I like the way she's been working with everyone. I just really, really enjoy, I really enjoy this judge. So it's just, I really, really enjoy her.